I'd like
We have. Do you need water or anything?
Yes, I do.
Aren't there 14 without the McHenry? Except in our world, it's 14.
I have a unanimous.
I tell you what, I got an announcement, and then after that. The committee will come to order without objection. The chair is authorized to declare recess of the committee at any time. Before we get started, we were a little pressed for time at the last occasion. I would again like to welcome Congressman Luke Messer of Indiana again to our committee. And go ahead, yes, sir, deserving of a second round of applause. And assign him to his new subcommittees pursuant to the committee's organizing resolution of January 23rd, 2013. I hereby assign Mr. Messer to fill the vacancies on the subcommittee on capital markets and government-sponsored enterprises and the subcommittee on monetary policy and trade. I also assign our chairman emeritus, Mr. Bacchus, to serve as a voting member of the subcommittee on oversight and investigations. I wish to announce to all members we have, if you counted them, 14 bills to mark up today. We may not necessarily get to all the bills today, in which case I would anticipate a continuation of the markup next week. At that time, the markup may include TRIA as well. Regardless, I would anticipate marking that up clearly before the July 4th recess and perhaps as soon as next week. Regardless, at 10 a.m. in the morning, tomorrow morning rather, we anticipate having votes, rolled votes tomorrow at 10 a.m. in the committee room. And before proceeding with today's legislative business, I wish to recognize the ranking member.
Thank you very much, Mr. Chairman. I'd like to just take a moment to thank all of the members of this committee who have sent flowers and condolences to me because of the death of my mother. I would like especially to thank you, Mr. Chairman, for your thoughtfulness, your kindness, and your consideration in rescheduling. Your words of condolence and sympathy certainly have been very helpful to me, and I appreciate it very much. Thank you all.
Certainly it was the least of a courtesy that could be extended, and although there is literally an aisle that divides two camps, we are still one family in this Congress and in this committee, and as you well know, our hearts have gone out to you. I'm sure every member has kept you in their prayers, and we wish again for that your family would find some peace, and we welcome you back. We will now proceed to today's legislative business. Without objection, the chair will recognize himself and then the ranking member for 5 minutes for purposes of making an opening statement. 12.2%, that is the rate of underemployment or real unemployment in today's economy. The latest figures show that there were roughly 10 million unemployed Americans looking for work last month. 20 million, almost 20 million Americans today are underemployed. According to the Department of Labor, in May, the labor force participation rate fell to 62.8%, the lowest level in at least a generation. It hasn't been lower since March of 1978. According to the Census Bureau, 15% of Americans are living in poverty. According to the Bureau of Economic Analysis, the economy actually shrank by 1% in the first quarter of this calendar year. According to a study done by the Brookings Institution, the American economy is less entrepreneurial now than at any point in the last 3 decades. I say this to remind all members of this committee that, again, millions, in this case tens of millions of our fellow countrymen continue to suffer in a continuing non-recovery recovery. It is their interest, their sustainability, their hopes, their desires, their needs that should be paramount on our minds as we enter the markup of the legislation before us. We should continue to focus not just on the statistics, but on the voices I know that I hear from my district. I hear from David of Mesquite, who says, I've sent out over 1,500 resumes and have gotten 4 interviews with none advancing to more than the first. I hear from James in Winsboro, who says, last month my husband only worked 6 hours. We are selling things to make ends meet. I hear from Bobby in Mineola, who writes me, part-time underpaid work with cost of living so high is destroying families that I know in Texas. These are the statistics. These are the voices. Again, we have, I believe, 14 bills before us that all have a common thread. Ultimately, they are there to help the people who are underemployed and unemployed in America today. What we will do is offer bills that will add more transparency and more accountability to both the Financial Stability Oversight Council and the CFPB. And I would just remind my colleagues, particularly those on the other side of the aisle, regardless of how noble a purpose an agency may have, it does not mean it is not in need of accountability and transparency. I believe there is no agency in government that has a more noble purpose than the Veterans Administration, and clearly there is no agency of government that is probably in greater need of accountability and transparency. Small businesses are the job engine of America. We all know that. The evidence is indisputable. And small businesses need capital, and small businesses suffer under the weight of the red tape regulatory load. And again, let's err on the side of helping those who want to go to work in America. So I want to thank my colleagues who are bringing these various bills to the markup today. Again, we have heard from many that CFPB is a unique agency, and regrettably, they are part of a challenge where America's small businesses are suffering a death of 1,000 paper cuts. The bills that are presented for the CFP, almost all are practices that are routine for almost every other federal agency. In addition, we have a couple of bills coming out of Mr. Garrett's subcommittee that will make it easier for small businesses to access the capital they need to become successful and create jobs. Again, it will be a long markup, but I assume a productive markup, and I can assure you the voices of David from Mesquite and Bobby from Mineola will be heavy on my mind as we enter this markup. I hope that each member thinks about the voices of those who are underemployed and unemployed in their districts. At this time, I yield to the ranking member 5 minutes.
Thank you very much, Mr. Chairman. Today we will consider a multitude of measures related to capital markets, defense production, the Financial Stability Oversight Council, and the Consumer Financial Protection Bureau. And while I have concerns with the majority of these bills, I'm particularly concerned to see such an egregious amount of time being spent on measures weakening the CFPB. This misuse of this committee's time and resources is even more disheartening as the renewal of 2 major initiatives critical to helping small businesses, creating jobs, and spurring economic growth continue to go unaddressed. Now, I am appreciative the chairman just advised me prior to taking up the committee that we should be and perhaps will be taking up the Terrorism Risk Insurance Act next week. which ensures our largest venues, businesses, and employers have affordable access to terrorism insurance coverage. And again, I'm talking about the extension of the charter of the Export-Import Bank, which supports hundreds of thousands of jobs and levels the playing field so that American businesses, large and small, can compete successfully in global markets. Each additional day this committee ignores these items generates continued uncertainty for American businesses that actually hurts job creation, our competitiveness, and the economy. Instead of causing yet another self-inflicted wound, we should be sending a strong signal to the wide range of job creators, small businesses, manufacturers, and other segments of our economy that these important entities will be extended quickly and for the long term. So I'm very pleased that the chairman opened up today talking about job creation and giving us the stats on jobs, unemployment, and underemployment. So I want us all to make these measures a real priority. I find it particularly ironic that today we consider the Defense Production Act an important measure that empowers the President to prioritize government contracts in the case of defense, infrastructure, or natural disaster emergencies. Mr. Chairman, as you know, this measure expires on the same day as the charter of the Export-Import Bank. And while our staffs have been in conversation for months over the reauthorization of the DPA, not one step has been taken to move the renewal of XM forward. Democrats believe we must stop wasting the few legislative days we have left in this session and quickly move on legislation to renew XM and TRIA to ensure our job creators have the support they need to continue driving our economy forward. So instead of the majority continuing to push a steady drumbeat of the piecemeal measures that undercut reforms made in response to the worst crisis in a generation, the bills before us today would water down protections for American consumers and investors, undo important transparency and accountability measures for Wall Street's biggest actors, and exempt many large public companies from oversight by financial regulators like the Securities and Exchange Commission. Two measures we may consider today are designed to chip away at the important role of the Financial Stability Oversight Council, one of the centerpieces of Wall Street reform. In case my colleagues on the other side of the aisle have forgotten, FSOC was created for the express purpose of looking at every aspect of our financial system for possible weaknesses and risk, something that did not happen in the lead-up to the crisis. These bills are merely roadblocks to that goal and only serve to disrupt the delicate balance between ensuring the stability of the system and protection of sensitive market information that could weaken the economy if disclosed. 9 measures making changes to the CFPB will also be considered, and I'm not opposed to making improvements, but let's make one thing clear. Many of the Republican members of this committee did not support the Bureau's creation and are part of a continued effort to bog it down with additional paperwork, increase its bureaucratic responsibilities, and eliminate important tools at their disposal. While I do support reasonable efforts to improve the Bureau, I find it hard to negotiate in good faith with those who are only interested in destroying it. Finally, we will be offering a number of amendments to these measures today. Where possible, we will attempt to underscore the importance of diversity and inclusion of women and minorities. I expect my friends on the opposite side of the aisle to look favorably on these amendments, as I hope their actions and commitment to diversity today match the rhetoric we have all heard in the ongoing investigations regarding the CFPB. Mr. Chairman, I thank you, and I yield back the balance of my time.
Pursuant to notice, I now call up H.R. 4697 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4697 to require the Securities and Exchange Commission to revise the definition of a well-known...
Without objection, the bill is considered read and open to amendment at any point. The Chair recognizes the distinguished House Majority Whip from California, Mr. McCarthy, the sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chairman. The goal of my bill, H.R. 4697, the Small Cap Access to Capital Acts, is to provide the opportunity for small companies to enjoy the same advantages that many larger companies do by qualifying for well-known seasoned insurance status, also known as WICSI. Companies that have WICSI status benefit from a more flexible registration process that allows them to quickly take advantage of favorable market conditions and access the capital needed to strengthen their operations, grow, and create economic value and jobs. By expanding WICSI eligibility to these companies with more than $250 million in market cap, which this bill will do, we are including many small and medium-sized businesses that are at the forefront of innovation and in the best positions to grow the economy and create jobs. Now, this provision has been a recommendation included in the SEC's last 2 forums on small business capital formation and will allow these companies to file an automatic shelf registration statement that includes vital information about the company and potential security offerings. And so long as no informational material changes, the company can then automatically take the registration off the shelf and proceed to the next stage of offering the securities to the market. As the biotech industry testified at the April 9th hearing on capital formation, having WICSI status reduces cost and provides flexibility in the timing of a second offering to fund the research and grow their businesses. Now, Brian Hahn, Chief Financial Officer for Glycomimetics, offered this support of H.R. 4697. He noted, the primary benefit of being a WICSI is that any Form S3 filed by a WICSI is automatically effective and not subject to SEC review. The streamlined process grants flexibility to WICSIs, eliminates delays, and allows them to conduct offerings off the shelf with greater efficiency. Because WICSIs are only required to pay the SEC a filing fee when the shelf offering actually commences, rather than at the time of filing the S3, as it is the cause of non-WICSIs, they save capital and only incur a cost burden when they decide to go forward with an offering. With respect to lowering the threshold from $700 million to $250 million, Mr. Hahn testified, for a growing biotech company, this would give important flexibility in the timing of a secondary offering, allowing the company to prepare and register the offering in advance and make the offering at the moment market conditions are best, allowing more insurers to qualify as WICSIs and therefore conduct effective shelf offerings will expand the capital formation and the potential of Form S3 and provide a valuable avenue to innovation funding of the public market. Also, this bill will not weaken investors' protections or transparencies. WICSIs will still be required to file all other registrations, disclosures, and report that the SEC requires. Companies still have the liability relating to the information contained in the prospectus and filing. Now, lastly, to address the concern that arose at the hearing, the Small Cap Access to Capital Act would prohibit companies that are currently emerging growth companies under the Jobs Act from qualifying for WICSI status. This will keep the separation that was intended when defining an emerging growth company. There has been little problem with the current threshold to date. Therefore, there is no reason to believe that a $250 million company that meets all other reporting registration requirements of the SEC should be required to jump through more hoops than a larger company to raise capital in a market where access and timing is of the essence. Thank you, Mr. Chairman. I look forward to the consideration of the bill, and I yield back the balance of my time.
Gentleman yield back who seeks recognition. For what purpose does the ranking member seek recognition?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Mr. Chairman and members, I believe this legislation is wrong-headed. The bill would require the Commission to revise the definition of well-known seasoned issuer, or WICSI, to include issuers that are neither well-known nor seasoned. Well-known seasoned issuers are meant to be the companies most widely followed by analysts, representing the most significant amount of capital raised and traded in the United States. Because they're so widely known, covered, and understood, these companies are afforded certain benefits, the most significant of which is automatic shelf registration, which permits the sale of securities without any prior review of the registration filing by the SEC currently. In order to receive this benefit, a WICSE must have a worldwide public float of at least $700 million, among other factors. This is a relatively robust standard, with about a third of companies trading on the New York Stock Exchange meeting the criteria. This bill would drop the 700 million threshold to nearly one-third of where it is currently, down to 250 million. By dropping the WICSE standard so low, we would be inviting nearly all companies traded on the New York Stock Exchange and NASDAQ to become WICSEs. This is problematic, as companies with this low level of public float may only be covered by one analyst and may not trade efficiently in the market. As Professor John Coffey noted at the April hearing that considered this bill, this proposal may be the most radically deregulatory of all the bills we considered that day. Eliminating the opportunity for SEC review of the registration filings of these companies would undermine one of the bedrock principles of our securities laws and would, as Professor Coffey notes, invite misbehavior if an issuer knows it will not be subject to prior review and encourage costly litigation if errors are later discovered. The bill would also make it much more difficult for an issuer's investment bankers and other agents offering due diligence review of its registration statements to do their jobs. Since there would be no pre-offering period between filing the registration statement and it becoming effective. Moreover, because WICSEs can register securities for sale without separately identifying the selling security holders or the securities to be sold by such persons until the time of the actual sale by such persons, expanding the definition will promote secondary sales by large shareholders which do nothing to raise additional capital and create jobs. In fact, this could amount to a bailout by insiders who know more about the company than the public does. The claim that this bill would do anything to facilitate capital formation is dubious. I would urge my colleagues to seriously oppose it. I yield back the balance of my time.
Gentlelady yields back. Who seeks recognition?
Mr. Chairman,
For what purpose does the gentleman from Tennessee seek recognition?
move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, unemployed Americans are crying out for more jobs, urging Congress to review rules and regulations that stifle innovation, economic growth, and job creation. All of us here today are here for one reason: to give the private sector the tools they need to create jobs. We don't create jobs in the halls of Congress, they do out in the private sector. According to the Bureau of Labor and Statistics, the unemployment rate is still at 6.3%. The best thing our government can do right now to get our economy moving in the right direction is to help create an environment where new ideas and startup companies have a chance to grow and succeed. This is why I support the gentleman from California's bill, H.R. 4697, the Small Cap Access to Capital Act, because his bill will help create additional capital which will help companies expand and increase the number of jobs in this country. As the gentleman from California has noted, H.R. 4697 would expand the number of companies eligible for well-known seasoned issuer or WICSE status by changing the market cap threshold from $700 million to $250 million. By broadening the class of WICSE eligible companies, the filing burden on these businesses will be less onerous, meaning less capital will go to redundant compliance costs and more can go to expanding their businesses. WICSEs benefit to the greatest degree from the communications and registration flexibilities that were provided to them in the securities offering reform done by the SEC in 2005. Most notably, WICSEs can register their securities offerings on shelf registration statements that become effective automatically upon filing. As a result, the SEC does not have to review or comment on these registration statements before sales are made. And this is not a new idea. H.R. 4697 is taken from both the 2011 and 2012 recommendations of the SEC's Government Business Forum on Small Business Capital Formation. In today's business environment, companies need to have the ability to act quickly to take advantage of opportunities when market conditions are favorable. Big companies shouldn't be the only ones that get to have the flexibility and quick access to the market to raise capital in hopes of expanding their businesses and creating jobs. Smaller companies, which much of the innovation, growth, and job creation take place, should also be able to have some of these same advantages. The Small Cap Access to Capital Act will help smaller companies compete for capital and will allow them to innovate, grow, and create jobs. And with that, Mr. Chairman, I support this piece of legislation and yield back the balance of my time.
Who seeks recognition? For what purpose does the gentleman from Massachusetts seek recognition?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, sir. I just want to clarify one thing. The SEC forum that passed forward the recommendation was a forum of businesses. It wasn't the SEC that made these recommendations. The recommendations were made by businesses that came in, and quite frankly, any business with any idea could put a recommendation forward, so it doesn't have the weight of the SEC. What we're doing here, though, is really is turning this upside down. What we try to do for investors and for smaller companies to preserve the integrity of the market, we said that we're going to create a classification called a well-known seasoned issuer. And what we said was this is going to be a stamp of approval. In other words, we're saying that a company with $700 million in market capitalization is widely covered. It's the analysis done on that company is very robust. It's big enough that a number of analysts that will dig down will know a lot about that company. That's good for the employees and the jobs that you're trying to create, and also protects the investors. What this is doing is turning this upside down so that every company now, under this bill, will basically have the stamp. The stamp will mean nothing. We're only, instead of $700 million in cap, you're saying $250 million in cap. It is very unlikely that many more than one analyst will ever look at that stock at any one time. So what we're just completely deleting the benefit that we created last time for all the people that you've just mentioned. We created that seal of approval for having the well-known seasoned issuer stamp on them. Now, if this bill passes, that means zero. That means zero. It means we don't know anything about a well-known seasoned issuer. So it actually has the opposite effect of what you're talking about, what you say you desire. It removes the integrity of the classification that we've created that people can rely on. Because after we put this in place, you can rely on nothing. Nothing. There won't be an analyst that will be behind these companies. They're so small. So I oppose this. I think we did a good job last time by trying to create the ability or enhance the ability of small companies to raise capital. I think we did a good job. It was widely supported on both sides of the aisle. I think it was a responsible step that we took. And this is recklessness. This makes the stamp of approval worth nothing, just so you understand what we're doing here. And with that, I yield back the balance of my time.
Gentleman yells back. Who seeks recognition? The chair will yield 5 minutes to himself. Just to say, listening very carefully to the debate here, I certainly don't want to have to go to my constituents, those whose voices have been heard in this hearing room already, and say, you know what, when you couldn't find a job or you only had part-time work, I want you to rest assured that I beat up on Wall Street banks. You know what, that's not going to help my constituents pay their bills. And we have this anomaly in our economy that, not unlike the literary illusion, water everywhere, not a drop to drink, we have capital everywhere, but not a dollar to access for so many startups, for so many entrepreneurial ventures, so many small business enterprises, the job engine of America. And so as I look at the legislation from the distinguished majority whip, number one, I don't see something that is bailing out Wall Street banks. We must be reading different pieces of legislation here. I would remind my friends on the other side of the aisle, this is also about eligibility. It doesn't necessarily guarantee WICSI status. It's about eligibility. I would also say it doesn't mean that a company somehow disappears into the ether, never to be heard from again. For every securities offering, they will still have to file the necessary registration and disclosure statements with the SEC, but it is about streamlining a process to preserve capital at a time, again, when tens of millions of our fellow countrymen can't find work. You cannot help the job seeker by continuing to punish the job creator who is in desperate need of capital in order to expand and start new businesses. So I want to thank the distinguished majority whip for this legislation. I want to encourage all members to support it. It is one more bill that is an important part of this committee's legacy in the 113th Congress, and that is to be a part of jobs legislation so that the men and women who are struggling in this economy have opportunities for them and their families. I yield back. Who seeks recognition? For what purpose does the gentlelady from New York seek recognition? I think the mic.
Ask permission to move to strike the last word.
Gentlelady is recognized for 5 minutes.
I thank you, Mr. Chairman. Mr. Chairman, I appreciate all the legislation is above us because certainly from the opening statements we do have a lot of work to do. But with that being said, I would like to hand over my time to Mr. Lynch of Massachusetts.
I thank the gentlelady. Apparently, the flash flood warning. So I might want to hike up there.
Apparently, the gentleman from Massachusetts is about to flood us with his verbiage.
Yeah, sorry about that. Mr. Chairman, if I could, one of the most egregious parts of this, and I appreciate the gentleman's remarks, but what we have tried to do with the Jobs Act and recently with the Small Cap Liquidity Reform Act is enhance the ability of these companies, smaller companies, to raise capital, and that's a good thing, and it does create jobs, as the gentleman professes his desire to be. But what this would do would also allow the stamp of approval, in addition to companies that are not, it is not well, they are not well seasoned, they are not well known, they are very small, small capped companies, but also remarkably enough, the stamp of approval would also apply to any company that is guilty of violation of the financial of our laws. So a company that broke the law and scammed investors would be eligible for this stamp of approval that we're going to give them in this act. That is inexcusable. That is inexcusable. You're taking this stamp of approval that we've established already. It was a good move. I agree. It was a Republican idea. We supported it to establish this, and it was a recommendation of the SEC that it be $700 million in capitalization, because they said this is the level at which we know that we will have enough money, we will have enough information about these companies at this level. We know that several analysts at a minimum will cover it, so that investors will have all this information. Now you're dropping it to 250. We won't have the information, but on top of that, this legislation would require would allow any company that violates the financial services law that has been convicted of scamming investors, they would get the stamp of approval too. So I don't know how you can defend that. I really don't. And I can't speak strongly enough against it. It's just it's a bad idea. Once in a while, you come up with a bad idea. That's all I'm saying. This is one of them. And so I think we ought to vote against it. That's my opinion, to protect the consumer. Thank you. I'll yield back.
The gentleman yields back to the gentlelady. Does the gentlelady yield back? Gentlelady from New York.
I yield back.
Gentlelady from New York yields back. Who seeks recognition? For what purpose does the ranking member seek recognition?
Mr. Chairman, I have an amendment at the desk.
We'll pause for a moment and allow the amendment to be distributed. Is there any member who has yet to receive a copy of the amendment? The clerk will report the amendment.
Amendment offered by Ms. Waters, page 2, line 11, insert period, before the period the following.
Without objection, the amendment is considered read. The gentlelady is recognized for 5 minutes to explain her amendment.
Thank you very much, Mr. Chairman and members. I agree with the gentleman from Massachusetts that this legislation would not only provide for those who don't have the experience, don't have the analysis done by reducing the amount from $700 million to $250 million, thus creating risk for our investors. And so I'm going to offer this amendment to make a wrong-headed bill incrementally better. Especially, let's see, specifically, my amendment would prohibit the Securities and Exchange Commission from granting waivers to a company that becomes ineligible to claim well-known seasoned issuer status because it or its subsidiary has been convicted of a felony, a misdemeanor, or is determined to have violated the anti-fraud provisions of the federal securities law in any judicial or administrative decree or order within the last 3 years. To put it simply, this amendment would prevent the SEC from granting WIC-C waivers to institutions involved in criminal cases brought by the Department of Justice. It would also apply to settlements and cease and desist orders over fraudulent conduct negotiated with regulators or the DOJ. I'm offering this amendment because the American public has grown increasingly frustrated with the lack of accountability in our financial system, both with regard to conduct contributing to the financial crisis and to scandals that have occurred since then. Since 2008, we have seen instances of LIBOR manipulation, robo-signing of foreclosure documents, and failures in money laundering controls that facilitated the flow of profits to narcotic traffickers and countries sanctioned by the U.S. government. While law enforcement has tallied up record monetary settlements in response to this conduct, I remain concerned that our regulators are not using the full set of tools available to them to deter future bad behavior. In particular, the SEC has liberally waived automatic disqualification provisions in our securities laws, enshrining a new policy that might make some firms, in the words of one SEC commissioner, simply too big to bar. Since the beginning of 2006, the Commission has issued 73 WIC-C waivers to firms that would otherwise be barred from such status. Since 2010, the Commission has granted at least 30 WIC-C waivers, 29 of which went to large financial institutions and broker-dealers. In many cases, these issuers are receiving their second, third, and even fourth WIC-C waiver in less than 4 years. Most concerning, these waivers are increasingly being offered even in the face of very serious misconduct. In 2012, the SEC offered its first waiver in the 10-year history of the WIC-C status for criminal conduct related to 6 years of LIBOR manipulation at one firm. In April of this year, the SEC again voted to grant such a waiver to another firm guilty of LIBOR manipulation. The SEC should not reflectively throw away its enforcement tools, particularly in cases involving criminal or fraudulent conduct of large financial institutions. Doing so undermines firms' incentives to obey the law. To be clear, the type of conduct my amendment would cover includes very serious offenses such as making a false report, bribery, perjury, larceny, theft, robbery, extortion, forgery, counterfeiting, fraudulent concealment, embezzlement, misappropriation of funds, and making false statements to the government. The WIC-C status is a special benefit that allows companies to bring securities to market without first receiving the scrutiny of SEC staff. This status should be reserved to issuers that have shown a commitment to maintaining market integrity via compliance with the law. My colleagues on the other side of the aisle have claimed to share my concerns about market integrity with their recent inquiry into the settlement policies of the Department of Justice. If they are serious about doing so, they will support this amendment, which I believe will make our regulators more accountable to Congress and to the public. Mr. Chairman and members, I just don't see how the members on the opposite side of the aisle could resist this amendment. I just don't think that you would want to create this kind of risk and be responsible for it and take responsibility for it. I thank you, and I yield back the balance of my time. I would hope you would support this amendment.
Gentlelady yields back. Who seeks recognition? What purpose does the distinguished majority whip seek?
Strike the last word.
Gentleman's recognized for 5 minutes.
I want to thank the ranking member for her amendment, but I also want to remind him if they read the bill, it does nothing to deal with the current rules of disqualification or others. Now, while I'll agree that WIC-C disqualification would be an appropriate remedy in most cases of bad actors, if they could commit criminal, civil, fraud violations, but I also think the consideration of due process matters in the best interest. And when I look to the current SEC, their discretion to grant the waivers of individual circumstances, when I look at what one commissioner recently put out, if the misconduct that triggered the disqualification does not affect the issuer's current and future disclosure, or if it did affect the issuer's disclosure, but because of the issue's ramification, such disclosure would be reliable going forward, then granting the WIC-C waiver is appropriate. I think the current SEC's ability to look, have a due process going forward, this bill does not deal with any of that. It lowers it from 700 to 250. It allows, as the ranking member knows, especially with the biotech industry in California, how it has been such an integral part of job creation, you don't get revenue at the beginning. But to be able to go out to that issue of maybe the second tranche, hitting the right time is important. You still have to file. If you change anything, you cannot go off the shelf. It gives the appropriate that a small business can be treated the same as a large business. Why do we give special treatment to large businesses? And it will not when it comes to any qualifications there, and it still has the SEC to refer. But I also believe this country has a fundamental policy and principle in due process. And if someone has broke the rule, then appropriate, they should be denied. But I think the due process of the SEC also has a principle to go forward. That's why, unfortunately, I cannot be supportive of your amendment today, and I yield back.
What purpose did the gentlelady from New York seek recognition?
Thank you, Mr. Chairman.
The gentlelady moves to strike the last word. Gentlelady's recognized for 5 minutes.
Thank you so much. And I want to speak strongly in support of the ranking member's amendment, because I believe that the amendment makes it very clear that WIC-C's and the WIC-C status is a privilege. It's not a right. It's a privilege. And it's a privilege that is granted to outstanding companies that have strong track records of service and honesty and accountability to investors and the public. These are outstanding companies like Boeing, our #1 exporter, General Electric, large companies that are followed by many researchers, investors, analysts, and their work is literally reported in financial papers, and people are well aware of their records. And because of it, it signals to investors that they can place a higher degree of trust in a company's disclosures than in other companies' disclosures, because so many people are looking at it. But if a company no longer has a strong track record, if a company has a record of being convicted of fraud, of dishonesty, of corruption, then I don't believe it should be eligible for a special discretionary benefit that we are giving them, plain and simple. And I would argue that a company that's been convicted of a crime, of criminal actions, is no longer a company with a strong public track record. So this amendment would not prevent a company that has been convicted of a crime from ever being a WICSI in the future, but that company would have to prove that they have cleaned up their books, that they aren't violating the law, that they're not being corrupt, and they earn that level of trust again. But to have companies that have been convicted of major crimes continue to have this privilege, I feel sends an absolutely wrong message and is absolutely wrong. And this is about protecting investors. This is what it's basically about. And certainly companies that are convicted of crimes, they have to prove to their investors that that they're abiding by the laws of our country again. So I support the ranking member's amendment, and I urge my colleagues to do the same. I think it's just absolute common sense. And I would like to yield back the balance of my time.
Gentlelady yields back. Who seeks recognition? The chair will recognize himself for 5 minutes. I would say that certainly the ranking member's amendment is germane, but as pointed out by the distinguished majority whip, it does functionally deal with a different issue. I listened carefully to what the ranking member has to say. Certainly, it is not without merit, her arguments. But I would say this: we had a hearing on this bill on April 9th. I recall no discussion or debate on the WICSI waiver issue at that time. The SEC chair, Mary Jo White, testified before us on April 29th. I recall no discussion of this issue being raised in that hearing. 3 weeks ago, 3 weeks ago, this markup was formally noticed, and I thank the ranking member. We did receive her amendment last evening, but it's not really in time for members to consider what is a matter of first impression for many. So I am not prepared to back the ranking member's amendment at this time. If she is interested, I would be willing to work with her. We are going to have other SEC hearings in the weeks and months to come. Be happy to address the issue at this time. But I think there are potential unintended consequences that I think this committee needs to work its deliberations and due diligence upon. The potential impact on investors is certainly at least one of them. So it could be that it is a very meritorious matter, but given that the amendment was filed last night, it has previously not been considered and debated in this committee. I think it's a very serious matter that is deserving of consideration. So if the ranking member would like to have her vote, very happy to have that vote now. I will recommend a no vote. If she is interested in withdrawing and working with the chairman in good faith in the matter, I'd be willing to do that. It's certainly the ranking member's privilege to do what she will. But I do believe this amendment deserves further consideration then simply this markup
Mr.
will.
Chairman.
Well, it's still my time. Are you speaking?
Yeah, I just didn't want you to go ahead and gavel this thing or rule it, you know. I didn't want, you're negotiating an opportunity for the ranking member to withdraw it. I just want to speak on the amendment in case she might withdraw it.
Well, okay, I think you've certainly communicated that to the rank. Anyway, I understand the gentleman's interest. Any other? Anyway, the chair yields back the balance of his time. Who seeks recognition? Would the gentleman from Massachusetts like his own time now?
Yes, please.
For what purpose, the gentleman?
Move to strike the last word.
Gentleman is now recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate that. Mr. Chairman, I just want to point out that the record of the SEC on prosecutions has been far less than robust. You know, we went through the whole financial crisis, and I'm hard-pressed to remember any one firm or bank that's been prosecuted for that whole debacle. But that being the case, I think Ms. Waters, our ranking member, has really exceeding narrowly carved this exception. What she's trying to do is to get at these firms that have been found guilty of fraud, that have been found guilty of violating the financial securities laws, the federal security laws. And so she's saying that this exemption that you're providing for people should not be given to folks that have been violating the law. And while the gentleman from California asked the question, he said, why should we treat smaller companies differently than larger companies? Number one, we know a lot more about the larger companies. So they've got a track record. They're a well-seasoned issuer. We know a lot about them, and so we give them the benefit that they are due because of good behavior. And so the real question that we should be asking on this amendment is, why should a company who broke the law and has been found guilty of fraud be treated the same way as a company that has not committed fraud, that has not been convicted, that has not violated the securities law? I mean, that's a pretty straightforward answer. We should not treat those two companies the same. So we're trying to protect the consumer. We're trying to do the right thing by businesses that operate within the law. And I think it's certainly the right thing to do. There should be some negative consequences to committing fraud. And what you're saying in this legislation is, no, we're going to treat everybody the same, whether you broke the law or complied with the law.
Would the gentleman yield, since
briefly,
the chair
sure.
yielded to the gentleman from Massachusetts? I think the gentleman said there ought to be some consequences. I'm under the impression that this in no way, shape, or form impacts the enforcement actions of which the SEC can take. WICSI status, I'm under the impression, has nothing to do with that. And so fraudsters can certainly still be fined and go to prison.
All right, reclaiming my time. This is the way the statute works, okay?
Okay.
The prior law says you have to have $700 million in capitalization, okay? And you must not be an ineligible issuer. One of the ways that you become an ineligible issuer is by violating the securities laws, violating the fraud prohibitions. Okay, so that is not carried forward in this new bill, in your amendment. It drops to 250, and the requirement that the person be an eligible or not be an ineligible issuer, that goes away as well. So that's what you're doing. Maybe it's not intentional. Maybe we can come up with an amendment on this. But right now, as written, this amendment by the gentleman from California would allow an ineligible issuer to have the benefits of what he's trying to do, to have the smaller $250 million cap requirement. That's the plain language of the bill. This is not open to other interpretations. Straightforward. So that's what we're doing here, just to make my point.
Who seeks, for what purpose does the gentleman from Tennessee seek recognition?
I move to strike last word.
The gentleman is recognized for 5 minutes.
I yield to the gentleman from California, Mr. McCarthy.
The gentleman brought up an issue, and let me be very clear, and even in the opening statement we said it. The only thing this bill does is lower it from $700 million to $250. It keeps everything the same. So if the gentleman wants to argue that people cannot have the fraud on it, you don't want it at the $700, you don't want it to $250. This keeps all the SEC provisions in there. It does nothing other than $750 to $250. Very clear, straightforward.
Will the gentleman yield?
I would gladly yield.
Time belongs to the gentleman from Tennessee.
Oh, I will yield.
Okay.
Briefly.
The language prior to your amendment includes a prohibition on ineligible issuers. The language of the statute after you're done is silent on it. Okay? What the gentlelady's amendment does, it expressly says the SEC will not drop the exemption, will not drop the amount for an ineligible issuer. That's what her language does. It's very tight. She's not doing an expansive change here. She's making sure that the bad folks, the people who are guilty of fraud, violating the securities law, do not get the benefit of what you're trying to give to the other companies. That's what she's trying to do.
If the gentleman from Tennessee would yield.
Yeah.
No, I want to be very clear. The language only says from $700 million to $250. That's the only change of this legislation. That's the same thing, the recommendation that comes from.
Well, if that's your worry, then you should be able to accept the gentlelady's.
It's in the text, sir. And reclaiming the time he lent to me, if you have a concern, I'll gladly work with you, but this does nothing different. I can't put something in that's not in it. I'm only dealing with 700 to 250, nothing else. That's the text of the bill. I can't read something into it that's not, but I would gladly work with you if you believe there's something that's not there.
Well, yeah, there is.
I yield back, Mr. Chairman. Balance my time.
Gentleman yields back, who seeks recognition. Gentleman from Connecticut, for what purpose? Gentleman seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. We've gotten bogged down in the weeds of this particular bill and amendment. I support the ranking member's amendment and have very real concerns about the underlying bill. But I want to take a big step back here, which is to ask the question, why exactly are we doing this? The chairman made an argument, a vivid argument, water, water everywhere, capital, capital everywhere, but no capital available. That is apparently why we're here and why this flood of bills is before us. Unfortunately, the facts don't begin to support that premise. I'll throw a few facts out there. IPO volume in the year 2013 was $50 billion. That's double what it was in 2008, 2008 being a pretty tough year. In the first quarter of 2014, quarter-on-quarter IPO volume is up 109%. I don't know what's going to happen in the next couple of quarters, but we may double the $50 billion in IPO volume that we saw last year. The other source of financing for small companies, venture capital. Last year we saw $30 billion in venture capital investments. This year we are on a $40 billion pace. Let's put that into context. 20 years ago, the venture capital market was $4 billion. This year it'll probably be $40 billion. 10x over 20 years. Now these numbers aren't records. We had bubbles in 1999, the tech bubble. We had bubbles in 2006, 2007. So these aren't records. I'm not sure anybody necessarily wants to get back to the record bubble volumes. But the idea that there is not capital available for worthy businesses is simply not true. And I think it's that context in which we need to consider these bills, which would, I guess, maybe, although it's an unproven point, make it easier for people to raise capital. I guess it would reduce the paperwork. But guess what? Not every business out there, in fact, most businesses probably shouldn't be funded because there's a lot of bad ideas out there. And bad ideas that sail through and hurt investors does nothing for our capital markets in the long run. So, Mr. Chairman, I just wanted to put those figures out. These two markets, IPO and venture capital volume, are up very, very substantially, partly because of the recovery in the economy, I think partly because of the Jobs Act. But this premise that somehow capital is constrained to good businesses which are creating jobs is very simply not supported by the facts. And I yield back the balance of my time.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Ohio seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. I yield my time to the gentleman from Tennessee, Mr. Fincher.
Thank you, Mr. Stivers. Just referencing the comments made from across the aisle about IPOs, the Jobs Act creating a category of issuers, emerging growth companies, dropping the threshold, making it easier for smaller companies to go public and gain access to capital is one big reason why IPOs have gone up so much. And to just reiterate my support for Mr. McCarthy's legislation and opposing the ranking member's amendment, all we're doing here is dropping the threshold from $700 million to $250 million, making it easier for small companies to gain access to capital. There's something wrong in America when we're going after small business and making it harder for small business to grow. This is a very slippery slope. All we're doing is making it easier to gain access to capital for people, $250 million instead of $700 million. I yield back, balance my time to Mr. Stivers.
I yield back the balance of my time, Mr. Chairman.
Gentleman yields back.
Mr. Chairman.
For what purpose does the gentleman from Texas seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I yield to the ranking member.
Thank you very much, Mr. Green, for yielding to me. Mr. Chairman and members, these issues are very clear. It's nothing complicated about this bill. It's nothing complicated about my amendment. It is very simple. What this bill is doing is creating risk for investors by lowering the amount of capitalization to an amount to those who will not have the kind of analyst oversight, to those who have not demonstrated their ability, to those who we don't know much about, and the SEC will not know much about. And this underlying McCarthy bill would preserve the SEC's waiver authority, which they've used permissively like a rubber stamp. My amendment cracks down on these waivers. That's very simple. The chairman talked about not having had this issue discussed when we had hearings. The first time this issue ever made it into the public domain was April 28th, when an SEC commissioner finally pushed for a commission vote on a waiver after years of staff doing it via delegated authority. The other issue that has been brought up about whether or not there's due process. The firms get due process with the DOJ, and with regulators once they admit guilt or plead guilty or are convicted. We want to stop the SEC's permissive waiver policy. The SEC has become simply a rubber stamp on WICSEs even after convictions. Now, Mr. Chairman, I respect the fact that you have offered to work with us on this amendment, but there's really nothing to work on. There's nothing that I can see with this amendment that I would be willing to modify, that I would be willing to eliminate. This is what oversight is all about on this committee. And I am saying, and others are saying on this committee, that if you are convicted of wrongdoing in all the ways that I have identified in my testimony here today, that you should not be eligible for a waiver. That just does not make good sense. That is not good public policy. And so I would ask us to move forward with the vote. Vote it up or down. Either you are for protecting the investors and you're protecting the ability to know and understand who these people are, or you're not. So I would just ask for, and I vote on my amendment because there's nothing really to negotiate here.
I yield back.
Gentleman from Texas yields back, who seeks recognition. The question is, on agreeing to the amendment, all those in favor say aye. Aye. All opposed say nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it. A recorded vote has been requested. Those in favor of a recorded vote will raise their hands and be counted. Sufficient number having raised their hands, a recorded vote is ordered. Pursuant to subsection C5 of Rule 3 of the committee rules, the vote on this question is postponed. Are there any other amendments? There being no further amendments, without objection, the previous question is ordered. Pursuant to notice, I now call up H.R. 2629 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 2629 to provide an exemption for low-revenue companies from certain SEC regulations. Section 1, short title.
Without objection, the bill is considered read and open to amendment at any point. The Chair recognizes the gentleman from Pennsylvania, Mr. Fitzpatrick, the sponsor of the legislation, for 5 minutes.
Thank the Chairman. Mr. Chairman, the Fostering Innovation Act is simply recognition that one-size-fits-all regulation is not helpful to our economy. This committee and both chambers of Congress recognized this fact when it passed the Jobs Act in 2012, which included regulatory relief for emerging growth companies, including relief from Section 404B of Sarbanes-Oxley. However, there are still small and emerging companies that were not included, and so that's why this bill is necessary. This legislation would do two very important things. It would raise the threshold for a company's compliance with Section 404B from a public float of $75 million to $250 million, and it would include a very important revenue requirement of at least $100 million for companies with less than a $700 million public float. As I mentioned, the Jobs Act acknowledged the need to provide 404B relief to small companies, but as far back as 2005, the Internal Controls Subcommittee of the SEC's Advisory Committee on Smaller Public Companies recommended that small companies should be relieved of 404B compliance. In testimony before the Capital Markets Subcommittee, Brian Hahn, the CFO of a pharmaceutical company called Glycomimetics, pointed out that his company only cuts 110 checks a month, and there are only 2 people that sign those checks, yet they have to come up with controls of where they store their checkbook in a way that can be verified by an external audit. These procedures have a cost, and this is money that, as Mr. Hahn testified, is not being spent on core missions like research and development, which creates good-paying jobs. I've heard these same stories for almost 2 years from companies and constituents in my district, like Synergy, located in Doylestown, Bucks County, and from Jeff Hatfield, the CEO of Vitae Pharmaceuticals. These are employers that are on the vanguard of American innovation. They support the types of STEM jobs that we all believe are important, and they're providing good wages for their employees. Even if biopharmaceutical companies like Synergy, Vitae, and Glycomimetics were able to avail themselves of the emerging growth status that was created by the Jobs Act, this relief is going to go away after 5 years, and they may not be making a dime for an additional 5 to 10 years after that. It can take a dozen years or more for some of these companies to have a product ready for market, and again, every penny that they have to spend complying with laws and regulations that offer very little benefit to investors means they are not applying those precious capital resources to more essential functions that I would suggest probably mean a whole lot more to investors than where their checkbook is locked up at every night. So with that, I encourage my colleagues to support the bill, and I yield back.
Gentleman yields back. For what purpose does the ranking member seek recognition?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Mr. Chairman, I must oppose H.R. 2629, which would drastically limit the number of companies that are subject to independent audits of their financial reporting. Specifically, this bill would raise from $75 million to $250 million the market value at which companies would be subject to an independent audit of internal controls over financial reporting. It also adds a new provision exempting companies with between $250 million and $700 million in market float, provided the company had less than $100 million in annual revenues. Congress passed Sarbanes-Oxley in 2002 in the wake of corporate and accounting scandals at Enron, WorldCom, Tyco, Adelphia, and elsewhere. Such accounting fraud cost investors billions of dollars when the share prices of affected companies collapsed and shook public confidence in the nation's securities markets. Under Dodd-Frank, the Congress exempted from 404B non-accelerated filers or companies with less than $75 million in market capitalization. Mr. Chairman and members, that amounts to 60% of companies who file reports with the Commission. This bill, H.R. 2629, would raise that threshold to cover about 75% of companies. Dodd-Frank also required the SEC to study how to reduce 404B compliance burden for companies with a market capitalization between $75 million and $250 million. The SEC staff had the following findings in their study, which was released in April 2011. The cost of Section 404B have declined since the Commission first implemented these requirements, particularly in response to 2007 reforms. Investors generally view the auditor's attestation on internal control over financial reporting as beneficial, and financial reporting is more reliable when the auditor is involved with internal control of financial reporting assessments. As a result, the SEC staff did not recommend extending the exemption under Dodd-Frank. Beyond the SEC study, this issue has also been examined by the GAO. Section 9891 of Wall Street Reform required the GAO to report the differences between companies exempt and not exempt from Section 404B audits. Their July 2013 report found that since the implementation of the auditor attestation requirement, companies exempt from the requirement have had more financial restatements than non-exempt companies, and the percentage of exempt companies restating generally has exceeded that of non-exempt companies. The majority of these restatements produced a negative effect on the company's financial statements. GAOs and other analyses show that these costs have declined for companies of all sizes since 2004. Companies and others reported benefits of compliance, such as improved internal controls and reliability of financial reports. A majority of empirical studies GAO reviewed suggests that compliance with the auditor attestation requirement was a positive impact on investor confidence in the quality of financial reports. The GAO also found that firms that voluntarily comply with the auditor attestation enjoyed a lower cost of capital than firms that are exempt. Specifically, both the cost of equity and the cost of debt are significantly lower for companies that voluntarily comply with the requirement compared to those exempt companies that do not. Simply put, Mr. Chairman, independent audits are good for investors, good for market confidence, and good for public companies. The Fitzpatrick bill goes far beyond the Dodd-Frank exemption, which already provides relief to small companies by removing audit requirements at affected companies that have been in place since 2004. Now is not the time to roll back investor protections. Attempts to roll back SOX 404B have long been opposed by the Council of Institutional Investors, CalPERS, the Center for Audit Equality, the CFA Institute, and American Institute of Certified Public Accountants. Again, now is not the time to roll back these important common sense protections. I would ask for a no vote on H.R. 2629.
For what purpose does the gentleman from New Jersey seek recognition?
Right, the last word.
Gentleman's recognized for 5 minutes.
So I thank the chairman, and I thank the sponsor of this piece of legislation. This is long overdue legislation, and I appreciate the gentleman leading the charge on it at this point in time. So let's understand exactly what we are dealing with here when the ranking member says that this is good for investors, good for the economy, and so on and so forth. No. The facts speak for themselves, and there are studies that show that really it's not good for any of those. It's really only good for those people who are being paid, which is the auditors. Let's go to some of the facts. The facts say that the costs that the SEC originally projected for this were way lower than what they actually were for the companies and the economy. For example, the SEC initially estimated the cost for Section 404 to be about $1.2 billion. What's the real cost? Around $35 billion, almost 30 times as much. And for these smaller companies, which is exactly what Mr. Fitzpatrick is talking about here, they're talking around $1.5 million, or that's right, 0.46% of their revenue. That's a lot of money to these smaller companies, these entrepreneurial type companies who need those dollars to go to those scarce resources to go to investment purposes, or invest in the new technology, as opposed to investing in hiring outside auditors. Let's also get some facts as far as, is this good for the investors? Well, no. I'm relying here on a study done by the SEC. What did it say? That the benefit investors receive appear to be nominal. For example, as the SEC notes, the majority of respondents recognize no effects of Section 404 compliance on their ability to raise capital, investor confidence, the overall company's firm's value, and so on. So let's then go to the idea that maybe this was good to try to prevent future calamities in the marketplace, as far as companies who fall under the 404 attestation requirement, and because they had it, we were able to avoid any of the pitfalls prior to this law going into effect. Let's go and take it and see what the facts speak there. Well, here it is. Go to the SEC.gov archives, and we can pull out a whole stack of report of independent registered public accounting firms' attestations on various companies. The first one I read, the independent attestation says, in our opinion, such consolidated financial statements schedule, when considered in relation to the basic consolidated statements, so on and so forth, presents fairly in all material respects the information set forth therein. Clean bill of health. Who was that for? Well, it was Bear Stearns back in 2007. How about another one, independent accounting firm, also under this law, says the same thing. Our responsibility is to comply with the law, so on and so forth, and in our opinion, this company maintained in all material respects effective internal controls over its financing, so on and so forth. Who was that on? Citigroup, 2008. How about another one back in 2008? Same language, it's a different company that's doing the attestation. And who is this attestation saying everything's a clean bill of health? Oh, that was IndyMac, 2008. How about here, one other one in 2008? Countrywide, also clean bill of health under the 404 attestation. Another one back in 2008, by February 26, 2008. Again, we have audited in accordance with the Public Company Accounting Oversight Board, and dated February 26, expressed an unqualified opinion on these financial statements. Oh, that's Fannie Mae, another company that we're all familiar with how they did after their passing these requirements. One more I can look at too here. Again, January 28th, 2008, again by a report of independent registered public accounting firms under the 404 attestation provision, which you are saying is essential to public confidence, investor confidence, and making sure that we don't go through this crisis again. Same language. And which one is this on? Oh, Lehman Brothers, 2008. Here's also a report out of corporate compliance newsletter. Internal control failure leads to $500 million loss understatement by Merrill Lynch. Again, they give the same sort of language that I had read before. In our opinion, this outside auditor points to the situation with that company as well. What do all these show is that even for the companies that you're saying that this is supposed to make sure that we don't run into a crisis, each one of these companies, well, we know what the history actually speaks for themselves, how they did. A couple more I could have given you was Merrill Lynch, 2008, Washington Mutual in 2008, and there's a gentleman from New Mexico here, one that he often appropriately references, that's MF Global in 2011. Same attestation was complied with. So perhaps the 404 attestation and independent review doesn't solve the problems that you're suggesting that it does, and perhaps we should improve the economy and improve the ability for these smaller companies to succeed in the marketplace by giving them the breather that they do need and not have to comply with the extraneous requirements of the 404. So with that, Mr. Chairman, I commend the gentleman from Pennsylvania for this legislation, long overdue. Let's see if we can have bipartisan support to make it move forward. Thank you.
Time of the gentleman has expired. Who seeks recognition? For what purposes? Gentleman from Tennessee seek recognition.
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
I support H.R. 2629 and thank the gentleman for his hard work. There's been a 70% increase in IPOs in 2014 already, with over 100 companies filing to go public in just the first few months of 2014, which is close to the average per year from 2001 to 2010. 69% of the companies that went public and after the Jobs Act was signed into law were emerging growth companies with less than $100 million in revenue. Smaller companies now have a better chance to go public and create jobs for unemployed Americans. But more can be done though to improve the process of going public for small companies. Overly burdensome regulations are still hurting business expansion, which is why we are debating this bill today. Mr. Fitzpatrick's bill would simply update the thresholds for the definition of a non-accelerated filer to include companies with a public float less than $250 million and companies with a public float between $250 and $700 million, but less than $100 million in annual revenue. Supporters of increasing the current $75 million exemptions from Sarbanes-Oxley 404B for small companies would save audit costs, which hinder many companies from going public. Going public provides opportunities for companies to raise needed capital in order to expand, reinvest, and create jobs. Providing an update to these exemptions for a law that went into effect more than a decade ago just makes good sense, especially for our nation's small businesses, which are the backbone of job creation in America. I strongly encourage my colleagues to support this legislation and yield back the balance of my time.
Gentleman yields back. Who seeks recognition? Are there any amendments? If not, the question occurs on reporting the bill favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the Chair, the ayes appear to have it. The ayes have it. A recorded vote has been requested. Those in favor of recorded vote will raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is ordered. Pursuant to subsection C5 of Rule 3 of the committee rules, the vote on this question is postponed. Pursuant to notice, I now call up H.R. 3389 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 3389, to repeal the Consumer Financial Civil Penalty Fund and to deposit existing amounts in such fund into the Treasury and for other purposes. Section 1, short title. This act may be cited as the CFPB Slush Fund Elimination Act of 2013.
Without objection, the bill is considered read and open to amendment at any point. The Chair recognizes the gentlelady from West Virginia, Ms. Capito, the Chairman of the Financial Institutions Subcommittee, sponsored the legislation to offer a manager's amendment.
I have an amendment at the desk.
We'll pause for a moment to have the amendment distributed. The Chair has been informed that the amendment has been pre-circulated. So is there any member who has not received the amendment? The clerk will report the amendment.
Amendment offered by Mrs. Capito. Strike all after the enacting clause and insert.
Without objection, the amendment is considered read and will serve as base text for purposes of markup. The gentlelady from West Virginia is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman, and I would like to thank you for marking up the legislation today. When we discussed this in the subcommittee, we had a pretty lively discussion on my bill, and in response to that, I would like to say that we made some changes, one of which was the title of the bill, and so we have retitled it Ensuring Harmed Consumers Receive Compensation Act, because that actually goes to the heart of my bill. And what I see is a lot of gray area here with the CFPB. So basically, just to understand the process, when somebody is considered to be a harmed party or an institution has had practices that are considered harmful to individuals, they are then fined by the CFPB, and that entity then is able to make payments to commiserate with the harm to the individual. So the consumer is paid back through this initial fine. In addition to that, the CFPB then is assessing a civil penalty that goes into this, what I had previously called a slush fund, which I still believe it to be, but I'm going to kind of bite my tongue here and say into the civil penalty fund, which now totals around $116 million. In that fund is supposed to be used for several things. It's supposed to be used if there are other parties that have been harmed, then they can have restitution from this fund. I have no problem with that. That's a right and proper way to use the fund. The other thing that the fund is designated for is financial literacy. And I'm all for financial literacy, but we had a hearing the other day of private entities and nonprofits who are engaged in financial literacy. We found out from the report that was issued that we have 13 different departments and doing 13 different programs in financial literacy, no coordination at all, millions and millions of dollars. So basically what this amendment does, my original bill said that whatever's left over after you take care of the harmed parties that are still remaining, whatever is left over goes to the Treasury. That is in line with what the Federal Reserve, the FDIC, the OCC, and NCUA do with their civil penalty monies. All their money goes to the Treasury. In response to some of the pushback that we had, basically what I'm saying in my amendment is that you can use the civil penalty fund to pay back harmed parties, but you cannot use it to give out for other functions. The fund has been used for administrative costs for the CFPB, which is hard for me to believe an agency that already has over $400 million still needs another $1.6 million for administrative costs. And 47% of the funds that have been distributed previously have gone to the uncompensated consumers. That's fine. I think that's a right and proper use of this civil penalty fund. So basically what we're saying is no more distributions for financial literacy. You can use this money for uncompensated consumers. No more using this for administrative costs. Quite frankly, there's $116 million sitting in a fund that really doesn't have the accountability that we should have as taxpayers and that we should have as overseers of the financial community, CFPB being one of them. So that is the substitute, and that if I want to reiterate to everybody, if a consumer is harmed, they will still get, and they should get, the restitution that they would get from being harmed by any kind of financial practice that is then the CFPB is assessed a civil penalty on. So with that, I would like to yield back and hope for support for my bill.
Gentlelady yields back. For what purpose does the ranking member seek recognition?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
You okay? Thank you very much, Mr. Chairman. First of all,
what's the question?
Let me say to the gentlelady, I'm so pleased that she is amending her original legislation, because I could not understand why she was attempting to prevent the Bureau from using civil penalty funds for victims who have been defrauded by predatory and abusive lenders. So I'm glad you've changed that. Thank you very much. But I don't understand why you continue down this road in a different way to prevent these funds from being used to promote financial literacy and education. I think, Madam, Mr. Chairman, that Ms. Capito has been one of those who have been one of the big supporters of financial literacy on this committee, as have members on this side of the aisle. So somehow to identify this as a problem at the CFPB is just not understandable. Of course, the funds that are used to promote financial literacy and education have not been misused. They have not been abused in any way that have been identified by the gentle lady. And I don't understand why it is not important to continue to be able to promote financial literacy and education as an important function, an important way to utilize these civil penalty funds. And so I would ask my members, number one, to thank Ms. Capito for amending her bill that would have denied the victims from being compensated, but I would also ask my members to oppose the attempts to continue in some way with this legislation that would deny the use of these funds to promote financial literacy and education. And with that, I would yield to the gentleman from Minnesota.
Thank you. I thank the chairman and the gentlelady from California. You know, the Consumer Financial Protection Bureau holds providers of financial services accountable for to treat consumers fairly, and the CFPB holds bad actors responsible for any misleading, fraudulent, or predatory behavior. The CFPB has the power to assess fines to compensate victims and to provide additional penalties to penalize bad conduct. Sometimes a firm that receives fines for defrauding Americans cannot pay any redress. For example, Chance Gordon and Abraham Pessar set up a number of companies that promised to help homeowners reduce their mortgage payments. The firms charged clients upfront fees. Upfront fees are illegal. The firm did not provide the help it promised. The firms also falsely suggested they were affiliated or endorsed by the government, but their victims were not going to be able to receive compensation because the companies could not afford to refund their illegally gotten gains. That's where the CFPB's Civil Monetary Penalties Fund stepped in. Funds collected from the fines from other firms were used to compensate those victims. This bill, which was originally titled the CFPB Slush Fund Elimination Act, would have eliminated that fund. Last night I was provided a new version of this bill. This bill is entitled the Ensuring Harm Consumers Receive Compensation Act. The new title just restates what is the status quo. The CFPB can ensure harm consumers receive compensation if the firm that defrauded them is bankrupt. There is no need for a bill to make sure that the victims of Gordon and Pessar's illegal mortgage relief scheme to receive any redress. There is no need for a bill to make sure the victims of Gordon and Pessar's illegal mortgage relief scheme receive any redress. The CFPB is already able to compensate the victims of Michael DePani's American Debt Settlement Solutions, Inc., which is acronym ADSS. ADSS routinely charges consumers illegal upfront fees for debt relief services that rarely, if ever, materialize. ADSS was fined $500,000 but had no money left to pay, so victims were also compensated from the Civil Penalty Fund. What does this new revised bill do? It eliminates funding that remains after consumers have received redress. Current law provides that to the extent that victims cannot be located or it is unpractical to compensate victims, the Bureau may use funds for promoting financial education. The funds are used to embed a financial education specialist in the Department of Labor job placement sites. Those specialists would exclusively serve members of the military separated from service. I thank Chair Capito for this revised version of her bill. Unlike the previous version of her bill, this revision would not prevent consumers from receiving compensation, but it would deprive them from education.
Mr. Chairman.
Time of the gentlelady has expired. For what purpose does the gentleman from North Carolina seek recognition?
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thanks. I say to my colleague from Minnesota that the compensation to those victims that he mentioned would still be permissible under the text of this law, and I think that's important. The idea of compensating victims is still a part of this legislation. What this is in essence a tip, right? So the CFPB negotiates a settlement with a company. The company then writes checks to those that are harmed, and then the CFPB has this additional tip that they can request and have that company put some cash into a separate segregated fund that I consider, just like my colleague from West Virginia, a slush fund. And in that slush fund, they can pay for administrative fees, which from the recent data we have, it's about $1.5 million they've spent on administrative fees, rather than helping those that are harmed from fraudulent activities. That's not just. That's not right. That's not the intention. And I'm perplexed as to why my Democrat colleagues are speaking against ensuring harmed consumers receive compensation. That's the name of this act. I think my colleague, Ms. Capito, has done a good job of listening to other members' concerns and listening to testimony in the legislative hearing and adapting and changing the text of her bill. I think that's wise legislating. Also, I would commend to my colleagues the Transportation and Housing and Urban Development Appropriations Bill that is on the House floor this week. Within the THUD appropriations bill this week, we'll have just over $200 million for the Neighborhood Reinvestment Corporation. They do a significant amount of housing counseling. In addition to that, in the GAO report from 2010 that my colleague Ms. Capito mentioned, mentions 13 financial literacy agencies or 13 different programs within government that do financial literacy. They spend about $68 million a year on financial literacy programs. Those are good things. I think it is important that the government and private sector be about financial literacy. And I would ask my colleagues why these funds in this CFPB slush fund don't actually go to those programs within government that are working. Why aren't they teaming up with the private sector for programs that are working? And I would like to work with my colleagues on both sides of the aisle to make sure that we have the best financial literacy programs in government. But having this slush fund does not help victims, nor does it actually help improve our financial literacy programs. In fact, it simply creates a different avenue for financial literacy programs to happen, which may or may not be based on best practices. I think what we want is to help those that are harmed, and this bill ensures that that happens, that we actually focus those funds rather than on a variety of different programs. We focus it on helping those uncompensated victims, and that's going to continue. But it also means that the CFPB must be much more responsible with what they do with these funds and the expenditure of these funds. So I commend my colleagues on the other side of the aisle to vote for Ensuring Harmed Consumers Receive Compensation Act. And I would be surprised if they would want to cast that vote against such a wise and good bill, especially with such a wise and good name of such a wise and good bill. And I yield back.
Gentleman yields back. For what purpose does the gentleman from Texas seek recognition? Gentleman would hit his microphone, please.
I move to strike the last.
Gentleman is recognized for 5 minutes.
Thank you, Chairman Hinserling. For 10 years, I have co-chaired the Bipartisan Financial Economic Literacy Caucus. Over the years, the caucus has worked together on many important financial literacy initiatives. The need for financial literacy in America is too great to allow it to become a partisan issue. That's why I am so disappointed and discouraged by the introduction of H.R. 3389 entitled the CFPB Slush Fund Elimination of 2013. I'm sincerely grateful for all of the bipartisan support for financial literacy through the years and within this committee. However, I do take issue with a civil penalty fund being called a slush fund. There is nothing slush nor wasteful about compensating the victims of consumer fraud and abuse, and certainly not about financial education. That is the wrong title for this bill. Penalties assessed against companies that break consumer protection laws are deposited into this fund to be distributed to compensate victims. In cases where victims cannot be located, and that's very important, where they cannot be located, the remaining funds are used for consumer and financial education for veterans and many underserved Americans. Improving financial literacy levels and empowering consumers to make good financial decisions is critical, not just to individuals' financial well-being, but also to the economic security of our nation. 5 weeks ago, I expressed my gratitude when this subcommittee held a hearing entitled Examining How Technology Can Promote Consumer Financial Literacy. At that hearing, Alicia Cackley of the Government Accountability Office testified about how the Consumer Financial Protection Bureau has played an important role in the improved coordination of federal financial literacy programs. And I quote, she said, "We have seen more coordination, especially since the Consumer Financial Protection Bureau came into existence. They've played a role at increasing the coordination across all federal agencies." The Financial Literacy Education Commission existed before CFPB, but since this Bureau was created and the director of the CFPB became the vice chair of that commission, we have seen more coordination happen. Unquote. 2 weeks later, this committee we're in held a hearing on H.R. 3389 and other bills considered here today. When explaining the reasoning behind this bill, my esteemed colleague stated that, quote, "We had a financial literacy hearing just 2 weeks ago, and we found that there are financial literacy programs throughout the government that have no coordination," unquote. That is very confusing, and it doesn't square. It seems to me that the GAO and my Republican colleagues substantially disagree about one of the underlying assumptions upon which this bill is based. Therefore, I urge my colleagues to vote against H.R. 3389, and I yield back my time.
Gentleman yields back. Who seeks recognition? For what purpose? Gentleman from New Jersey seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
And to yield my time to the gentlelady.
Thank you. Respond to the comments on, particularly on the financial literacy, because that was my subcommittee that had our subcommittee that had the hearing. And I am absolutely a proponent and a believer in financial literacy. I think on that panel we had 3 private entities, and we also had World of Money, which is a nonprofit, talked about the financial literacy programs that they were doing, I believe in New York City, with younger people. Very, very well done. And it's less, my bill is less about not having the money go into financial literacy. It's more about transparency and accountability. We're talking about $116 million, and when we had the testimony before our committee 3 or 4 weeks ago about this very fund, it was sitting at around $90 million. So in the space of 3 weeks, we've got another $26 million that one singular director of the CFPB can direct any way he wants into this amorphous financial literacy. And one of the things that we learned that the GAO report talked about was that there's 13 different agencies doing 13 different programs, and there's less coordination. And I'll grant you, she said that CFPB could fill in this space, but there's still a lot, her follow-up statements were that there's still a lot of work to be done. So it's less, in my view, it's not about not believing in financial literacy. I certainly do. Not believing in housing counseling. I certainly do. I think we all agree that making amends to affected parties has, it was not really in the original bill. It was inartfully written. It was supposed to be after you pay the victims, then we move forward with this. So, I mean, I can see why financial literacy as a catch-all is a direction that we all want to go in, and I certainly put myself in that position in partnership with private entities, because that's where the real work's being done. But at the same time, do we really want to see a fund that is accumulating $30 million every 2 and 3 weeks into a fund that we as members of Congress really don't have any kind of accountability for or transparency for? And to say, well, we're going to put it was supposed to go to financial literacy, partially to financial literacy. We've already seen that they used it for administrative costs. Why does a bureau that already has $500 million a year need money out of a civil penalty fund to administer? Makes no sense to me. So I really think it's about more good government and firm oversight and transparency and accountability to know that in another year we're going to be sitting here and we're going to say that fund now has $250 million in it. Where is that going to go? And the other entities that I mentioned in my opening statement, when they assess penalties of this nature, the other financial regulators, that money goes back into the Treasury. And that was my original bill. But I decided to hold back on that and to let it sit and wait and see, make sure all victims are made whole, and make sure that we are moving in the direction that's intended for a civil penalty, which is a victim's penalty. And I agree. I think we all agree. Financial literacy, education, financial education, in conjunction with the 13 different agencies that are doing this, that are uncoordinated with the private sector that we had the hearing about, I really think that we could do a lot better job. And the way to do a lot better job is to have better accountability and transparency for what is now over $100 million fund sitting at the CFPB. And I want to thank the gentleman from New Jersey for giving me his time.
For what purpose does the gentleman from Washington seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. I yield my time to the gentleman from Minnesota.
Thank you, gentleman, for yielding. I'll yield back in a moment. I simply want to add that since we all agree that financial literacy is important, I'm not sure why we need to move forward with the Chair Capito's present version of her bill. I do thank her for working with us and pointing out why Victims Penalty Fund is important, but I think that financial literacy is important. And I might even be inclined to join Chair Capito even with this present version if I had a factual basis for doing so. I'd like to know, are the funds presently being used? Are they not being used for financial literacy? Are the funds being used for some unintended purpose? I mean, we are an oversight body on this Financial Services Committee. We can call the CFPB in and say, what's going on with your civil penalties fund? It's not being used for what you said it was going to be used for, and can take action. But I've actually been sent information from my staff on what the CFPB does with the civil penalties fund, and so I'm not convinced now that this fund is being used in an improper way. I'll also add that I think the CFPB is in the best position to do financial literacy of all the agencies that do it. Here's why. They are at ground zero where the frauds happen. So when frauds happen, as in the cases that I already mentioned, these fake home rescue schemes, things like that, requiring upfront fees, it is the CFPB that is holding these people accountable. So the CFPB can hold bad actors accountable and then turn right around and say, be on the alert because these people are out here doing this. So with that, I'll yield back to the gentleman. And again, it's always a pleasure working with my colleague from West Virginia. I think she's trying to do the right thing. I just don't think that this is the right thing. So I yield back.
I yield back the
balance. The gentleman yields back, and the gentleman yields back his remaining 2 minutes. Thank you. Do we have anyone else speaking on the If not, then the question is agreeing to the amendment in the nature of a substitute. All those in favor will say aye. Oh, yeah. All those opposed will say. Is it okay? I'll roll back. Is it fine? Okay, let's run through that again. All those in favor will say aye. Aye. All those opposed will say nay. In the opinion of chairs, the ayes have it, and the amendment is agreed to. The question is now on the underlying bill as amended. All, huh? Yeah.
Well, we just
underlying bill.
voted on the amendment.
We just voted as.
What, he has an amendment?
Oh. That's fine.
Mr. Chairman.
Do we have any amendments to
the
amendment as the nature of a substitute?
Mr. Chairman.
Looks like we do. The gentleman is.
Mr. Chairman, I have an amendment at the desk.
Okay. Does the clerk have the amendment? We'll hold while the amendment is delivered to the clerk.
I got it. I got it. Yes.
What's that?
Without objection, the vote on the amendment in the nature of substitute is vitiated, and the amendment in the nature of a substitute remains pending.
Clerk will report the Clay amendment.
The clerk will report the amendment.
Amendment offered by Mr. Clay, page 1, line 3.
Without objection, the amendment is considered read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. And Mr. Chairman, I move for the adoption of the amendment. And in the interest of full disclosure and transparency, we ought to tell the public and the rest of the members of this body exactly what it is this bill will do, H.R. 3389. And that's simply stated is what my amendment will achieve if adopted. You know, we talk about financial literacy, and we talk about giving help to veterans. And when you think about it, with the growing economic disparities in this country that persist, with the persistence of poverty in this country, I just, for the life of me, cannot understand why we would want to attack a concept like financial literacy. If we are to help families get out of being mired in poverty, then we need programs that will assist them. And you know, the Bureau has adopted a set of criteria for selecting programs that will serve consumers and improve consumer education and financial literacy. The criteria require, among other things, that programs further the Bureau's mission and strategic goals, promote or enhance financial literacy and consumers' economic security, and include specific outcome targets to ensure the program's effectiveness. The Bureau has selected the first consumer education and financial literacy program that it will fund with civil penalty fund money, and the Bureau has issued a request for proposal to deploy a financial coaching program that will serve two groups of Americans. One, recent veterans who are transitioning from service member to veteran life, as well as military widows and widowers. And two, economically vulnerable consumers who want to improve their approach to money management. One-on-one financial coaching will help veterans transition from military to civilian financial life and help consumers who may be cash-strapped learn how to manage the money that they have more effectively to achieve their financial goals. Working with a financial coach can also help consumers identify and understand how to distinguish between useful financial products and frauds and scams, thus safeguarding against them becoming victims of frauds and scams in the future. The program for recent veterans and military spouse survivors is planned to have a presence in all 50 states. The component for economically vulnerable consumers, although smaller, will provide financial coaching services through locations that are diverse in terms of geographic location and include those from urban and rural communities and from different cultural, ethnic, racial, and other backgrounds. And Mr. Chairman, I would hope that the gentlewoman from West Virginia would consider this a friendly amendment and consider accepting it in that spirit of friendliness. And at this time, I would yield back.
Gentleman yields back. For what purpose does the gentlelady from West Virginia seek recognition?
In the spirit of friendliness, I'm not going to accept your amendment. But I will say that what you've described to me sounds as though that's the business that the CFPB was created for, is to help consumers. We understand that. I'm simply trying to get better transparency. I have a listing here of where the money has been spent. It goes through the receipts very specifically, and then it says disbursed $13,380,000 to consumer education and financial literacy programs. What does that tell you? It doesn't tell you anything. It doesn't give you the accountability and transparency that we're looking for. So with that, I would just say I oppose the gentleman's amendment, but I do appreciate the friendly nature in which he offered it. Thank you.
Who seeks recognition? The question is on agreeing to the amendment. All those in favor say aye.
Aye.
Those opposed say nay. Nay. In the opinion of the chair, the nays appear to have it. A recorded vote has been requested. Those in favor of recorded vote will raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is ordered pursuant to subsection C5 of Rule 3. The committee rules the vote on this question is postponed. Are there any other amendments?
Mr. Chairman.
For what purpose does the gentleman from Minnesota seek recognition?
I have an amendment at the desk.
We'll pause a moment, allow the amendment to be distributed. The clerk will report the amendment.
Amendment offered by Mr. Ellison. Strike all after the enacting clause, insert the following. Section 1, short title.
Without objection, the amendment is considered read.
Mr. Chairman, I'd like to reserve a point of order.
The point of order is reserved. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, other prudential regulators, for example, the Office of Comptroller of Currency, the Federal Deposit Insurance Corporation, the National Credit Union Administration, and the Federal Reserve, all assess penalties. Over the past 10 years, the OCC assessed more than $1.4 billion in civil monetary penalties. The Federal Reserve assessed more than $1.7 billion, FDIC more than $47 million, and the National Credit Union Administration's over nearly $400,000. So that's more than $3 billion collected over the last decade that went to the Treasury Department. My amendment would change how those funds are treated. Instead of sending the money to Treasury, my amendment would require the prudential regulators to establish programs to better meet the needs of communities. Number one, technical assistance to fragile nations. My amendment would let the regulators use penalty funds to provide technical assistance for financial institutions to provide remittances to fragile nations. I'm very concerned about how difficult it is for financial institutions to provide services to remittances providers in Somalia and other vulnerable nations. Number two, technical assistance to banks to meet the anti-money laundering obligations. I emphasize and sympathize with the community financial institutions struggling to comply with complex Bank Secrecy Act and anti-money laundering laws. My amendment would provide some technical assistance funds to them. And three, the community economic development. Today on the floor, we will consider the Transportation HUD Appropriations Bill. As Chair Capito noted in her floor speech last night, the THUD bill underfunds the community development block grants. The THUD bill does not provide adequate investments in low-income communities. My amendment would let financial institutions apply for these funds to fund job-creating programs identified by lenders. 4, manufactured homes. I'm very concerned about the millions of outdated manufactured homes in this country. These homes' utility costs are exorbitant. My amendment provides down payment assistance to let owners of pre-1994 manufactured homes replace their homes with Energy Star manufactured homes. My bill would incent financial institutions to lend to buyers of manufactured homes, creating more competition. And then 5, affordable housing, affordable rental housing. There's 11 million people in this country who pay half of their income for rent. We're not focused on solutions to help them at all in this committee. The THUD bill on the floor today will not help them. So my bill provides for affordable rental housing assistance. And then 6, and this is a very serious issue for me, I'm alarmed by the growing wealth gap and the high numbers of unbanked households. Many financial institutions want to offer matched savings accounts to adults and children. My bill enables financial institutions to see these accounts and match the savings. I think the financial institutions and American families want to see investments in affordable housing, community development, greater access to financial services for the underserved. The appropriations process has failed to provide adequate resources to strengthen our most disadvantaged families and communities. My amendment lets us find another way to invest in the American people, and I urge its adoption.
Will the gentleman yield?
Sure, I certainly
Question.
will.
I don't know if this is overlooked this, but my understanding is you're going to ensure that the CFPB can't help with financial literacy, nor any of these regulators can give funds to financial literacy. Was that the gentleman's intent?
Reclaim my time. What my bill does is recognizes that there are a tremendous number of important needs across our country, that if the gentlelady and the gentleman don't appreciate the current uses for the penalty funds, there are ways outside the appropriation process that we can meet the pressing needs of the American people. Needs like community development, a block grant, needs like manufactured homes, needs like economic development and match savings accounts. But I've been advised that my bill has been ruled non-germane. So, Mr. Chairman, I withdraw it.
The gentleman has withdrawn his amendment. Are there any further amendments? For what purpose does the gentleman from Washington seek recognition?
I have an amendment on the desk, Mr. Chair.
We will pause for a moment, allow the amendment to be distributed. Have all members received a copy of the amendment? The clerk will report the amendment.
Amendment offered by Mr. Heck, page 1, line 13.
Without objection, the amendment is considered read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chair. You know, adages become adages because most often they're predicated on wisdom. And there's none more true than the ancient wisdom that an ounce of prevention is worth a pound of cure. And that's exactly what we're talking about here. It is frankly a bit inconceivable to me that we would seek to separate the agency which is charged with protecting consumers and collecting data about where the most widespread abuses are coming from the effort to prevent them in the first place, which is, of course, what heightened financial literacy is all about. I don't know how it is possible to do that. Now, there are reasons offered here today for why it may not be appropriate for the Consumer Financial Protection Bureau to be the font of effort with respect to increased financial literacy, and they've fallen into a bunch of different categories. But one that is not in dispute is the evidence of need. Every single member of this committee believes that our economy and our consumers would benefit from having increased financial literacy. In a general sense, I think back to the economic crater and the Great Recession. This institution, I've learned in 18 months, has an almost perverse obsession with blame. Here are the themes I've heard. It's the fault of the government because they didn't provide enough oversight. It's the fault of the big bad banks which foisted bad products upon people. It's the fault of the consumers who made poor choices and should have known better. I'm kind of old school. I frankly think it was a bit of each. But the one that we're dealing with here, that we could mitigate, that we could reduce, that we might even be able to prevent, is if we provide consumers with improved tools for decision making when it comes to financial products. What this amendment does simply, and let me digress briefly. The other objection I've heard is that there is not enough involvement with those in the private sector who are delivering financial literacy education. But the very fact of the matter, this is the fact of the matter is that CFPB has been hard at work collaborating with the private sector, partnering with the private sector to provide these tools. They've had multiple rounds of stakeholder meetings, forums, and the like to work with the very people that will be better enabled to deliver education if this amendment passes. The other objection I've heard is that there is somehow a lack of focus in the efforts of CFPB. I get that one a little bit. And that's exactly the problem that this amendment seeks to address by saying that there will be an initial emphasis on transitioning veterans. We all know this, statement of fact, that veterans are more subject to fraud than other populations. They need our help in particular and acutely. In the district I represent, there will be about 4,000 soldiers and service members transitioning to civilian life every year for many years to come, and they need our help. We've been through a pretty tough 10 days or 2 weeks in this institution with respect to how we treat our veterans. I entreat you, I beseech you, to treat them well in this amendment and in this bill by enabling the Consumer Financial Protection Bureau to do what they do well, to do what they are ready to do, to help those young men and women as they take off the uniform and enter civilian life. With all due respect, it is Orwellian to suggest that we are for increased financial literacy and then gut the funds that enable us to heighten it. It is Orwellian. This gives the focus to this legislation and this statute and these funds to help that population which is acutely in need, and which I trust and pray we all share a commitment to. Thank you, Mr. Chair, and I yield back the balance of my time.
Gentleman yields back. Who seeks recognition? For what purpose? The gentlelady from West Virginia seek recognition.
Thank you, Mr. I'll move to strike the last word.
Gentlelady is recognized for 5 minutes.
And I appreciate the Chairman for recognizing me. I appreciate the gentleman's amendment. He knows, and I know it takes it back basically and undoes what I'm trying to do. So I'm looking here at the civil penalty fund as of May 2014. I certainly feel that I can't point to a specific allocation, but I am certain that the CFPB, as you've said, they've had meetings, they've been trying to meet the challenges of helping to educate consumers. I mean, that's the mission, I think, that it was one of the missions that it was originally set up for, so I'm certain they're moving forward on that. But, you know, the kind of cynical question in me is, if they have $116 million right now sitting in this fund, and financial literacy is a need that we all recognize, and supposedly the CFPB recognizes it better than anybody else, why have they only spent $13 million in this region? There's still $116 million.
Are you asking me to yield?
Well, no, I'm kind of esoterically talking, I guess. If you have the answer to that.
There is an answer.
And, okay, what's the answer?
The answer is because they're preparing to collaborate with the private sector and do it right.
Yeah, I don't have great assurances on that one, but I appreciate the answer. So, I mean, I just think that it's an amorphous amount of money. It's growing exponentially. Yes, it's titled under the bill as going to something that we all love, financial literacy and protecting those that you know, I'm alarmed with the number of people dropping out of the banking system. I'm alarmed with folks who are having to go into alternative banking methods. That's sort of been the focus of our subcommittee. We've had a lot of hearings on this to the concern of that. But it's still, you know, it's still out there with directionless, and I just don't have the, I think we can do it better, I guess would be the way. So I'll yield to my friend from New Jersey.
So I would say that it's Orwellian to abdicate one's responsibility and have somebody else be responsible for something, someone else who you have no budgetary control over, someone else you have no authority to tell them to do one thing or another, or no authority to demand answers from them and expect to receive the answers. It's Orwellian to say that you are actually doing something to help your constituents in the area of financial literacy when you abdicate that responsibility and accept none of the responsibility. The way we are supposed to do these things, if you believe in programs such as financial literacy, is to create a program, have it go through the appropriations process, have the ability to have oversight, have the ability to call in the responsible agency and answer the questions and actually get timely answers, and if they don't do as they perform, to be able to change those people at the agency, or at the very least in the interim, to change the funding for them. We have none of that with the CFPB. Dodd-Frank basically allowed Congress to abdicate all of its authority in this area, and then apparently to come back to this committee and claim credit for anything that they do is good, and hold up your hands and say that we're not responsible for anything that they do is bad. Now, you say that gentleman says that he knows that they're going to do it in an efficient or in a manner with the private industry. I don't know that. We haven't heard that. There's no documentation to do that, to that point. We've had them here at this committee. And if they don't do that, maybe they are. Maybe you're privy to information that no one else is privy to in this committee. And maybe they are going to do those things. But what if they don't? Can we stop their funding? No. Can we call them on the carpet and say, well, you were promised this? Well, you didn't promise this, but we heard it through the rumor that you were going to do it and they didn't do it? No. If they don't do as you anticipate or you hope for or you wish, there's no consequences. I think the American public wants to finally to have some consequences out of this administration. I think the American public says it's about time that somebody in Washington is held accountable for their actions. What the gentlelady is trying to do is hold this agency and the money that flows through it to a degree of accountability, and I commend the lady for her efforts. I'll yield back to the lady.
I would just say quickly that, and looking at the structure, I know I don't have any time, but there is a whole consumer education and engagement division separate from this fund. There's a whole Bureau of Office Financial Education that focuses on financial literacy. So for the other side to say that financial literacy will not go forward by eliminating this fund is absolutely not the case when you look at what the CFPB created on.
Time of the gentlelady has expired. Who seeks recognition? Gentleman from Washington has already spoken.
Mr. Chair.
Gentleman from Michigan,
Chair.
for what purpose does the gentleman from Michigan seek recognition?
Move to strike the last word.
Gentleman's recognized for
Yield
5
to the
minutes.
gentleman from Washington.
Thank you, Mr. Chair. I was seeking recognition in order that I might seek unanimous consent to enter into the record the July 19, 2013 solicitation from the Consumer Financial Protection Bureau to all private vendors to participate and collaborate with them in service delivery for transitioning veterans and economically vulnerable consumers.
Without objection.
As well as the statement from the head of that division within CFPB, Holly Petraeus.
Without objection. Gentleman yields back. Who seeks recognition? The Chair recognizes himself for 5 minutes, simply to say that with the exception of the word practical in the phrase transitioning veterans, I don't see where this gentleman's amendment is any different than simply reverting back to the status quo. So certainly the gentleman could have debated the underlying amendment from the gentlelady from West Virginia. That would be my first point. My second point, again, is there is over-focus on the purpose of funding as opposed to the outcome of funding. So I believe we could all agree that financial literacy is a good thing. The question is whether or not CFPB, number one, is adding value on top of the other 13, I believe, financial literacy programs operated by 13 different federal agencies. I haven't seen evidence necessarily that the money is being used effectively. I would like to see the outcomes. So I know the gentleman has apparently evidence of an intent of CFPB to work with unknown private sector entities. May be a good thing, may not, may be effective, may not be effective, I don't know. What I do know is that CFPB continues to be a uniquely unaccountable agency that, as the gentlelady from West Virginia has read from a report, we know little or nothing about the funds that have been allocated towards this purpose, which seems to be somewhat inherent or certainly the tradition that has been set by the CFPB of being a particularly opaque agency and how their funds are being expended. But most importantly, this again would be one more area where they would be unaccountable and unique, because the other similarly situated agencies, the prudential regulators, which my friends from the other side of the aisle wish to compare CFPB to, they don't have the ability to use the proceeds for anything else but compensating the victims as they collect these various settlements and fines. So again, this would be one more way that CFPB would be uniquely unaccountable to the people. I also would agree with the gentleman from Washington. We should show the utmost respect to our veterans. We have all been shocked and appalled by what we have seen unfold at the VA. I would assume that the gentleman would not recommend that we cease to hold oversight hearings on the VA and simply cut them a larger check and not ask them how they are spending their money. And I would also say that one of the greatest ways we can show respect to our transitioning veterans is to give them the freedom to choose their own credit cards, the freedom to choose their own home mortgages, as they have fought for our freedom by donning their nation's uniform. Perhaps we should also respect their freedoms, and I look forward to getting cooperation from the other side of the aisle to ensure that the CFPB cannot abuse their freedom to choose financial products of their own choosing with legislation to follow. With that, the Chair yields back. Who seeks recognition?
Mr. Chairman.
For what purpose does the the ranking member seek recognition?
I move to strike the last.
Gentlelady is recognized for 5 minutes.
Mr. Chairman and members, I can't tell you how disappointed I am that financial literacy would be attacked this way. I know that the gentlelady has said she supports financial literacy. She does not consider this an attack. She simply is concerned about the amount of money at the Consumer Financial Protection Bureau, and she doesn't understand the way that it is being spent. Let me draw your attention to the fact that we have gone through a subprime meltdown in this country that threw us into a recession, almost a depression. And one of the things we all agreed on was that our consumers signed on the dotted line to mortgages they could not afford in many cases. In many cases, they didn't understand what they were signing on to. Many of the members of this Congress learned an awful lot about no-doc loans, about loans that were resetting in 6 months or 12 months, about no-interest loans. We learned an awful lot that many of us had not been familiar with. And so we all agreed in so many different ways that it was important for us to be involved with financial literacy, that first-time home buyers, that people on fixed incomes, people whose incomes perhaps would not increase over the next 10, 15 years, everybody needed to understand mortgages and the various ways by which mortgages were initiated and provided for those consumers who desire to be a part of the American dream. You can't have too much financial literacy. You can't have too many entities of government doing financial literacy. We have a lot in the private sector who are involved with financial literacy. We have agencies of government who are involved in financial literacy, and it's all very necessary. Let me submit to you that if you don't understand how the CFPB is spending its money on financial literacy, it is not appropriate or proper to simply talk about not allowing them to do it. It is more proper as an oversight responsibility to bring them in and ask them to tell us what the program is. It is better for us to talk directly to the head of the Consumer Financial Protection Bureau, have him help us to understand, this is how much money you've spent, what are your projections? How do you plan, because this has been a short period of time that the Consumer Financial Protection Bureau has been in business to begin with. And we don't know what the plans are. We don't know how extensive they are. We don't know what the cooperation is with the private sector. We don't know what the coordination is with the other agencies of government. Why are we jumping to conclusions rather than doing a respectable and responsible oversight? So I would suggest that if we are truly concerned about financial literacy, and if we truly want to help all of our constituencies understand what they can and should learn about financial dealings, we would not cut off the ability of this agency to help people with financial literacy. We would understand exactly what they're doing and how they're doing. And I submit to you that this committee can call in Mr. Cordray anytime that they would like. He has been cooperative in every way. When he's been wrong, he's admitted it. When he has made changes, he has done that with no apologies. And so I would ask that we not support this substitute amendment because it is premature and it does nothing to help with financial literacy, even though we claim to support it. I would yield back the balance of my time.
Gentleman yields back, who seeks recognition. For what purpose does the gentleman from New Mexico seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Yield as much time as you might consume to the gentlelady from West Virginia.
I'm going to make this brief, and I appreciate all the discussion. I think it's been very lively. I do know what the CFPB is doing in terms of consumer education and engagement because they give us a semi-annual report. In the semi-annual report, which is covering consumer education and engagement, which is financial literacy, financial education, working with public libraries, working with the youth, working with the veterans, working with workplace financial literacy. There are, in the second quarter of 2014, they spent $11 million. So over the year, it's going to be $44 million that they're already spending in the space of financial literacy and financial education. I know that because it is specifically lined out in their report. All I know about what they're spending in this fund is that they spent $13 million for consumer education and financial literacy programs. I have no idea to who and to what entity, according to this, that I can find out. And we've asked, and we need to ask again. But remember, this is the same CFPB that Mr. Pierce has asked how many questions of and never gotten the answers. So, you know, I mean, I do think that the ranking member keeps saying, we don't know, we don't know. How many times when Mr. Cordray comes before this committee does the argument begin with, he's been here 28 times, and yet the other side can still say, we don't know? Not right now. I think I've talked enough. I think I'm going to have to say I am very much a proponent of financial literacy. I'm very much an opponent of financial education. The CFPB is spending approximately $40 million in this space already. They are using a separate fund for whatever reasons we don't know. It's under this just general category. It's not accountable today. It won't be accountable 10 years from now as we move forward. And by that time, at this rate, there could be $1 billion in this fund. Who knows? With that, I'll yield back. Thank you. Thank the gentleman for his time. Or I'll yield back to the gentleman.
Thank you. The gentleman from Washington had said it's inconceivable why that someone would be opposed to your amendment or to the process of financial literacy. I would just tell you that no one is opposed to the idea of childhood obesity. We've got over 100 agencies dealing with that, and those are supposed to be accountable to us, and yet we can't get that in control. No one is opposed to what the VA is doing, and they're supposed to be accountable to us, and yet you see that system is run amok. And all we're saying is that this system in the CFPB has no accountability, no ability for us to impact it, and that's a very simple problem that we're addressing here. No one has any opinion or ill will towards work training program, but one work training program may cost a couple of $1,000 while some cost $35,000. One work training program trained people, felons, for work in police forces. We can't go back and get that money back. And so, again, we see these elements where we're supposed to have control and don't have too much control. And in the CFPB, we're ceding total control, and that's a problem for me. I don't know. The ranking member said that you can't get too much financial literacy. Well, that in itself is not a protection, because John Corzine had about as much knowledge as anyone, and he broke MF Global by putting money where he shouldn't have been putting it anyway. And so this idea that we're going to somehow inoculate all of America by these programs that they're going to spend millions and hundreds of millions of dollars is one that just ends up being sort of empty when the taxpayers are the ones getting stuck for the bill through higher fees in order to pay a CFPB that is not accountable to anyone. I think that the objections are quite conceivable, as a matter of fact, and would yield back my time. Thank you, Mr. Chairman.
Gentleman yielded back his time. Who seeks recognition?
Chairman.
Who seeks recognition?
Green from Texas.
Gentleman from Texas seek recognition for what purpose?
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I will yield initially to the ranking member.
Thank you very much. I appreciate that, Mr. Green. I'd like to ask the members on the opposite side of the aisle, which one of you, in the many times that Mr. Cordray has been before this committee, asked him about his financial literacy program? Which one of you did that?
Ma'am, I did.
Would you please tell us what you asked him and what he responded?
Sure. Thank you. If the gentlelady would yield.
Yes, I yield to the gentleman.
Thank you. So I have asked Director Cordray before the committee and in subsequent written communications and phone calls about his financial literacy programs and what he's doing to try to coordinate the 13 different programs better. And his answer, and I'll try to summarize the best I can. Is that okay? His answer to me was that he is trying to work. They have a financial literacy coordinating council that he co-chairs, and he is working through that to try to coordinate the programs better. And that was really the extent of what he said they're trying to do. And I do think we need to continue to do a better job of coordinating those 13 programs. I think the director is trying to do that. He did not give me a detailed accounting of where the money's going, I will say, and I don't know that I asked that. So I just asked what he's doing with his coordination program. So that's the extent of my interaction, both in the committee and in subsequent follow-on letters and phone calls.
Well, thank you very much. And I guess, can I reclaim the time, or do you have to reclaim the time?
I will yield.
It's the gentleman's time from Texas.
I will continue to yield to the ranking member.
Thank you very much. And I appreciate that, because what was just told to us is that Director Cordray had a response that talked about a coordinating council that he's putting together, that he's working on, which was not indicated in any way that the gentle lady seemed to know about, to factor into her thinking.
Yield.
And so I still would remain with my position that we have not queried him enough. We don't understand what his projection. No, I will not yield you And I would hope that the gentleman who...
The time belongs to the gentleman from Texas, which I assume just got his cue from the ranking member.
The gentleman continues to yield to the ranking member. And so I maintain that we have not queried him sufficiently about the programs that he is initiating. We don't know what his projections are. We don't know about how far he's gotten with the coordinating council that was just told to us. And so, again, I feel that this attempt to take away his ability to do what he needs to do and what he perhaps wants to do on financial literacy is premature, and it should not be done. And I would ask that we reject this legislation and we vote against it. And thank you, Mr. Green, for yielding the time to me.
Reclaiming my time, I shall now yield to Mr. Heck.
Quickly, 3 points. It's been asserted here that no other agency has a similar approach to consumer education. Not true. Not true. Both the CFTC and CMS have exactly parallel programs. Number 2, we're kind of down to it here. Now what I am hearing is it's about accountability. I embrace that discussion. That's a healthy discussion. That's an appropriate discussion. And I only wish that the bill that would have been brought forward would have been a bill to create some accountability mechanisms. It doesn't. It eliminates. It's not about accountability. It's about elimination. And thirdly, notwithstanding what my good friend, the esteemed member from California and the ranking member keeps saying, the issue before the committee right now is my amendment, not the broader bill. And what my amendment seeks to do is to provide for an avenue to provide for financial literacy for transitioning veterans. That's what this amendment is about, helping the tens, if not well in excess of 100,000 service members who will be transitioning out into civilian life, to give them the tools to be successful. Please vote yes. Thank you, Mr. Green.
I yield back.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Ohio seek recognition?
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. I do want to clear up any misconception or confusion. The Financial Literacy Coordinating Council was created by an act of Congress and not by Director Cordray, and has been continuing for a while. I do think there need to be some changes, and I'm working on a bill that would fund financial literacy overall and actually require some coordination of our financial literacy programs. I want to work with anybody on the committee who's interested in working on that, and we've got a first draft that should be back in the next couple weeks, and I look forward to working with folks on that. And if do you want any more time? Nope. Yes, I will yield.
Just as Congressman Heck indicated a moment ago, we're not opposed to accountability. We're not opposed to accountability at all. And it seems to me you're moving in that direction. And you have a more comprehensive approach to dealing with the question of financial literacy. And some of us would be happy to work with you on that. And it sounds as if it's something we could be very supportive of. So I would ask your colleague, in the interest of the comprehensive work that you're doing, to respect that and to allow this committee to have that opportunity to work with you rather than continuing to try and force a vote on this bill today. I yield back to the gentleman. Thank you.
Thank you. I yield back.
Would the gentleman yield to the chairman?
I will yield the chairman my time.
This debate has ensued for quite some time. I think, once again, it would be important to focus at the issue at hand and to remind all members, I believe this is now accepted as fact, the CFPB already has financial literacy programs separate and apart from the Victims' Compensation Fund. So number one, they already have a financial literacy program. We can debate whether those have been effective, ineffective, whether they are benevolent, whether they are malevolent, whether they serve any purpose whatsoever, but they exist. So number one, regardless of what happens to the gentleman from Washington's amendment or the gentlelady from West Virginia, CFPB will continue to be in the financial literacy business. Ostensibly, we will find out just how effective they have been. The issue is whether or not funds for that are collected in a victim's compensation fund should be used for other purposes besides victim compensation. The gentlelady from West Virginia says no. The chairman agrees. I am still struck again by how many times the ranking member said, we don't know, we don't know, we don't know, with respect to what the CFPB is doing with this particular tranche of funds that theoretically are earmarked towards victims, rather not earmarked to victims' compensation, but instead ostensibly some form or facet of financial literacy over and above their other programs. So if we don't know, then why don't we put the onus on them to make their case that they need this extra power? And it is a very perverse incentive to be able to go out and impose civil penalties and then be able to use those for other purposes. That's the issue that I don't think has been sufficiently illuminated in this debate. It is a perverse, and as the gentlelady from West Virginia has brought up on more than one occasion, they have used the funds that are supposed to go to victims' compensation for administrative overhead. Such a deal. I can go out and now impose civil penalties to help pay for the penthouse at my new refurbished building that costs more money on a square foot basis to build than the Bellagio Hotel. Such a sweet deal. I can go out and impose these civil penalties and use them for other purposes besides victim compensation. That is a dangerous practice. It creates perverse incentives. Our committee should not be a party to it, and I would urge all members to reject the amendment from the gentleman from Washington and support the underlying bill of the gentlelady from West Virginia.
Reclaiming my time and yielded back the...
Well, regrettably, the chairman just took all your time. Who seeks recognition? The question is on agreeing to the amendment of the gentleman from Washington. All those in favor say aye.
Aye.
Those opposed say nay. Nay. In the opinion of the chair, the nays appear to have it. A recorded vote has been requested. Those in favor of recorded vote will raise their hand and be counted. A sufficient number having raised their hand, a recorded vote is ordered. Are there any other amendments? For what purpose does the gentleman from Michigan seek recognition?
Mr. Chairman, I have an amendment at the desk.
We'll pause for a moment and have the amendment distributed.
I've got one. Thanks.
All of our amendments are amendments to the amendment, not just.
About to go.
The clerk will report the amendment.
Amendment offered by Mr. Kildee. Add at the end of the following.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. And I certainly don't want to relitigate many of the discussion, much of the discussion that has already taken place on this, and I'll certainly also avoid references to George Orwell. That seemed not to have worked. Maybe I'll inject some Will Rogers, who said that if you inject truth into politics, you have no politics. So let's just get some facts, all right? What this amendment would do is fairly simple. It premises the full force of this legislation, assuming that it would be enacted, on the completion of a GAO study on whether the CFPB has in fact played a role in improving the coordination of financial literacy efforts among the various federal departments and agencies. This amendment would require the GAO to complete such a study within 90 days of this bill's enactment, to submit its completed report to Congress and to the Treasury Department, and Treasury then would also have 90 days to make a determination independent of CFPB as to whether or not it, in its opinion, sees those coordinating activities as having been successful in advancing financial literacy efforts among those federal departments and agencies. We do know, and I'm glad to hear that there's broad support for financial literacy efforts, and I understand that there are a number of agencies providing such. But in this case, here we have a source of revenue, that source of funding that can be used to support financial literacy. It can, in effect, I think, and I would disagree with the chairman's analysis of the sort of the perverse incentives here. My thinking on this is that if in fact the use of these civil fines and penalties is used to actually reduce the likelihood through improved coordination of financial literacy efforts and improved efforts overall, decrease the likelihood of the kinds of activities that would result in losses and fines, then it would seem to me that the incentive to use these dollars to reduce those programs or those sorts of activities actually has a very positive impact, and presumably a better informed consumer would less likely fall victim to an entity that is engaged in this sort of activity. So to my way of thinking, the question here is sort of been litigated as to whether or not there's a sense that the CFPB's efforts in this space have been effective. Let's just simply get a report that determines whether or not that effort has been effective, and not pull back on this important effort if in fact the determination is that this has been a successful and important and a viable use of these funds. With that, I yield back.
The gentleman yields back. For what purpose? The gentlelady from West Virginia seek recognition.
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Yeah, I would be in opposition to the gentleman's amendment because it basically guts my bill. And at the risk of being repetitive, I would like to say that the CFPB is in the financial education and literacy space of $44 million right now, separate and apart from a civil penalty fund. This is about making sure that all the victims of any kind of disruptive and unfair and dishonest practices are fully compensated. And it's also about transparency and accountability of $116 million, separate and apart from the $44 million that's already going forward with literacy efforts as we see them. Thank you.
Gentlelady yields back. Who seeks recognition? Are there any amendments to gentleman? Oh, I'm sorry. For what purpose does the gentleman from Minnesota seek recognition?
Move to strike the last.
Gentleman's recognized for 5 minutes.
I want to speak in favor of the Kildee amendment because I think it gets to my basic problem with the bill. I mean, I'd rather have us call some witnesses in here, take some testimony on the use of the civil penalty fund. Is this fund being properly used? Is it not? Is the fund are the funds being applied to the purpose for which they were intended or not? Is there a slush fund or is there not? I'm afraid we're kind of legislating by anecdote here. I'd rather have some real data to move ahead on. I mean, the fact is our country just went through one of the great financial perils of our nation, and you know, massive frauds occurred, massive abuses of financial, massive abuses of people's wealth was taking place, and literally we've seen Americans lose home value, all because of a lack of consumer education, consumer protection. And so before I'm going to peel back on an agency doing consumer protection, consumer education, I'd like to know whether that's a worthy, meritorious thing to be doing. And so, unfortunately, you know, I can't support the underlying bill until I have a factual basis. But I just want to say that I don't think it's improper for Chairwoman Capito to want to make sure that government funds are used properly. I think she's right to want to do that. I just think we need to know whether that's what we would be doing if we followed her bill, and I don't think we have the factual predicate to make that decision. So I would support a study in this case. I think that really is what's warranted. I yield back.
Gentleman yields back who seeks recognition. For what purpose? Gentleman from Ohio seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'll be pretty brief. I hope no one doubts my commitment to financial literacy. As I said, I'm working on a comprehensive bill that I think will solve many of these problems. With regard to the amendment, the Inspector General did a comprehensive report of all 17 programs the federal government is spending money on in the financial literacy space just less than a year ago. And it's already out there, and it relates to a number of issues related to them and things that I think we can fix in the bill that I'm proposing. The greater issue of the bill that the gentlelady from West Virginia poses is to make sure that we don't create a moral hazard for the CFPB to encourage them to fine folks more to send that money to a good cause, and secondarily to make sure that the victims of crime are the beneficiaries of the Victims of Crime Fund. That kind of is a no-brainer, and we all want to make sure we take care of the victims. But if it's a choice between compensating the victims and spending money on financial literacy, which sounds like a great issue too, there's a way to do both. But the Victims of Crime Fund should take care of the victims, and we'll find a way to fund financial literacy. And as I said, I'm working on the comprehensive bill that I think can help fix that. I yield back to the
Would the gentleman yield again to the chairman?
I will happily yield to the chairman.
And then if the gentleman would like some of his time back, I'll try not to be so greedy this time. I would urge members to reject the amendment of the gentleman from Michigan. Among other reasons, as I read this, and it is reading the amendment for the first time, the GAO is to carry out a study to determine whether CFPB has played a role in improving the coordination of financial literacy efforts. So as I read it, it is not restricted to the question at hand, and that is the use of the civil penalty fund to engage in other practices besides compensating victims. So it does not segregate, bifurcate, if you will, between this and the other financial literacy programs of the CFPB. So if we had this study, it would not tell us, again, necessarily whether or not the civil penalty fund, quote, played a role in improving the coordination. I would also offer the opinion that playing a role is a fairly low threshold. I suppose one could play a role in improving coordination of financial literacy efforts by making a conference room available for a meeting and serving coffee. That would be a role in improving coordination. I'm not sure that's really what we're trying to get at. What we're really trying to get at is this a good use of funds separate and apart from other uses, and whether or not there are perverse incentives in using a civil penalty fund for other purposes besides compensating victims. If we're going to have accountability, then what we really ought to do is put the CFPB on the appropriations process so that we can have a legitimate debate on should we be spending $40 million, $60 million, $20 million, $80 million on these efforts, and are they really improving financial literacy among our consumers? So I would urge a rejection of the gentleman's amendment from Michigan, and I thank the gentleman from Ohio for yielding time to me, and whether or not he knows that he just yielded it back. Who seeks recognition? The question is on agreeing to the amendment. All those in favor say. For what purpose does the gentleman from Kentucky seek recognition?
Move. Word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I just was reviewing the most recent GAO report looking into the CFPB's financial literacy programs, and since my friend, the gentleman from Michigan's amendment, calls on a new GAO study to carry out another analysis of whether or not CFPB has played a role in improving the coordination of financial literacy efforts among federal departments and agencies. I just note that the GAO just issued a report looking into that very point. Now, we could continue to study this, I suppose, with the gentleman's amendment, but let me just quote something from the most recent GAO report looking into the very same issue. And this is from, I believe, just this past spring, the GAO report. And it says, quote, in July 2012, we recommended, GAO recommended to Treasury and CFPB that the Commission, namely the Financial Literacy and Education Commission, identify for federal agencies in Congress options for consolidating federal financial literacy efforts into the agencies and activities that are best suited or most effective. Commenting on a draft of that report, Treasury agreed with the recommendation, and subsequently CFPB noted its agreement as well, but the recommendation has not been implemented. And I would just suggest that if the CFPB is not taking the recommendations of the GAO, why are we asking the GAO to do another study? And I'd be happy to yield to the gentleman.
Thank you.
The gentleman has yielded to you.
Thank you for yielding. So I guess I'm a little confused because what I've been hearing up until the comments by the gentleman from Ohio and now yours is that there's been no study, no oversight, no report, no information on the use of these funds for financial literacy. And in fact, what was stated is that the only information that was presented, the only information that the committee had access to, was a statement as to the amount of money that the CFPB has used for this particular purpose. I do think, and I share the concern about oversight, I do think that there's a need for oversight. And it would seem to me that a specific review, which would presumably, intelligent people at the GAO executing it, would go beyond the provision of a conference room and coffee for the meeting. But a review, a serious review, specific to the questions that the committee, this committee markup is elucidating, would be very helpful. Now, if it's your view that that information has already been provided, Mr. Heck has already pointed out that there's a process of implementation underway. There has been a request for proposals prepared for private sector participation in the implementation of these important financial literacy programs. So perhaps implementation is simply a matter of time. I don't know. But it would seem to me that more information is always better than less, and more timely information, I think, in this case, as opposed to simply saying, let's just eliminate this as a potential authorized use of the funds, would be a step in the right direction. With that, I yield back.
Well, thank you for your answer. It just seems to me that the GAO has already done this, already done what your amendment seeks to do, which is to look at this issue, and they've made a recommendation, and the CFPB has not adopted the recommendation related to coordinating these efforts. I would just kind of finally, just in the remaining time I have, I would just kind of generally note that these federal programs related to financial literacy do not appear to be working. In 1960, the personal savings rate, the share of people's after-tax income that they saved, was 11%. In 2013, it was just over 4%. 3/4 of the American people are living paycheck to paycheck. And according to a 2009 survey conducted by market research firm TNS, nearly half of all Americans don't believe they could come up with $2,000 in 30 days if they had to. Now, some would say, well, that counsels in favor of more government-run, government-dictated financial literacy programs, because we clearly have a problem in this country with financial literacy. But if these 13 or 14 or 15 financial literacy programs that we have across 13 federal agencies were actually working, I don't think we'd see these kind of statistics. And I don't know what another program is going to do to help this. I think we need to fundamentally reform the way we're doing this in this country. I yield back.
Gentleman yields back. Who seeks recognition? Chair very briefly yields to himself. Just to say again, I want to crystallize the debate. We're talking about a civil penalty fund for victims should funds be used for other purposes. I remind members that there could easily be a great fraud perpetrated for which there may be insufficient funds. All the gentlelady from West Virginia is saying, victims' compensation funds should go to compensate victims. Every dollar you take out of that fund to spend for some other purpose, you're taking away from victims. Now, if that's something that the minority side wants to do, happy to have your recorded vote on that subject matter. The question before us is, should a victims' compensation fund be used for victims' compensation? I would urge defeat of the gentleman's amendment from Michigan, and I would urge a supporting vote on the gentlelady from West Virginia. I yield back. Who seeks recognition? The question is on agreeing. The question is on agreeing to the amendment. All those in favor say aye. Those opposed say nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it. The amendment is. A gentleman has asked for a recorded vote. A recorded vote has been requested. Those in favor of a recorded vote will raise their hand and be counted. Sufficient number having raised their hand, a recorded vote is ordered pursuant to subsection C5 of Rule 3 of the committee rules. The vote on this question is postponed. Are there any other amendments? There being no further amendments, without objection, the previous question is ordered. Pursuant to notice, I now call up H.R. 4604. 4604 for purposes of markup, and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4604 to amend the Consumer Financial Protection Act of 2010.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from Georgia, Mr. Westmoreland, the sponsor of the legislation, for 5 minutes.
I want to thank the chairman for bringing this simple little bill, H.R. 4604, that provides security and control of personal information held by CFPB for all consumers. We all know that the CFPB is collecting personally identifiable information. On April the 16th, the CFPB, in conjunction with the Federal Housing Finance Agency, released a notice in the Federal Register expanding the type of data collected for the National Mortgage Database. Data collection will now include Social Security numbers, financial account numbers, home address, and GPS location of your primary residence, and your name and the ages of your children. At the July 2013 hearing, I asked Deputy Director Antonkis how many employees at the CFPB have access to the data CFPB collects. After much delay, the CFPB responded that a minimum 830 CFPB employees and contractors have access to the personal financial data. And we've already seen what one person at our security agency has caused with that data breach. Finally, I asked the CFPB employees who access personal financial data, do they have a security clearance? The answer is no. My bill, the CFPB Data Collection Security Act, is a direct result of CFPB's actions and answers to my questions. The CFPB Data Collection Security Act has 5 main provisions. First, the bill allows any individual to opt out of all CFPB data collection. CFPB would have to provide an opportunity for individuals to opt out of data collection and would not be allowed to collect information pertaining to that individual at any time in the future. Second, H.R. 4604 requires CFPB to purge data from their system after a certain period of time. For records regarding a consumer complaint, those records would be purged after completion of the CFPB review. For data collected during an examination, the CFPB would have to remove data after 3 examinations. For any other information, the CFPB would have to remove the data after 60 days. Third, the CFPB Data Collection Security Act would require the CFPB to provide consumers with 1 year of free credit monitoring following a data breach. CFPB would also have to provide public notice on its website of the data breach. We all know what the devastating effect of the Target data breach has had to consumers, and they did the right thing and at their own expense provided free credit monitoring. We feel this good government's provision should be applied to the CFPB as well, especially since it is my belief that CFPB's systems still remain vulnerable to outside attacks. Fourth, CFPB would not be allowed to collect data without a Senate-confirmed director. I will have a manager's amendment later that will clarify this provision so CFPB would be able to continue their ongoing supervisory duties. Finally, H.R. 4604 would require any CFPB employee handling personally identifiable information to obtain a confidential security clearance. A confidential security clearance is the least level of a government clearance. Mr. Chairman, these are common sense reforms that allow individuals to have control over the data the government collects on them in the name of consumer protection. Since the CFPB is not accountable to Congress or the President, it is my firm belief CFPB must be accountable to the consumers, the same consumers that they are charged with protecting. Let us give consumers more control over the data the government collects on them, and I urge my colleagues to vote yes on H.R. 4604. And, Mr. Chairman, I yield back.
Gentleman yields back. For what purpose does the ranking member seek recognition?
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you very much, Mr. Chairman. The committee has already considered an opt-out bill that Representative Duffy introduced, and the Republicans already forced it through the House, making most of the effect of this bill duplicative. Eliminating the CFPB's ability to retain data over long periods interferes with the agency's mission to be a data-driven regulator. Long-term trends in consumer credit markets are an important source of information to the Bureau's researchers and policy teams. Forcing the Bureau to act without the benefit of data leads to inefficient outcomes that are bad for banks and consumers. Neither other regulators nor the many businesses that collect, store, and sell personal financial information are required to attain national security clearances for their employees. The CFPB's cybersecurity infrastructure has been audited, and the Inspector General found few opportunities for improvement, and that the agency was making great progress implementing standards set by federal government, as well as improvements recommended in previous audits. Notably, even though several very large security breaches have occurred at private businesses in the last year, Republicans have not made any efforts to provide additional protections to consumers or increase standards for how businesses handle sensitive customer and consumer information. The manager's amendment fails to address the substantive problems with this unworkable bill. The bill misleadingly suggests that the Bureau does not properly safeguard consumer information and creates an unnecessary burden on the Bureau, which would hamper its ability to protect consumers effectively. I consider that this bill is yet another example of unnecessary legislation designed to create obstacles and hamper the CFPB's ability to carry out its mission and to be effective. I would ask my colleagues not to support this bill. It is, again, duplicative and quite unnecessary. I would yield back the balance of my time.
Gentlelady yields back. Who seeks recognition? For what purpose does the gentleman from Minnesota seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I urge my colleagues to not support this particular bill. This bill seems to continue this fiction that the Consumer Financial Products Protection Bureau can look up any name or anyone's name and pull up everything there is to know about any of us. Some believe that the CFPB can find my credit history, my credit cards, my credit report, my mortgage, my retirement account information. None of this is true. With the exception of consumer complaints, the information the CFPB has access to is not attached to someone's personally identifiable information. But this information, the information it does have, is important. In fact, if you want to see if African Americans or Latinos are charged more for mortgages, you've got to review these loans. If you want to see if consumers whose medical debt takes a while to settle are harmed with lower credit scores, you need to look at the credit reports. This bill makes that access nearly impossible. It imposes extreme requirements that are not required by any other regulator. This bill would severely curtail the Bureau's ability to perform its market monitoring and consumer protection functions. And I'm not even sure how it will work. If someone opted out of having their information collected, would some CFPB staffer need to find a way to link that individual to every potential personally identifiable link? I intend to offer amendments to address this particular bill, but I simply would urge anyone listening to debate to consider, does it make sense for an agency charged with protecting consumers to be able to look at the trends in the data so that we can try to head off massive frauds before they really take root? I think it does make a lot of sense. If we had such a thing, we might have protected ourselves from the predatory lending scandal that has truly destroyed so many people's financial lives in this country. So with that, and with respect, I yield back.
Would the gentleman yield, just for clarification,
well,
did the gentleman say he intended or intends to offer amendments? I simply inquire because there are votes on the floor, and I'm trying to figure out the ability of the committee to dispose of the gentleman.
I did have an amendment that I was going to offer in this committee, Mr. Chairman. But I mean,
or did?
I do.
Thank you. The chairman was seeking that clarification.
I understand it may not be now because we got votes on the floor.
Yes, yes. Who seeks recognition? For what purpose does the gentleman from Pennsylvania seek? I'm sorry, if the gentleman would yield for just one moment. There are votes taking place on the floor. We'll probably recognize 2 more speakers, and then the chair will declare a recess. So the gentleman is recognized for 5 minutes.
I'd like to yield to Mr. Westmoreland.
I'd like to, and thank you for yielding. I'd just like to point out the Federal Register, Volume 79, Number 73, Wednesday, April 16, 2014, notices. This is the National Mortgage Database Project. Categories of records in the system: borrowers, co-borrowers information, name, address, zip code, telephone number, date of birth, race, ethnicity, gender, language, education records, religion, Social Security number, military status records, employment status records, financial information, account number, financial events in the last few years, life events in the last few years, other assets and wealth, mortgage information, current balance, current monthly payment, delinquency grid, monthly payment, refinanced amount, bankruptcy information, credit card, other loan information, account type, credit amount, account balance, amount past due, amount minimum payment amount, account actual payment amount, account high balance amount, account charge-off amount, second mortgage, household composition, single male, single female, presence of children by various ages, categories, number of wage earners in household, household income, credit scores, borrowers, co-borrowers at origination, Vantage score, deceased indicator, marital status, property attributes, property type, number of bedrooms and bathrooms, square footage, lot size, year built, age of structure, units in structure, most recent excess value per tax row, year of most recent excess value, effective age of structure, assessor's partial number, neighborhood name, and project name, real estate transaction attributes, sale price, down payment, occupancy status, owner, rent, new versus existing home, county, census tract, block, latitude, longitude, and date purchase, mortgage characteristics, attributes, mortgage products and purpose, origination date, acquisition date, amount of mortgage, refinanced amount, amount of down payment, term of mortgage, interest rate of mortgage, source of mortgage, mortgage channel, mortgage insurance type, loan to value at origination, origination amount, credit limit, originator, current servicer, debt to income ratio at origination, number of borrowers, numbers of units in mortgage, presence of prepayment penalty, origination points paid by borrower, discount points paid by borrower, balloon payment date, amount, percentage of down payment, secondary market indicators, and 9, information collected from consumers as part of surveys, randomized control trials, or through other mechanisms. I would say that is pretty detailed information that they're going to have, and there is a need for this bill, and to say that they do not have the information or will not have the information, somebody needs to argue with the Federal Registry and not to author this bill. And I yield back.
Time belongs to the gentleman from Pennsylvania.
I'll take it.
I yield the balance to Mr. Pierce.
Thank you, Mr. Chairman. I thank the gentleman for yielding. When we were here, we had the opportunity to ask Mr. Cordray many questions about this program. He left a lot of things unanswered. There are those who claim that no personally identifiable information is being gathered, but the mortgage database, the National Mortgage Database collection proves just the opposite. That is, the registered notice specifically states what is being gathered. The CFPB is collecting information on hundreds of millions of people, and it's critical data. They're going to hold it permanently, and I'm not sure exactly how they're going to protect it. I made the point to Mr. Cordray that Mr. Snowden's release was not planned by the agency. It's just that the agency will not have control over everybody that looks at it. One of the things I think is critical is that people whose information is being gathered have a right to know that criminals are not looking at that, and that people who intend to release it through unauthorized mechanisms are not looking at it. We specifically have questioned CFPB about if DHS, Secret Service, and FBI have or have not been involved in it. They said that they have not been. I mean, this is very highly technical stuff, and they're not going to the specialists. They're going to create their own specialists. I find that very disturbing, but a lot of reasons that we support the gentleman's bill and are his bill. So, again, support that. Yield back.
Time of the gentleman has expired. Pending the conclusion of votes on the floor, the committee stands in recess. The committee will come to order. We will presume proceedings on the consideration of H.R. 4604. For what purpose does the gentleman from New Mexico seek recognition?
I have an amendment at the desk.
We will pause and allow the amendment to be distributed. All members received a copy of the amendment. The clerk will note that the amendment is being offered by the gentleman from New Mexico, Mr. Pierce, not the gentleman from Georgia, Mr. Westmoreland. The clerk will report the amendment.
Amendment offered by Mr. Pierce, page 3, after line 11.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Mr. Chairman and members, this amendment is necessary in order to clear up possible discrepancies. We clarify the term collect in this, and it means that we'll clearly let the CFPB know what information is not allowed to be collected if a consumer has chosen to opt out. Secondly, the amendment would clearly state what purposes CFPB may collect personally identifiable information. And finally, I believe that with these changes, it's necessary to clarify to the CFPB what will be required by the bill while not restricting their stated purposes of protecting consumers. The language has been structured so as not to interrupt what's ongoing. There were possibilities that the original language could mean that, and after talking to the author of the underlying bill, he's in agreement that these clarifications need to be made. And so with that, I'd yield back.
Gentleman yields back. Who seeks recognition? Are there any for what purpose does the gentleman from Wisconsin seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I think this is an incredibly important bill and an incredibly important discussion because we have our federal government collecting massive amounts of information on the American citizenry. And I think this is analogous to the NSA. When America found out that the NSA was collecting phone records about who you call, when you call, and for how long you call, most of America was outraged that the government would have such personal information on them and how that information could be used by the government. And one could argue that the NSA would push back and say, but what we're trying to do is we're trying to protect America from terrorist attacks. There's a reason why we're collecting this information. It's compelling. We experienced 9/11. We don't want America to experience that again. And so, yes, there's an invasion of your privacy, but there's a good reason for it, America. A lot of us disagree with that, but you could step back and go, well, they're at least making an argument that has some flow and makes some sense, though we might disagree with the argument. We do agree that there is a risk. With the CFPB and the collection of all the information on Americans in regard to their financial transactions, as Mr. Westmoreland earlier discussed, Social Security numbers, financial accounts, zip codes, addresses, phone numbers, race, religion, and the list goes on. What's the compelling reason? Why are they collecting this information? The NSA gave us their reason. What is the CFPB collecting this information for? And I don't think there is a good reason when the only reason that I've heard is to protect consumers. I think if you ask the American people, they would tell you that we want protection from government collecting all this information on us. That's our concern. And so I'd introduced a bill that would make the CFPB ask the American citizenry for permission, but I would agree with Mr. Westmoreland's bill that we're talking about today. Let the American people opt out. If they don't want the government to have this information, let them opt out. This is all about the consumer, right? This is about protecting consumers, and if we care about consumers, I think the agency charged with protecting them should empower them. Empower them to opt out of this data collection. I think this is a frightening new space that our government is going into. I think it's our duty to stand up and push back and protect the consumer. And I want to be clear to my friends across the aisle who have stood up in favor of this data collection. Listen, the CFPB is here, and the CFPB is making rules. And so I want to make sure the CFPB has good information. I'm not saying I don't want them to have any information, but we know all too well in politics that good information comes from sampling data. You can take a small sample of the whole and get a representation of the whole by only taking a little bit of information. We could do that with the CFPB, allowing them access to good information to make good rules. There is no reason why you have to take all the data, every piece of it, and so much of it. That begs the question why, and for what purpose. I think the American people, if asked and polled, the consumers in America, they would say that is too much, the government has gone too far, the CFPB has overreached, let's stop them here. And so I am in support of Mr. Westmoreland's bill as amended, and with that I would yield back to the chairman.
Gentleman yields back. Who seeks recognition? Are there any amendments to the amendment? If not, the question is agreeing on the amendment. All those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. In the amendment. The request for roll call has been withdrawn. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the amendment is agreed to. Who seeks recognition? Are there any other amendments? There being no further amendments, without objection, the previous question is ordered. The question occurs on reporting the bill as amended favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the bill as amendment is ordered. A recorded vote has been requested. Those in favor of recorded vote will raise their hand and be counted. With a little help from the chairman, a sufficient number having raised their hands, a recorded vote is ordered pursuant to subsection C5 of Rule 3 of the committee rules. The vote on this question is postponed.
Mr. Chairman, a unanimous consent to enter into the records two documents. Unanimous consent.
Without objection.
Americans for Financial Reform in opposition to H.R. 2629, 4564, and 4697. Consumer Federation of America, identical opposition. Thank you, Mr. Chairman. Yield back.
Pursuant to notice, I now call up H.R. 4262. Again, H.R. 4262 for purposes of markup, and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4262 to apply the requirements of the Federal Advisory Committee Act to the Bureau of Consumer Financial Protection. Section 1.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from Wisconsin, Mr. Duffy, the sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chairman. I think I have a bill here that can hopefully garner bipartisan support, and I'll lay my reason out for that. No, but first, what I do here, we have the Federal Advisory Committee Act, FACA. This was a sunshine law making sure that the American people had access to federal advisory committees, making sure we had access to the information and advice that was being provided to the government. And there are a couple exceptions to that law. The first was for national intelligence. The other was for the CIA. I don't think we need a great debate about why we shouldn't be exposing advisory committee meetings to the general public on those two spaces. Makes pretty good sense. But the other was a Federal Reserve. The Federal Reserve was exempt as well because of their monetary policy function. We didn't want to have that debate in the open for obvious reasons. Well, the Consumer Financial Protection Bureau is housed under the Federal Reserve, And because they're under the Federal Reserve, the CFPB has claimed that they too are exempt from FACA, that they don't have to open up their Consumer Advisory Committee meetings to the public. I think that's a far stretch. The Bureau has not been making monetary policy. The conversation that they're having and the advice they're receiving is in regard to consumer protection, which would fall most definitely under the spirit, if not the law of FACA. I had a good conversation with Director Cordray on this issue, and Director Cordray actually agreed with my legislation, or the point of my legislation, that these meetings should be open. We had a call, and he sent out a press release or a blog saying that the CFPB is now going to open up their consumer advisory meetings, which I appreciate. I've continued with my legislation, however, because the director is saying he's doing this out of goodwill, out of voluntarily doing it. He's not admitting that he's required to do so under FACA. And so this decision is at the whim of any future director, or if Director Cordray wakes up and changes his mind one morning. So I think this legislation is important to move forward to make sure there's clarity that the consumer advisory committee meetings will be open to the public. Therefore, I hope that we can get bipartisan support, especially to my Democratic friends, because Director Cordray has agreed that these meetings should be open. With that, I yield back, Mr. Chairman.
Gentleman yields back. For what purpose does the ranking member seek recognition?
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you very much, Mr. Chairman. The Federal Advisory Committee Act establishes that federal advisory committees adopt certain uniform governance measures with an emphasis on open meetings, chartering, public involvement, and reporting. The CFPB currently complies voluntarily with the Act, and as of May 20th has announced that it will make all advisory committee meetings open to the public. In response to input from industry and Congress, the Bureau has already voluntarily adopted the practices required under the Act. This confirms yet again that the Bureau is responsive to congressional oversight. And just a reminder, new advisory committees should be established only when they are determined to be central, and their numbers should be kept to the minimum necessary. So this is quite unnecessary, and I would just ask for a no vote on this bill.
Does the gentlelady yield back?
I yield back the balance of my time.
Gentlelady yields back. Who seeks for what purpose does the gentleman from Pennsylvania seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I want to commend my colleague, Mr. Duffy, for this very common sense bill. I'd heard that Mr. Duffy has attempted to sit in on a CFPB advisory board meeting and was turned away from the meeting. It makes no sense for the CFPB to close advisory meetings to the public, and especially to members of Congress. To my knowledge, they're not discussing national security secrets or the fate of the free market system. Closing advisory committee meetings are not the actions of an agency or an administration that is pledged to be the most transparent in the history of our country. I recently read that Director Cordray has seen the light and will now allow advisory committee meetings to be open to the public, and for this I commend the Director, to use the phrase, better late than never. However, Director Cordray's belated policy change does not mean that H.R. 4262 is no longer necessary, as has just been suggested. In fact, in my mind, Director Cordray's policy change should mean that passage of this bill is bipartisan. Now there are no more barriers between Democrats and Republicans agreeing on this, so let's codify it into law so that we all agree. Without Mr. Duffy's bill, there's no way to know if future CFPB directors won't go back on the policy change that Mr. Cordray has made. Consumers have a right to know what these advisory committees are working on and how they are advising the CFPB. If my colleagues support consumer protection and returning oversight of the CFPB back to consumers, then I urge them to support Mr. Duffy's bill. A vote for H.R. 4262 is a vote for transparency, and it's a vote for good government. That's why I'm voting for H.R. 4262, and I hope all members of this committee who support transparency and support good government will do the same and vote yes.
Would the gentleman yield?
I yield.
And if I could just chime in here, I think there's a lot of disagreement that happens on this committee. We're all not always on the same page. The chairman and ranking member can attest to that. But I think this is one space where, for the most part, it seems like we do agree in principle, and the director agrees. And all we're doing is making sure that, for future reference, there's clarity that these meetings are going to be open. As Mr. Fitzpatrick mentioned, we're not dealing with CIA issues, intelligence issues. We're not setting monetary policy within the CFPB. And again, as we reform and try to reform the CFPB, there will be disagreement. But good government makes sense on a bipartisan level, and I think this is one space that we can find agreement in regard to good government. Let's make sure these meetings are open, not just today, but as long as the CFPB is holding consumer advisory meetings. With that, I yield back to Mr. Fitzpatrick, who I imagine is yielding back to the chair.
The gentleman, would we yield to the chair? I thank the gentleman from Pennsylvania for yielding. I just wanted to compliment the gentleman from Wisconsin, but for his actions and interest, I'm not sure that the CFPB would have opened the doors and brought in the sunshine into these advisory committees. But Mr. Cordray, Director Cordray, has decided to do this. I commend him for coming to the conclusion that this was the right thing to do. Again, this should be the rule and not the exception, and all we're doing is simply codifying something that is now current practice of the CFPB, and but for the CIA, the Directorate of National Intelligence, and the Federal Reserve's monetary policy function, every other government agency I'm aware of has to open the doors to the public to their advisory committees. Again, it's common sense. So I want to thank the gentleman from Wisconsin for his leadership here. And I believe the gentleman from Pennsylvania yielded me his time, and I'd be happy to yield to the gentleman from North Carolina.
Thank you, Mr. Chairman. I think it's just important to note that this law would survive Mr. Cordray as director, and this law is with the agency. While I appreciate and respect the personal commitment of Mr. Cordray, we need to be mindful that this is with the agency.
Now we're happy to yield back to the gentleman from Pennsylvania. It's 32 seconds. Gentleman yields back. Who seeks recognition? Are there any amendments? If not, the question occurs on reporting the bill favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the bill is ordered reported favorably to the House. Without objection, staff is authorized to make technical and conforming changes to the bill. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 4539 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4539 to require the Bureau of Consumer Financial Protection, when issuing a research paper, to include all studies, data, and other analysis on which the paper...
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from Pennsylvania, Mr. Fitzpatrick, the sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chairman. When this administration came to power, the President committed to holding himself and his staff to a new standard of openness. And just last year, he stated that his administration was the most transparent in history. It is in the spirit of openness and transparency that I'm offering H.R. 4539, the Bureau Research Transparency Act. Simply put, this bill would make the CFPB show its work by requiring that research papers made available to the public by the Bureau be accompanied by the studies, data, and analyses on which the paper was based. A little over a year ago, the CFPB released a research paper on payday lending whose findings were called into question. There were very legitimate concerns about the Bureau's methodologies and conclusions. In response to the request for clarification and justification, lawyers for the CFPB offered assurances that the conclusions met the standards of internal review and that they were unable to share supporting data because it was gathered under their supervisory authority. Recently, Director of the CFPB, Richard Cordray, has stated that the Bureau is in the end stages of formulating a rule on payday lending. Mr. Chairman, this creates a very troubling precedent whereby a supervisory agency that has also a regulatory authority can gather data which can never be shared, issue statements which cannot be verified, and then make rules based on those conclusions without ever having to justify them. Any agency which would try to establish this model should be called into question, not the least of which one that prides itself on being data-driven. In order to ensure that none of the information that the CFPB will be required to provide by this bill includes trade secrets, materials protected by contracts, confidential supervisory information, I plan to introduce an amendment to provide that the CFPB redact any information which would also not be allowed to be disclosed for FOIA requests. Furthermore, I have heard some concerns about the burdens that might be placed on the CFPB with regard to requirements to make available this information. First of all, I think that an agency like the CFPB, or any agency for that matter, should embrace being more open and more transparent. This legislation also gives the CFPB some discretion on how to comply with the law regarding using the Internet and other technology to make their information available in a more efficient manner. I believe that this very simple bill greatly advances a goal which I believe we all share in government, one that is more open and more transparent. I hope that my colleagues on both sides of the aisle can support it, and I yield back.
The gentleman yields back. Who seeks recognition? Does the gentleman from Pennsylvania wish to offer his amendment at this time?
Where's the amendment? Offer an amendment at the desk.
We will pause for a moment and allow the manager's amendment to be distributed. The clerk will report the amendment.
Amendment offered by Mr. Fitzpatrick, page 2, line 6, insert after the...
Without objection, the amendment is considered read. The gentleman is recognized for 5 minutes to explain his amendment.
As I mentioned in my opening remarks, the amendment very simply states that the CFPB would be required to redact any data that would also be exempt for Freedom of Information Act purposes in those requests. Specifically, the amendment would provide exemptions for trade secrets and confidential business information, which is B4, information barred from release by statute, which is B3, personnel and medical files, law enforcement investigative records, and confidential supervisory information. I urge my colleagues to support it.
Gentleman yields back. Who seeks recognition? For what purpose does the ranking member seek recognition?
To strike the last word, Mr.
Gentlelady is recognized for 5 minutes.
Well, I'd like to thank Mr. Fitzpatrick for at least attempting to make this a better bill, and perhaps these amendments certainly addresses some of our concerns, not all of them. The amended bill requires that Bureau research papers are accompanied by all documents on which the research was based, except for documents that are already exempt from disclosure under the Freedom of Information Act. Consumer Financial Protection Bureau research is based on many sources of data, including confidential and supervisory information the Bureau has privileged access to, as well as private databases the agency contracts with. Under its contracts with private databases, the Bureau cannot distribute data which it does not own. This bill would force them to either breach those contracts or ignore that data when making public decisions. This functionally destroys the CFPB's ability to be a data-driven regulator. Research papers from the CFPB have been thorough and thoughtful and very useful for both industry and consumers. They have included in-depth reviews of the payday lending industry, credit bureaus, treatment of medical debt, the impact of regulation on small financial institutions, and these reports have been crucial in providing transparency into the agency's policymaking decisions and document sources which are available to the public. The Bureau has been responsive to industry requests for rule changes after careful study of the data. A few examples of the Bureau evaluating its policies include reconsidering the rule definition for balloon loans under the qualified mortgage rule, forthcoming fixes to the ability to repay rule that will give mortgage originators additional flexibility, as well as exemptions to the mortgage servicing rules for small institutions and charitable organizations. Although the Fitzpatrick Amendment does improve the bill by providing protections for confidential supervisory information, the bill still has the effect of depriving the Bureau of access to important sources of data, which would prevent them from making careful decisions and will lead to inefficient outcomes that are bad for banks and consumers. I suppose what I have concluded working with the Consumer Financial Protection Bureau is that Mr. Cordray has been extremely cooperative, and he has been willing to modify decisions, to change decisions, and to recognize when we have concerns. This just goes too far, and it will tie his hands in trying to have the kind of data that will be helpful to all of the consumers that we care about. So I would ask for a no vote on this amended version of the bill.
Gentlelady, yield back.
Yield back the balance of my time.
Who seeks recognition? For what purpose does the gentleman from Indiana seek recognition?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I speak on behalf of my friend Mr. Fitzpatrick's legislation, H.R. 4539, as amended. Mr. Fitzpatrick's simple bill addresses an important and curious accountability gap at the CFPB. Traditionally, when experts publish their analysis of an issue, the authors also publish the data and the methodology they used to support their conclusions. In this way, the validity of their conclusions can be judged by the public and other experts in their field. For some reason, this is not the case for experts at the CFPB. Experts at the CFPB do not show their work when publishing white papers, just as they do not show their work when publishing guidance that can be as heavy-handed as a formal rule. The Bureau's refusal of simple transparency is undermining citizens' confidence in the government. It is likewise undermining the ability of stakeholders in regulated industries to trust their regulators are acting with integrity. This simple legislation is an easy fix to a very important problem. So I thank Mr. Fitzpatrick for this legislation, and I urge my colleagues to support this simple, common-sense piece of legislation. I'll yield back.
The gentleman yield to the chair?
Yes.
I thank the gentleman for yielding. I, too, wish to urge all of my colleagues to support the gentleman from Pennsylvania, both his amendment and the underlying bill. Again, the CFPB is very fond of saying that they are a data-driven organization. Then they shouldn't have a problem in sharing their data, which clearly they do. We, in fact, members of both sides of the aisle have raised concerns with respect to their work and indirect auto lending. We are still trying to seek answers in regards there. This is a very simple amendment. Again, let's have some sunshine here. If the data is so good, if it drives these policies, then why is the agency so reluctant to share this data? Particularly the manager's amendment, any concerns there were about proprietary information or personal information, that's all been taken care of by the manager's amendment. And so it's kind of put up or shut up time. If the data is leading to these policies, let's see the data. And in fact, concerns have been shown before, and I believe it was on March 1st earlier this year, the CFPB supplemented its white paper on payday lending which kind of suggested, in response, I think, to information submitted by the CFSA and others, which was kind of a tacit admission that maybe the methodology that they employed was faulty. And so I think it's something that, frankly, could benefit the CFPB if they would simply be more transparent. They could actually do the job better. So again, I believe this is an incredibly important piece of legislation brought by the gentleman of Pennsylvania. I urge all my colleagues to support the manager's amendment and the underlying legislation. I thank the gentleman from Indiana for yielding to the chair. Gentleman yield back.
Mr. Chairman, if I could just add to that, I agree with your comments. And if I could say that transparency and sharing that information with those folks in the private sector and those that they would regulate will bring a better product at the end of the day for not only for CFPB, but also for all parties involved. It can be very frustrating for a lot of these folks who feel like they're shooting in the dark and trying to comply, but they don't know where the decisions that are being made by the CFPB are coming from. And so I really appreciate this particular bill and would ask my colleagues to support it simply for the fact that I think the product at the end of the day would be better and that both parties would benefit from this exercise. So with that, Mr. Chairman, I'll yield back.
Gentleman yields back. Who seeks recognition? Are there any amendments to the amendment? If not, the question is agreeing to the amendment. All those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the amendment is agreed to. Are there any further amendments? There being no further amendments, without objection, the previous question is ordered. The question occurs on reporting the bill as amended favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. A recorded vote has been requested. Those in favor of a recorded vote will raise their hand and be counted. A sufficient number having raised their hand at the snap of the finger of the ranking member, a recorded vote is ordered. Pursuant to subsection C5 of Rule 3 of the committee rules, the vote on this question is postponed. Pursuant to notice, I now call up H.R. 3770 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 3770 to require Senate confirmation of Inspector General of the Bureau of Consumer Financial Protection and for other purposes. Section 1, short title. This act may be cited as the Bureau of Consumer Financial Protection Inspector General.
Without objection, the bill is considered as read. The gentleman is recognized for 5 minutes to explain his bill.
Thank you, Mr. Chairman. I'll be brief. This is common sense legislation that would bring the CFPB under the same congressional oversight as other financial regulators. Over 30 agencies, departments, and commissions have their own presidentially appointed and Senate-confirmed Inspector General, and the CFPB should be no different. The bill does not increase government spending, but dedicates existing CFPB funding to the Inspector General. I believe it's important for the CFPB to have its own Inspector General because today they use the Federal Reserve's Inspector General, but the Federal Reserve has one mission, the CFPB has another mission. It's important for the Inspector General to be deeply involved with the agency, understand the mission, and work not only to give oversight, but to give informal, independent advice to the decision makers at the agency. This bill, I think, would improve accountability of the newly created agency that now has 1,300 people and is growing in size and scope and regulatory scope. One of the witnesses at our hearing said that because the agency is new, the benefit of an independent Inspector General would be that they could give independent advice and give oversight to avoid or to keep bad practices from being institutionalized in this infant agency. So I think it's critical that the Bureau be held to the same standard of transparency and accountability as other agencies. And for those that believe the current Inspector General that is under the Fed is okay to service the CFPB, I do want to note that the Fed's Inspector General has done 15 reports. Actually, I think it's 16 now. But as of the last report to the Oversight Committee, they had done 15 reports. And on those 15 reports, they had 35 delays with regard to the CFPB. I don't find that acceptable, and I think an independent, presidentially appointed, and Senate-confirmed Inspector General that is focused on the CFPB will be able to meet their own work plans. These aren't dates that somebody else set for them that they missed 35 times. These are their own dates that they had to move 35 times on just 15 reports. So that tells me the status quo is not working. I would urge my colleagues to support this bipartisan bill, and I hope that we can work together if there are any issues. I yield back the balance of my time, Mr. Chairman.
Gentleman yields back. Who seeks recognition? For what purposes the ranking member seek recognition? Gentlelady is recognized for 5 minutes.
Mr. Chairman and members, this bill would amend the Dodd-Frank Act by replacing the CFPB's current Inspector General, who shares responsibility for overseeing the Board of Governors of the Federal Reserve System and the Bureau, with the Senate-confirmed IG exclusively dedicated to overseeing the Bureau. I have an amendment that I will offer, which will eliminate the requirement that the IG be confirmed by the Senate. I believe that the Bureau is already subject to robust oversight, both with its Inspector General and its many visits to this committee. The current FRB and CFPB Office of Inspector General has over 20 years of experience conducting audits within the Federal Reserve System. Since adding the Bureau to its responsibilities, the OIG has also increased the number of staff accordingly, from roughly 45 employees just prior to the establishment of the Bureau to more than 100 staff today. The shared Federal Reserve and CFPB-IG restructure is consistent with the shared IG structure of the IG for the Treasury and the OCC. The current OIG has written to members on several occasions to highlight its extensive oversight of the Bureau and to express the view that the legislation offered by Representative Duffy is unnecessary, and there is no evidence that the existing IG structure is inadequate. GAO has recognized that in some cases a shared IG among agencies with similar missions can be cost-effective and means of enhancing IG oversight by leveraging staff expertise and technical skills. Now, even though the current Inspector General has been doing an admirable job, I'm not opposed to the CFPB having its own IG. However, of course, as I said, I will be offering an amendment because I do not believe that the IG should be subject to Senate confirmation. Given the politically motivated opposition in the Senate appointing a director at the CFPB, it may be impossible for the President to find someone who can be confirmed in just 60 days. Requiring Senate confirmation is an unnecessary hurdle that would jeopardize Bureau oversight. Although the FDIC and FHFA, which both manage large taxpayer guarantees, have independent Senate-confirmed IGs. This is not the case for other financial regulatory agencies. IGs at the NCUA, SEC, CFTC, and Federal Reserve are not subject to Senate confirmation. Many important agencies such as the Farm Credit Administration, Federal Trade Commission, U.S. International Trade Commission, Federal Communications Commission, and Federal Elections Commission, among others, do not have Senate-confirmed IGs. With that, I would oppose this legislation unless, of course, my amendment would be accepted, so I will yield back the balance of my time.
So did the gentlelady yield back? Gentlelady yields back. Who seeks recognition? For what purposes does gentlelady from Missouri seek recognition?
I move to strike the last word, Mr. Chairman.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to express my support for H.R. 3770, the Consumer Financial Protection Bureau Inspector General Act of 2013. And I thank Mr. Stivers for introducing this important piece of legislation to protect our taxpayers. I'm a proud co-sponsor of this bill, which would create a separate independent Inspector General to oversee the CFPB. A dedicated independent IG is vital for agency accountability. Unfortunately, under the current structure, two very different agencies, the Federal Reserve and the CFPB, share a single Inspector General. This is highly unusual and creates a situation where the current Fed IG is stretched too thin and is unable to provide comprehensive oversight to the CFPB. Arguably, the CFPB should have greater oversight than other regulators because it is exempted from the congressional appropriations process and therefore has greater autonomy, too much autonomy, in fact. Given this higher level of independence and lack of accountability, it doesn't make sense that the CFPB should be one of the only financial regulators without an independent IG. A dedicated IG would protect taxpayers and give the public greater confidence in the CFPB's policies, research, and rules. Enhanced transparency and accountability are the hallmarks of good government, which is one reason why this bill enjoys bipartisan support. In fact, the concern that the Fed IG is stretched too thin under the current structure has turned out to be well-founded based on two recent hearings by the Financial Services Oversight and Investigations Subcommittee. During these hearings, the committee investigated allegations of discrimination and retaliation against the CFPB employees. We found the CFPB leadership was aware of potential issues with discrimination as early as September 30th, 2013, when the Deloitte consulting study conducted at the request of the CFPB concluded that there were broad-based pay disparities based on race and gender. Yet, when I questioned the lead of employee relations for the Office of Human Capital at the CFPB, she said she was, and I quote, unaware of the study, even though it had been 8 months since the study was completed. In addition to some members of CFPB management being kept in the dark about these problems, the Inspector General was also noticeably absent from our hearings. Despite red flags, it would appear that the Inspector General was unaware of the issue and did nothing to investigate the allegations of discrimination. There is also no evidence that the CFPB's leadership notified the IG when it discovered widespread discrimination. Last month, CFPB Director Cordray finally admitted that there were broad-based disparities among employee evaluations based on race and gender. He agreed to retroactively pay millions in remedies to the affected employees. Yet even after his admission, the IG has still failed to take meaningful steps to recommend remedial action. This incident provides an excellent example of why the current IG structure is not working. It is clear that an agency as young and unaccountable as the CFPB needs a dedicated Inspector General to conduct rigorous oversight and prevent these types of abuses in the future. I hope my colleagues will join me in supporting H.R. 3770, the CFPB Inspector General Act. I thank you, Mr. Chairman, and I yield back.
Generally, it yields back. Who seeks recognition? For what purpose does the ranking member seek recognition?
To strike the last word. I have an amendment at the desk.
We'll pause for a moment and allow the amendment to be distributed. Any member has not received the amendment? The clerk will report the amendment.
Amendment offered by Ms. Waters, page 2, strike line.
Without objection, the amendment is considered read. The gentlelady is recognized for 5 minutes to explain her amendment.
Thank you very much. Mr. Chairman and members, as I indicated when I first offered comments about the legislation, I'm not opposed to the CFPB having its own IG. However, I do not believe that the IG should be subject to Senate confirmation. For all of the reasons that I indicated, we've gone through a pretty difficult time as we dealt with the politics of having a director for the CFPB appointed. And I certainly don't think that the President could find someone who could be confirmed in 60 days. And so I would ask this committee to join with me in supporting the idea of the Inspector General being singularly responsible for the CFPB without having to go through Senate confirmation. To tell you the truth, I'm very pleased about some of the reasons that this bill is being proposed. And when the gentlelady from Missouri cites the discrimination and the problems that have been going on in the CFPB, ones that are this committee still will be dealing with, and possibly others, employees of the CFPB will be subpoenaed, or subpoenaed will be offered to bring them before us to talk about the inconsistency in the way that employees are reviewed. So I support the idea of a strong IG, and I think that in addition to some of the concerns that have been addressed by others, I'm pleased to join with the lady from Missouri, the gentle lady from Missouri, in saying that any questions about exclusion, about discrimination, about treating employees differently that we need to deal with, and that the IG can help us to deal with, I'm supportive of that. And so let us join together for a strong Inspector General dedicated solely to the Consumer Financial Protection Bureau, and let's not put obstacles in the way of getting this done by saying that this IG would have to be confirmed by the Senate. That would only prolong the possibility. That would only complicate the situation. So I would ask that you support my amendment, and I yield back the balance of my time.
Gentlelady yields back. Who seeks? For what purpose does the gentleman from Ohio seek recognition?
Mr. Chairman, I move to strike the last word and address the amendment.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I was just, I didn't know about this amendment till this morning or till this afternoon, but I did get a copy and looked at it and did a little bit of research. So there are 73 agencies that have inspector generals, approximately about 30 each are appointed, between 30 and 40 each are appointed by the president, and then the same that are appointed by the actual agency. Of the ones that are appointed by the president and confirmed include Treasury, HUD, Ex-Im Bank, and FHFA, where there's an individual head to the organization. The ones that are appointed by the agency, I think without exception, and I'll name some of them, the Fed, the CFTC, the CPSC, the FTC, and the NCUA are all boards. So there's already a means for some type of minority opinion and working out issues and having issues discussed. And I'm not trying to throw your amendment out or oppose your amendment at first blush. I'm trying to be thoughtful here, but the thing that keeps hitting me is that in agencies that are headed by one individual, in almost every case, they have the president appointing and a Senate confirmation in order to make sure that it's a strong, independent inspector general. And I think that's really important here, especially given some of the issues that the gentlelady from Missouri brought up and the 15 reports they've already done. You know, they were on some pretty serious conflict of interests, some or allegations of conflict of interest, allegations that people use their official position to then later on line their own pockets. And those were pretty serious. Some of them were very serious allegations. So I appreciate that the gentlelady from California is willing to support a inspector general for the CFPB by themselves, which is really important, and I really appreciate that. And I just think it's really important that we give that inspector general independence, because one of the witnesses really talked about how giving that independent advice and oversight is really important. And while certainly somebody that the head of the agency picks would be trusted by the head of the agency, I think somebody that has a presidential appointment, and I find myself in the interesting position of being for the president's power when the ranking member's against the president's power right now. But, you know, if I could, you know, split the baby and say the president would appoint but the Senate wouldn't confirm, I could do that, but I don't think that's constitutional. So I don't think we can go there, but I do believe that having a presidential appointment and having some real independence is important. So unfortunately, I think I'm going to have to oppose the gentlelady's amendment.
The gentleman yield.
I will.
I thank the
Whoever-
gentleman.
yes, to the will, yes.
I thank the gentleman, and I want to, piggyback on your remarks because one of the things that I think a lot of us are very concerned about is the lack of independence of this agency, and really the lack of the ability for Congress to oversee this agency. And so I think independence and some additional structure there to ensure that that there is appropriate oversight is very important. So I would unfortunately not support this amendment and support the underlying bill that calls for a presidential nomination and consent.
Thank you. I yield back.
Would the gentleman yield to the chair?
I will yield, yes.
Oh, to the chair.
I thank the gentleman for yielding, and I want to thank him for bringing this bill before the committee. Again, the question before us is, should we have an independent IG for the CFPB, and if so, should that IG be appointed by the President or appointed by the head of CFPB? Again, whether you believe in all what the agency is doing or not, it's hard to avoid the conclusion that it is a historically unaccountable and unique agency. Again, it's unaccountable to the President, and that the President can only remove the Director for cause, unaccountable to Congress since it's off budget, uniquely unaccountable to the courts since their pronouncements on consumer law are subject to the Chevron doctrine. And then the agency is uniquely unaccountable to themselves because there's not a them, there's a he. There is one director, and as the gentleman, the author of the underlying legislation, has pointed out, particularly where there is a sole director, we almost always have an independently appointed IG. And so I would urge a no vote on the ranking member's amendment and an aye vote on the gentleman from Ohio's bill. Gentleman's time has expired. Who seeks recognition? Are there any amendments to the amendment? If not, the question is, agreeing to the amendment, all in favor say aye. Those opposed say nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it. In the amendment, a recorded vote has been requested. Those in favor of a recorded vote will raise their hand and be counted, a sufficient number having raised their hands. A recorded vote is ordered pursuant to subsection C5 of Rule 3 of the committee rules. The vote on this question is postponed. Are there further amendments? There being no further amendments, without objection, the previous question is ordered. Pursuant to notice, I now call up H.R. 4804 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4804 to amend the Consumer Financial Protection Act of 2010.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from South Carolina, Mr. Mulvaney, the sponsor of the legislation, for 5 minutes.
I thank the chairman and the committee for the opportunity for discussing and bringing forward today the Bureau Examination Fairness Act. This legislation will codify certain practices that are already in place at the Consumer Financial Protection Bureau regarding supervisory examinations, and also tend to bring some clarity to some other parts of their examination process. Dodd-Frank conferred supervisory authority to the CFPB for depository and certain non-depository institutions. As part of that authority, the CFPB conducts examinations of these institutions and issues recommendations, letters, and reports of their findings. Despite the CFPB's best efforts to provide examiners with information about the examinations process and timelines for major examination milestones, the Inspector General and the supervised institutions have identified a number of concerns, and the bill seeks to address 3 of those, as we discussed in the hearing several weeks ago. Number 1, the bill would codify the CFPB's own policy prohibiting enforcement attorney ride-alongs on examinations. The IG raised independent and industry concerns with this practice last year, and around the same time the CFPB announced it would end the practice on its own. As the CFPB has already chosen to implement this practice, I hope we can agree that it's a good practice going forward and have no objection to codifying it. Simply prohibiting the enforcement attorneys at examinations will not prevent these attorneys and examiners from working together. It simply will make sure that the presence of an attorney doesn't turn a non-adversarial review into an adversarial one. Secondly, The CFPB has set internal timelines for examinations, 65 days for the issuance of supervisory letters and reports for non-depository institutions, and 110 days for reports for depository institutions, 65 and 110. Despite these goals, the IG found that some examinations have been outstanding for over a year, and the number of examinations outstanding for longer than 90 days has grown from just 1 in 2011 to over 100 in 2013. Further, the IG's report found that CFPB was not meeting its own internal timelines, with 90% of the drafts that received approval from headquarters missing the timeliness requirements. The IG found the CFPB's inability to provide reports to institutions in a timely manner creates uncertainty for those institutions. To address this, the bill codifies timelines for examinations and reports: 60 days for completion of examination fieldwork, and 120 days for the issuance of the final report, with a one-time 180-day extension possible to cover extenuating circumstances. These deadlines will provide us and Congress with an opportunity for oversight, and the CFPB with an incentive to close out those examinations. Finally, the bill clarifies that only one limited scope examination should be conducted on a single entity at a time, and clarifies what data can be requested for an examination. Supervised institutions have expressed concern about unfocused examinations lacking in identifiable scope. To help address the data request and the burdens of data requests and the costs faced by the institutions, the legislation would require, number one, coordination between the CFPB's various divisions before data is requested. Number two, that the CFPB identify the intended use of the requested data. Number three, the CFPB would request the data samples instead of full sets, unless the director determines that a full set is needed. And finally, will require director approval of any data request that would actually cost more than $50,000 to do. These three changes taken together will significantly improve the CFPB's examination process and give greater clarity as to examinations on both supervised institutions and for Congress. Thank you again, Mr. Chairman, for the opportunity. I look forward to discussing that. With that, I yield the balance of my time to the Chair.
The gentleman yields back. Who seeks recognition? For what purpose does the ranking member seek recognition?
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Mr. Chairman and members, this bill sets deadlines for the completion of CFPB examination, bars enforcement attorneys from accompanying supervisory teams during examinations, and creates additional bureaucratic burdens on the director with regard to data collection. First, it is important to remember that the CFPB does not have the authority to perform examinations at banks with less than $10 billion in assets. This is not about helping small banks or small businesses. So let's just get that clear right now. In response to industry concerns, Director Cordray is no longer sending enforcement attorneys along with examination teams by default. However, the Bureau should be afforded the discretion to send enforcement attorneys at times when it's appropriate. For example, if the institution has had compliance issues in the past, this bill would bar the Bureau from doing so. The bill also sets arbitrary deadlines for the Bureau to complete examinations and issue reports on large, complex financial institutions, and prevents the CFPB from performing multiple examinations concurrently, while also requiring the director to personally weigh on certain data requests during examinations. All of these proposals taken together impede the Bureau's work and leave the consumers at risk. The Bureau has the expertise to determine supervisory policy and has consistently demonstrated its willingness to be responsive to industry concerns. They have earned the right to determine their examination policies, just like the other banking regulators. And so, Mr. Chairman and members, I'm really concerned about the direction of this committee as it relates to our oversight responsibility, and whether or not we are doing the kind of oversight that would ensure safety and soundness, or whether or not we're undermining the ability for our institutions to be safe and sound. I am very concerned that as I have worked in this committee today, where we have been supporting waivers and we have been taking other actions that basically put investors at risk, et cetera, that this is one more attempt to tie the hands of the Consumer Financial Protection Bureau. And really, this is quite dangerous. I would ask that the members not support this legislation. I'll yield back the balance of my time.
Gentlelady yields back. Who seeks recognition? I'm sorry, the gentleman from Indiana. For what purpose does the gentleman from Indiana seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Yield to the gentleman from South Carolina.
And I thank the gentleman. Just a few things in response to the ranking member's comments. She went down the list, and I think that's the right way to look at the bill. It sets deadlines. Yes, it sets deadlines. What's wrong with that? Taxpayers have deadlines. Companies participating in government oversight have deadlines. We have deadlines. Why can't the government bureaucracy have some deadlines as well? And when we set the deadlines in the bill, we didn't go out and pick a deadline and make it 25% of what the agency was already doing. We tried to stick to basically what the CFPB said they wanted to do anyway. But there's nothing wrong with putting deadlines on the government when it's overseeing taxpayers. Regarding the ride-alongs with the attorneys, yes, it takes discretion away from the CFPB. Two things about that. Number one, the CFPB has already, in its discretion, said that this is not a good thing, that it impairs their ability to do their job because it turns non-adversarial relationships and investigations into adversarial relationships. But generally speaking, as taking away discretion from an agency and giving it to Congress, it strikes me that that would generally be a good thing. As between an agency that doesn't get appropriations from us, doesn't answer to us, only has minor oversight responsibilities or accountability to us, what's wrong with taking some of the discretion away from the organization and putting it here in this particular body? Finally, the ranking member mentioned, for example, on the fact that it puts additional bureaucratic burdens on the director by having to identify which ones would qualify for $50,000, have to be full examinations, partial examinations. I think we have a basic misunderstanding as to what a bureaucratic burden is. Making the director Cordray do his job is not a bureaucratic burden. A bureaucratic burden is what we have to do when we deal with a bureaucracy. So the red tape that the taxpayers have to go through, that's a bureaucratic burden. Having an agency do its job is not a bureaucratic burden, that's just life. So I hear what you're saying. Yes, it does require the director to do a little bit more work, but by doing that little more work, we actually relieve some of the bureaucratic burden from the taxpayers. And it strikes me that in the general sense of things, that's not a bad thing. So yes, we take a little bit of the burden and move it on to the guy that gets paid to do the job and has the nice office, and takes the burden off of the taxpayer that's paying for that guy and paying for his nice office. And it seems to me that that would be something that might be generally acceptable to more than just Republicans. With that, I yield back the balance of my time to the gentleman from Indiana.
Would the gentleman yield to the chair?
Yield to the chair.
I thank the gentleman for yielding. I listened carefully to the ranking member who showed concerns about our activities actually impeding oversight of the CFPB, but yet I have heard nothing from my friends on this side of the aisle but saying that we somehow should have less data, that somehow the public should be frozen out of attending sessions of advisory committees. I've heard nothing that would empower the people's elected representatives to actually engage in more oversight. And we keep on hearing the refrain about how important it is to protect consumers, but yet we don't have support if consumers want to opt out of having their personal financial information collected by the CFPB. And so, yes, this is an agency that should be held accountable. We were just debating an independent IG already. We've had reports from the IG that the practice of including enforcement attorneys in examinations, they were highly, highly critical of that practice. In March of this year, the IG released a report critical of CFPB's supervisory activities, again, evaluating their efficiency and effectiveness. They found that, again, as the gentleman from South Carolina reported, several of the examinations have been outstanding for more than a year. A number of examinations outstanding for longer than 90 days. If we don't hold this agency accountable, no one will. We have had testimony from the U.S. Chamber that this continued uncertainty and inefficiency puts unjustified cost on legitimate businesses seeking to comply with the law, directly constrains their lending, especially to small businesses that our economy desperately needs in order to grow and create jobs for the millions of Americans who remain unemployed. I couldn't say it any better myself, and so I would urge all members to support the legislation of the gentleman from South Carolina. Who seeks recognition? Are there any amendments? If there are no amendments, the question occurs on reporting the bill favorably to the House. Those in favor say aye. Aye. Those opposed say nay. Nay. In the opinion of the Chair, the ayes appear to have it. The ayes have it, and the bill is ordered. A recorded vote has been requested. Those in favor of a recorded vote will raise their hand and be counted. The sufficient number having raised their hands, a recorded vote is ordered. Pursuant to subsection C5 of Rule 3 of the committee rules, the vote on this question is postponed. Pursuant to notice, I now call up H.R. 4383 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4383 to amend the Consumer Financial Protection Act of 2010 to establish a small business advisory board and for other purposes. Section 1, short.
Without objection, the bill is considered read and open to amendment at any point. The Chair recognizes the gentleman from North Carolina, Mr. Pittenger, the sponsor of the legislation, to offer a manager's amendment.
I move to strike the last word. Mr. Chairman, thank you for holding this markup today and for adding H.R. 43.
I'm sorry, does the gentleman have an amendment at the desk,
Yes.
a manager's amendment at the desk?
Manager's amendment.
Okay, we will pause for a moment and have the manager's amendment distributed. Apparently, it has already been distributed. Is there any member who does not have a copy of the manager's amendment? If not, the clerk will report.
Amendment in the nature of a substitute offered by Mr. Pittenger. Strike all after the enacting clause and insert the following. Section 1, short title. This act may...
Without objection, the amendment is considered read and will serve as the base text for purposes of markup. The gentleman from North Carolina is recognized for 5 minutes in support of his manager's amendment.
Thank you, Mr. Chairman. I move to strike the last word. Thank you for holding this important markup today and adding H.R. 4383, the Bureau of Consumer Financial Protection Small Business Advisory Board Act, to the docket. As the Consumer Financial Protection Board works to promulgate and implement new regulations affecting the American economy, it is vital that small businesses within the financial services sector have a seat at the table to voice their opinion. Small businesses comprise 70% of the jobs in this country, yet they have no voice at the table of the CFPB. The QM rule, for example, which went into effect in January of this year, is having a devastating effect on financial institutions that relate to small businesses, as there was no voice for them at the table during the time of its consideration for implementation. That is why I have joined with Congressman Denny Heck to establish a small business advisory board within the CFPB. The mission of this board will be to advise and consult with the CFPB on any new regulations coming forward and their effect on the small business community. The CFPB Small Business Advisory Board will consist of at least 15 members, but not more than 20 from the financial service community and related businesses, and will be appointed by the CFPB Director. In order to be selected to serve on the board, members must represent a small business dealing with financial service products and related businesses. Today, I will also be offering an amendment to the nature of a substitute, H.R. 4383. The purpose of the amendment and the nature of a substitute is to codify the Credit Union Advisory Council and the Community Bank Advisory Council into law. It will also cover the travel expenses for their members. Currently, the charters for these councils are in the place for at least 2 years, but the Director has the capabilities to extend the charter if necessary. Under the ANS, the Council will meet at least 2 times a year at the discretion of the director. There will have to be at least 15 members on each council, but no more than 20. This amendment will permanently allow industry representatives from community banks and credit unions to have a voice within the CFPB. We have all witnessed over the last few years on how rules and regulations have affected smaller financial institutions, and codifying these councils into law is the common sense thing to do. This amendment and the overall bill are strongly supported by CUNA, ICBA, Chamber of Commerce, American Land Title Association, and the American Bankers Association. This is a bipartisan, common sense piece of legislation that all members should support, and I thank my good friend Congressman Heck again for his strong support. I yield back the balance of my time.
Gentleman yields back the balance of his time. For what purpose? The gentleman from Washington seek recognition.
Move to strike last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. I also want to take this opportunity to compliment my friend from North Carolina. I actually like the underlying bill, and I like the manager's amendment as well. I think consistency with the size of the other two advisory boards is appropriate, especially given a little bit more diversity of the number of voices that need to be heard from. I do want to make the point, however, that as we increase from the underlying bill to the manager's amendment from 12 to 15 to 20, that it would be my hope that at least 12 of the new, under the manager's amendment, 15 to 20, would be appointed from the original targets of the non-bank, non-credit union financial institutions to ensure that those voices of that community, of those businesses that are directly regulated by CFPB, especially have seats at the table to be heard from. I think increasing the size will allow for the presence of other voices who are indirectly affected, but I would hope that that the agency and the prime sponsor's intent would be to ensure that the original targets would be so represented. And at this time, I would yield to you, sir.
Mr. Heck, I concur in total. We have worked closely together, and I believe that your interest will be met with this bill.
I thank you, sir, and encourage the members of the committee to support the manager's amendment. I yield back the balance of my time.
Sorry, the gentleman yield back?
I did.
Who seeks recognition? For what purpose does the ranking member seek recognition?
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. The amended version of H.R. 4383 requires the CFPB to establish a new Small Business Advisory Board and codifies the existing Credit Union Advisory Council and Community Bank Advisory Council, which were both voluntarily established by the CFPB. So the CFPB have not ignored the need for small business input, particularly the Community Bank Advisory Council and other. They voluntarily supported the inclusion of these entities. I believe that the Bureau, and especially Director Cordray, have done exemplary work reaching out to small businesses and proactively addressing their concerns. The Bureau conducts extensive outreach as part of its regulatory process, and it's one of the few agencies subject to SBREFA, which requires the Bureau to have its rules reviewed by small businesses before they are finalized. However, this bipartisan bill could have the benefit of providing additional channels of communication among the Bureau and small businesses. As small businesses are crucial to job creation and economic growth, I support efforts to increase opportunities for dialogue with the Bureau. I hope that in establishing the Small Business Advisory Committee, that the Bureau will focus on small businesses that issued consumer financial products and services whose input they would benefit from the most. As we have said on this side of the aisle, we have no problems with joining in with the opposite side of the aisle to improve the Bureau wherever we think it can be strengthened. We have, of course, opposed efforts to dismantle or to cause the Bureau not to be able to honor its mission. by complicating the ability for it to exercise its authority. This is an example of where we can cooperate and where we agree that this would be helpful. And so while I do have an amendment that I will offer that would make it even stronger, I support this bill and would ask our members to support the amended version.
Mr. Chairman.
Gentlelady yields back. Who seeks
Mr. Chairman.
recognition? For what purpose does the gentleman from Georgia seek recognition?
I have an amendment at the desk.
Is it an amendment to the amendment? Because we're still
It's an
debating
amendment to the amendment in the nature of a substitute.
Maybe I think I better go first. If Mr. Scott will allow me, I'll take up mine first, and then I'll have you follow. I think it would make better coordination that way. I have an
In that
amendment
case,
at the
for
desk.
what purpose does the ranking member seek recognition?
I have an amendment at the desk.
We will pause for a moment and allow the amendment to be distributed.
This is it.
Clearly, after a sidebar discussion with the ranking member, we would instead prefer to go and recognize the gentleman from Georgia and now take up his amendment first, if that's satisfactory. In that case, the ranking member just gave an affirmative answer on your behalf. So the gentleman from Georgia has an amendment at the desk.
Yes.
Is this correct?
Yes, I do.
We will pause for a moment and allow the amendment of the gentleman from Georgia. The gentleman from Georgia's amendment will be distributed, and that is the amendment that will be considered now. We will pause and allow the amendment to be distributed. Both sides are working on some language with regards to both of these amendments. The chair is about to declare a recess. I anticipate we will come back into session in approximately 10 to 15 minutes. The committee stands in recess.
That's fine. Where's our new language? Are they reproducing it?
Yeah, they're making copies right now.
The committee will come to order. We had two amendments that had been offered. Neither had been reported by the clerk. By unanimous consent, those two amendments have been withdrawn. For what purpose does the ranking member seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment offered by Ms. Waters. Page 2, after line 22, insert C. In appointing members pursuant to subparagraph A, the director is encouraged to ensure the participation of minority and women-owned small businesses concerns and interests without regard to party affiliation. Page 3, at the end of line 11, insert. In appointing such members, the director is encouraged to ensure the participation of credit unions predominantly serving traditionally underserved communities and populations and their interests without regard to party affiliation. Page 3, at the end of line 25, insert. In appointing such members, the director is encouraged to ensure the participation of community banks predominantly serving traditionally underserved communities and populations and their interests without regard to party affiliation.
The gentlelady is recognized for 5 minutes to explain her amendment.
Mr. Chairman and members, I think just as the amendment has been read, that's precisely what we are advocating, that we have the opportunity to encourage participation in these three ways with businesses, small businesses, credit unions, and community banks. This basically describes the kind of people that we think would fit what we're trying to do, and they would be experts in the business that they're in, and they would be able to identify the kind of people that would help to have the kind of input that would ensure that good decisions are being made and that all people have opportunities here to be heard. So I would ask an aye vote on this amendment.
Gentlelady yields back. The chair will recognize himself for 5 minutes. The gentlelady's amendment, an important one. I think that we occasionally struggle in Congress, as we do in our society, to ensure that we are being inclusive without mandating quotas and set-asides, to ensure that populations that have been historically underrepresented are indeed included, that all Americans are accorded equal opportunity, that none are discriminated against, obviously based upon the suspect classifications that have been defined for 2 or 3 generations within our society. So I thank the committee for their patience, for the break that we took, but I believe the majority and minority sides have a mutual understanding of what is attempted by this amendment, and I think that we have mutually acceptable language, and I would encourage members to adopt the amendment by the ranking member. I yield back the balance of my time. Who seeks recognition? Are there amendments to the amendment? If not,
Yes, Mr. Oh.
okay. For what purpose does the gentleman from Georgia seek recognition?
Yes, Mr. Chairman, for two purposes, I have an amendment to the amendment in the nature of a substitute to H.R. 4383, and I also would like to enter a colloquy with you once if that's the appropriate.
So if I understand right, the gentleman has an amendment to the underlying amendment, Mr. Pittenger's amendment. We still are debating the ranking member's amendment. Are you trying to amend her amendment, or are you trying to are you trying to amend the gentleman from North Carolina's amendment? Oh, that's it. If we could dispense with the gentlelady's amendment first.
I was a little
okay. So the gentleman yields back, as I understand.
I yield back.
So again, we are debating the amendment of the ranking member who seeks recognition. Are there any amendments to the amendment? If not, the question is on agreeing to the amendment. All those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. The amendment is agreed to. Now, for what purpose does the gentleman from Georgia seek recognition?
Yes, Mr. Chairman, as I said, I do have an amendment to the amendment in the nature of a substitute to H.R. 4383 at the desk, and after going through it for a moment, then I'd like to enter a colloquy with you.
We will pause for a moment and allow the gentleman's amendment to be distributed. Okay. The amendment apparently has been distributed. Is there any member who does not have the amendment? If so, the clerk will report.
Amendment offered by Mr. Scott, page 4, after line 18, insert the following.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you very much, Mr. Chairman, and I certainly appreciate you and your time in working with us on this very important amendment to this very strong bipartisan piece of legislation. My amendment just simply directs the director of the CFPB to appoint another voluntary council created by the CFPB, which is called the Academic Research Council, as members to the maximum extent possible who represent historically black colleges and universities, who also represent Hispanic-serving institutions, who also represent women's colleges and other institutions of higher education for traditionally underserved populations. I believe it is important that the CFPB hear directly from these institutions that serve such an important purpose of educating young people of color and women on all of different diversities. The Academic Research Council was voluntarily convened by the CFPB, and I do not wish to mandate its existing in perpetuity. Since the Manager's Amendment codifies the other 3 advisory councils voluntarily created by the CFPB, and the ranking member, Ms. Waters' amendment, directs the director to include members representing diverse views on them, I simply thought it also made good sense to include a similar instruction to the director for the Academic Research Council. This is the reason that I have drafted the amendment in such a way that simply directs the director to work towards including diverse representation on the council only for as long as the council remains active with the CFPB. Codifying it adds texture and it increases the CFPB and it puts diverse members on it. And as you pointed out, Mr. Chairman, it is not codified, but I'd like to just enter colloquy with you that as we move with this, we don't want to lose the opportunity of having this as a part of the main bill as it's going to pass the House and move to the Senate. And I think that you have agreed to work with me and certainly Mr. Lynch and our side in perhaps making sure we get it connected and codified at the Rules Committee so it will be ready as it goes on the floor for full debate.
Would the gentleman yield?
Yes.
Indeed, this particular council has not been codified into statute as yet, so as you and I discussed during the recess, I do not believe that at this moment that this is ripe, but I would say again, it is important that all Americans are accorded equal opportunity under the law, that again, the academic institutions of which you allude, it is important that their views be heard, their views be represented. And so I would tell the gentleman from Georgia, at some point I would hope and expect these matters would go to the floor. I would further expect further markups, and I would either, one, speak to others to ensure that at the appropriate time that the gentleman be accorded the opportunity to codify the Academic Research Council into statute if that is his wish, and then to ensure the language or the concept that he's trying to get at to is included. If for some reason that opportunity does not exist, we'll assure that the opportunity exists in a future markup so the gentleman can codify this into statute and move forward on what he's attempting to do in this amendment. And so if the gentleman would be willing to withdraw his amendment at this time, I'd be happy to work with him on two different tracks.
Well, I certainly appreciate it, Mr. Chairman, and your gentleman, and we appreciate that. And of course, that next step will be at the Rules Committee, and with your influence and a word on your behalf at the Rules Committee certainly will go a long way, and I thank you. And I will withdraw the amendment.
The gentleman withdraws his amendment. Are there any other amendments? There being no further amendments, without objection, the previous question is ordered. The question occurs on reporting the bill as amended favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the bill as amended is ordered reported favorably to the House.
We're going to go to Posey.
Pursuant to notice, I now call up H.R. 4662 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4662 to amend the Consumer Financial Protection Act of 2010 to establish...
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from Florida, Mr. Posey, the sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chairman. I'm pleased to speak on behalf of this bill, H.R. 4662, the Bureau Advisory Opinion Act, which would allow businesses and individuals to ask the CFPB for an advisory opinion as to whether a particular transaction complies with the law and CFPB regulation. A number of federal agencies, including the Securities and Exchange Commission, Federal Trade Commission, and the Internal Revenue Service, already have an advisory opinion process, and it has functioned well for decades. These written opinions which are binding on the agency with regard to the party who requests them, give confidence that a particular course of action complies with agency rules. Businesses and individuals should not be caught with a gotcha. They should be allowed to proceed with a level of certainty. It is good for consumers, it is good for business, and it's good for our overall economy. Rather than have individuals and businesses play a guessing game as to how the CFPB will act, the advisory opinion process established by this bill would facilitate business activity and allow these businesses to implement new and innovative ideas without fear of them being later disqualified by the CFPB. The demand for such a system is high, and this bill has gained the support of a broad range of businesses, all of whom see its benefits. I therefore ask my colleagues to support this common sense idea that has already proven its value in other federal agencies and report H.R. 4662, the Bureau Advisory Opinion Act, out of this committee. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Who seeks?
Actually, does the gentleman have a manager's amendment?
Do I understand the gentleman has a manager's amendment?
Yes, Mr. Chairman.
If so, I'd like to recognize the gentleman at this time to offer his manager's amendment. We will pause and allow the amendment to be distributed. The clerk will report the amendment.
Amendment offered by Mr. Posey after page 3, after line.
Without objection, the amendment is considered read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. As Representative Pierce previously pointed out, one of the values of the advisory opinion process is that the guidance provided to any particular person can be applicable to other situations. In consequence, I am introducing a manager's amendment to further enhance the benefits provided by the bill. First, advisory opinions will be made public on an anonymous basis so that other businesses can benefit from the CFPB's guidance. Other federal agencies publish their advisory opinions, and this process has helped guide business decisions throughout the U.S. economy. The amendment further ensures that all requests for an advisory opinion are kept confidential and that only the opinion itself, without any information identifying the petitioner, will be made public. I therefore ask that you adopt this amendment. I yield back. Thank you.
Gentleman yields back. Who seeks recognition? For what purpose does the ranking member seek recognition?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you very much, Mr. Chairman and members. Let me first start by saying that Mr. Posey's amended version does not make this bill any better. As a matter of fact, the amended version of this bill establishes a process by which firms can inquire whether a product or service that it intends to offer conforms with federal laws in the opinion of the Bureau. The manager's amendment makes those opinions public, but it fails to address the unworkable time restraints for responding to the inquiries. The Bureau already offers informal guidance to a number of venues, including advisory councils and the Office of Financial Institutions and Business Liaison. The practical effect of this bill is to inundate the director with an onslaught of individual requests that would limit the Bureau's ability to perform its many other obligations, including research, supervision, enforcement, and education. Reviewing proposals piecemeal is a costly and inefficient process, and the Bureau should focus its efforts on implementing rules that make sense for all market participants, issuing public supplementary guidance where necessary. This process is consistent with requirements and expectations imposed on other financial regulators and ensures a level playing field for both consumers and providers of consumer financial products and services. I think that, as I have said, I do think that the Bureau would be inundated, and certainly they would not be able to keep up with the onslaught. This is not designed to help anybody. This is further designed to impede, to make it impossible to get anything done. And I would just ask a no vote on this bill, on the manager's amendment version of the bill.
Gentlelady yield back.
Yield back the balance of my time.
Gentlelady yields back. Who seeks recognition? The chair will recognize himself. One for situational awareness of the members. After we dispense with the Posey bill, there are two other bills pending before this committee. Votes are expected on the floor somewhere between 6 and 6:20. It is the intention of the chair to finish these three bills today. Members can do the math themselves. I do want to commend the gentleman from Florida for his bill. This is so common sense to ensure that small businesses that are trying to create jobs, that community banks that are trying to extend lines of credit, other people who are trying to extend capital, at least have the option of receiving an opinion, an advisory opinion from the CFPB. I mean, we've had the director of CFPB here before who cannot define the term abusive, and yet he has the unilateral power to declare any financial product as abusive and essentially outlaw that particular product. Businesses are trying to follow the law, so many of them are, but if they don't know what the law is, if we have lost the rule of law and instead we have morphed into the rule of rulers, then the business will not be launching these products. People will not be getting the extension of credit. Small businesses will not be able to expand and hire new people. It is that simple. Advisory opinions are used successfully by the SEC, by the Federal Trade Commission. You know, we don't dictate what the opinion is, but the CFPB ought to have some opinion and in some reasonable amount of time give some guidance to those seeking it. So again, I appreciate the gentleman from Florida. We'd be glad to yield him time. Does the gentleman from Florida wish time? I'd be happy to yield to the gentleman from Florida.
Thank you, Mr. Chairman. I could not have said it much better than you did. If we're interested in helping people have jobs, this is pretty important. I thank the gentlelady for raising the issue, and I appreciate the fact that there may be circumstances where it might take additional time for the CFPB to prepare an advisory opinion. I know this committee and members of this committee have asked the CFPB questions, and the CFPB has taken over 6 months to answer our questions, but there's a relatively short leash for industry to respond to the CFPB. So I do believe the best way to prompt the CFPB into action is to put a statutory time limit in place. The CFPB has already shown, you know, it has difficulty complying with other statutory time limits, and I don't believe that making the advisory opinion process open-ended will contribute to the timely preparation of these opinions, and I therefore believe a time requirement should be included in the bill, and I yield back. Thank you, Mr. Chairman.
Chairman yields back. Who seeks for what purpose? The gentleman from Washington seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chair. I happen to believe that there's the essence of a very good idea here. And in fact, I think we all function in environments where we are the beneficiaries of parallel kinds of processes. For example, statement of administration policy. We like having some advance notice, a signal, so that it can impact our thinking as we proceed. In my own state, we have various tiers of Attorney General letters. There's the letter, there's the memo, there's the formal opinion, and these help guide us as we proceed as to what is worth or not worth. So I count me as somebody who is definitely a friend to the concept, Having said that, I still think that there are implementation issues associated with the specific deadlines in here, but that's not to say that something, if there was an interest in having substantial bipartisan support, could not be worked out later. We don't have time today, I get that, but if there is an interest over there before the time the bill hits the floor, I know I'm speaking for others because I talked to them about it in the last day, about this could be a very positive thing if we do it right. And I offer that comment in all sincerity. If there is any interest, we stand prepared to make this a overwhelmingly supported bill, but I can't go there with the specifics that we have in it right now, notwithstanding the fact that I'm glad you brought it forward, and I understand the reasons you did, and it was for all the right reasons, so thank you. But I'm voting no. I yield back.
Gentleman yields back. Who seeks recognition? For what purpose? Oh, I'm sorry. For what purpose does the gentleman from New Mexico seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Really appreciate the gentleman from Washington's comments until the last one. I think that, that Representative Posey has a bill here. As a small business owner, the one thing you look for is sureness. In other words, you can live with numbers here or there, but you can't live with numbers that are not in place, or with concepts that are not in place. So what the gentleman from Florida is attempting to do is just say that we're going to give these series of head nods that unless something happens, we're going to move this way or that way. And it's extraordinarily valuable for investment, for hiring, for future business plans. And so I think the gentleman raises his objections fairly, and I hope that the sponsor of the amendment, and we're co-sponsors of it, or the bill, would try to figure out, because the more of these things that we can rationalize together, the better the country is. And so I really did appreciate your comments about that. These opinions being made openly and to the broader audience will then not just affect small businesses, but the bigger businesses are able to read the tea leaves from that and begin to set it up. And these processes simply mirror the things that have been happening in the FTC, SEC, and the IRS for decades. And again, like you pointed out, and I suspect the sponsor of the bill pointed out, that those processes have worked fairly well in the past, and if you can say anything from the IRS, has worked well. But they've been beneficial to businesses. And the biggest thing is that we're competing worldwide. It's no longer just one state against another, one business against another, but it's the U.S. business environment is competing with other countries' business environments. And I just think that we all ought to be looking for the similarities and the areas we can find agreement, because this is not a Republican versus Democrat thing. This is America versus the rest of the world. And so the things that we can do to make ourselves have competitive parity or even competitive advantage, we ought to be taking a look at. So again, we just support the bill and appreciate the opportunity to speak on that, and I would yield back the balance of my time. Thank you.
Gentleman yields back. For what purpose does the gentleman from California seek recognition?
I would like to strike the requisite number of words.
Gentleman is recognized for 5 minutes.
Okay. I join the gentleman from Washington as a friend of the bill in concept. I am concerned about the fixed deadlines. I think that those should be goals. One could imagine that we tell the agency 95% of the time you have to reach these deadlines. We recognize that some questions may be difficult, and as long as you get and if you assign as many as 5% of the requests to the file of things that are particularly difficult, and those take you longer, then at least 95% of the inquiries will achieve these deadlines. Another concern I have about the bill is I don't want resources taken away from consumer protection in order to provide this very important and valuable business protection. And that's why it seems appropriate that the agency be allowed to collect fees. I don't know whether I'll offer a formal amendment or just pontificate for the next 3 minutes and 55 seconds about the concept. The amendment that I've drafted simply allows the CFPB to charge fees based on its costs, but says that if you're a small business, the maximum fee you can be charged is $500. Given what it costs for any kind of business or legal advice, some of my lawyer friends would be aghast to think you could get any advice or information at all for as little as $500. So I think that this is consistent with protecting small business and at the same time turning to the larger businesses and saying, look, you want a lot of analysis done, you want a lot of legal research done, please pay the government for the cost of your inquiry. That would allow us to also say to businesses that if you have a difficult question that isn't very important, then don't ask it. If it's important, then you should be willing to pay the cost necessary to ask it if you're a large enough business to bear that cost. So I think that if this bill was limited to those inquiries where business was willing to pay the cost of determining the answer, subject to that $500 maximum for small business, and if the rigid deadlines were met, say 95% of the time rather than 100% of the time, that I could be a friend not only of the bill's concept but the bill as written or as revised. So with that, I look forward to further discussion. I believe that the author has a manager's amendment, and that will give me enough time to figure out whether to formally offer my amendment or not.
Gentleman yield back.
I yield back.
Gentleman yields back. Who seeks recognition? The question then is on agreeing to. For what purposes, gentleman from Massachusetts? Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I too want to line up as somebody who thinks the concept is great. It's perfect. The IRS has done it. They do it successfully. But again, the rigid time limits are a problem. IRS has a whole list of questions they will not answer because they take up too much time, they're too mundane. They publish that list every year. There's nothing in this that suggests that anything can be denied. The IRS charges fees of up to $12,000. I'm not sure I support the concept of being able to charge for the exact dollar cost of these things. That strikes me as probably a little too much and a little bit too high a barrier. But I think it should be something. I don't know exactly what it should be, but the IRS has no 90-day limit. They answer things usually within 6 months. They're actually aiming for 10 weeks. But I don't know the staff ratio of what the IRS dedicates to this versus what CFPB might be able to do. I don't know exactly what all that means. And my big fear is even if this would have passed, as is, all good intentions, everyone voting for it, the potential result is a flood of questions to the CFPB that they cannot possibly answer. And the result of that will be pretty much a blanket denial, which doesn't help anybody. And that's human nature. If I have 1,000 things to do and I have to get them done within 90 days, I can't do it. I can do 10 of them. I'll do those legit. The other 9,990 are going to get a form letter saying, thank you for your inquiry. No, you can't do it based on the information. That's not, I'm sure that's not the result you want. That's not the result I want. I want thoughtful, helpful things. And the IRS also has very clear rules that when they give a private letter ruling, that's what it is. It's binding on the individual, relative to the individual taxpayer. It is not binding on other taxpayers. And of course, it's all based on the information, which I think is all here. So I think the concept is perfect. I think it's easy to work these things out and get some answers to these things. I just think it's a little premature to take this bill and just rush it through, especially when I think you have a pretty clear opportunity over here to have a perfectly bipartisan bill that we can work out, because your goal, I don't think anybody opposes it. No one in their right mind would, but details matter, as you know. And the idea, we're hoping, in good sense, that the idea is not intentionally to flood the CFPB to kill them. I know that you have other problems with them, and that's what the other bills are for. This is, I'm hoping, not one of those bills. I'm hoping this is a bill that's intended to actually try to do something that helps. And if that's the case, I would love to be able to be helpful, and I would love to be able to be supportive, but I think that's going to take a little time to get there. And I'd ask the gentleman if we could have that time.
Gentleman yields back. Who seeks recognition? The gentleman from Florida has already been recognized. Gentleman from Indiana seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
I would yield to the gentleman from Florida.
I will yield across the aisle, or yield. I'll yield back and wait. Okay. I was going to say I appreciate the interest in this bill from the other side of the aisle, and I know that your interest is sincere. And you know, it is true that the IRS charges a fee. It's from $1,000 to $15,000. It's pretty broad to publish an IRS advisory opinion called a private letter ruling. It's important to note, however, that other federal agencies, such as the SEC, the Securities and Exchange Commission, and the FTC, the Federal Trade Commission, they don't charge a fee. They do it as a public service. They make the rules. They should make the rules clear enough that somebody could, you know, use a little bit of common sense and a regular roadmap to follow them. You know, I first heard about the question about 9 o'clock this morning that, you know, that was another issue. So I haven't had a whole lot of time jumping through hoops all day today to try and figure out a solution, or to have my staff get with your staff to try and figure that out. But I'm, you know, not looking to make the agency a profit center for business, and I'm not looking to make business a profit center for the agency. I'm looking to try and move this thing forward with common sense, and I really would love to have it be bipartisan. And so I promise you that if you're willing to work with me on this, I'm willing to work with you on it to see if we can come to some common sense middle ground on this thing before it gets to the floor. I mean, you have my commitment on that. So.
Time belongs to the gentleman from Indiana.
I would yield back.
To the gentleman from Indiana yields back. Who seeks recognition? Are there any amendments to the amendment? For what purpose does the gentleman from California seek recognition?
I have an amendment to the desk, which I'll offer, withdraw, and work with the gentleman as we go forward, and yield back.
Is the amendment to the manager's amendment or to the underlying bill?
It's the underlying bill, so I may have spoken too soon.
If we could then dispense with the manager's amendment.
I have no comment on the manager's amendment.
Okay, we'll dispense with the, are there any amendments to the amendment? If not, the question is on agreeing to the amendment in the nature, nope, it's agreeing to the amendment. All those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the amendment is agreed to. Are there any other amendments?
No.
No.
No, I'd rather just work with the author than go through the formal process.
Okay. Are there?
Much as I respect the ranking member, we'll short circuit this process.
Okay. There being no further amendments, without objection, the previous question is ordered. The question occurs on reporting the bill as amended favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. A recorded vote has been requested. Those in favor of recorded vote will raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is ordered pursuant to subsection C5 of Rule 3 of the committee rules. The vote on this question is postponed. The committee inadvertently bypassed adoption of the Pittenger Amendment and the nature of a substitute on H.R. 4383. Without objection, that amendment as amendment is considered adopted. Pursuant to notice, I now call up H.R. 4811 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4811, to provide for a notice and comment period before the Bureau of Consumer...
Without objection, the bill is considered read and open to amendment at any time. The chair recognizes the gentleman from Indiana, Mr. Stutzman, the sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chairman, and thank you for including H.R. 4811, the Bureau Guidance Transparency Act, in today's markup. I introduced this bill to safeguard industry from the CFPB's abuse of guidance. While guidance is traditionally a mere restatement of law or further explanation of rulemaking, the CFPB has recently exceeded this scope. H.R. 4811 requires the CFPB to provide for a notice and comment period prior to the issuance of guidance, similar to the required feedback period for rulemaking. It requires the CFPB to show its work by providing any data or other analysis relied on for guidance. In addition, H.R. 4811 was written to ensure that the CFPB redacts businesses' confidential and proprietary information from disclosures. Finally, this bill makes one particular heavy-handed guidance, Bulletin 2013-02, unenforceable until it has undergone the new process required of all future CFPB guidance. These are fair and reasonable adjustments to the CFPB's regulatory guidance process intended to promote transparency and dialogue between regulators and industry. I'm glad to report widespread support for this legislation from a range of groups, including the National Automobile Dealers Association, the American Bankers Association, the Independent Community Bankers Association, the Credit Union National Association, and the U.S. Chamber of Commerce. Mr. Chairman, I would like to share just a brief story of a young man who I ran into this last week, who is a banker in central Indiana, and this was an issue that he brought up without me even sharing with him what I was proposing today. And this is a very common issue amongst folks in the industry who continually are frustrated with the fact that they don't understand oftentimes the logic, the data, the research that CFPB does behind this guidance, and oftentimes are frustrated and concerned about the direction and the decisions that they have to make. And so, as Mr. Fitzpatrick's bill also was addressing guidance as well, this is something that I believe can bring quality work to not only CFPB, but also transparency and clarity to so many folks across the country who are uncertain of a lot of the work that is happening at the CFPB. So for so many of those small banks out there who don't have a large staff of folks who can continue to keep up with CFPB rules and guidance, that this is something that I believe will help them and so many others to understand where the CFPB's decision-making and guidance and rulemaking are coming from, and should bring better government for all involved. So with that, Mr. Chairman, I yield back.
Mr. Chairman.
The gentleman yields back. I do wish to remind all members they have the option to insert statements into the record. For what purpose does the ranking member seek recognition?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
This bill requires the Bureau to provide public notice and comment prior to issuing guidance in final form, and requires the Bureau to publish all studies, data, and other analysis relied upon by the Bureau in preparing and issuing such guidance. The bill specifically repeals Bureau guidance relating to indirect financing for auto dealers. This bill would interfere with the Bureau's ability to issue interpretive guidance on the rules and laws it enforces, making it harder for businesses to comply. Other financial regulators, such as the Fed, the FDIC, the OCC, the SEC, and the FTC, also issue guidance and are not required to seek public comment. Like the CFPB, those agencies take public comment during the rulemaking process in accordance with the Administrative Procedures Act. The CFPB has issued guidance on a number of topics in response to industry concerns about ambiguity. These include clarifications on mortgage servicing, the use of prepaid cards for employee payroll, a notification of intent to protect privileged information shared with state financial regulators, and methods for appealing supervisory decisions. These guidelines have not only been helpful in clarifying expectations to industry, but often are in industry's favor once such guidance clarified that employers could contribute to qualified employee benefit plans without running afoul of the anti-steering rules. Guidance from the Bureau tends to be brief and straightforward, and also carries contact information for experts at the Bureau who can help small banks and small businesses understand and comply with Bureau rules. The Bureau should be applauded, not punished, for being responsive to industry concerns. This bill would tie the Bureau's hands by making it more difficult for them to communicate compliance expectations. This additional burden would be particularly problematic as it impairs the Bureau's ability to provide guidance in a timely manner where new and potentially risky or complicated products and services pose a pressing risk to consumers. While the national auto dealers support this bill, and I want to tell you, there have been a lot of debate about this bill, a lot of discussion over a long period of time. The minority auto dealers who work in these communities understand the importance of fair laws and are not supporting this bill, which would harm the CFPB's enforcement of disparate impact. So, I know that a lot of members of this committee have been concerned about what the minority automobile dealers were thinking, and a lot of time have been spent trying to understand exactly where they were coming from. And they've made it absolutely clear in a communication to us now that they do not support this bill. So I want to share that with you in case there's some misunderstanding about where they stand. So with that, Mr. Chairman, I would ask for a no vote on this legislation.
Gentlelady, yield back.
And I yield back the balance of my time.
I wish to alert all members that there is a vote pending on the floor, so we must recess soon. If there are members who wish to be heard orally, we will recess now and continue this debate upon the return. They have the option, again, of having their statements entered into the record. After dispensing with the bill of the gentleman from Indiana, there will be one bill left. We will resume after votes. I'm led to believe we will be on the floor for approximately an hour to an hour 15. Does the gentleman from Georgia wish to speak on?
Yes, I would, and I appreciate just a few minutes on this one because I think
there are literally 3 minutes left on the floor, so if the gentleman wishes to speak, we will not dispense with this bill now, and instead we will return at approximately 7:15 to 7:30, at which point the gentleman can be heard.
I have a...
If the gentleman wishes to be heard in about 60 seconds.
60 seconds, because I do...
Gentleman's recognized.
Thank you, Mr. Speaker, because I have a fundraiser I got to get to right after. And I don't like to... But I have been on this issue. I do want to raise this issue of unintended consequences of this. Ms. Waters is absolutely right. But it has brought the auto dealers into this situation because of an action by the CFPB last March in issuing a ruling, issuing guidance that was not clear, did not give either side, anybody in the automobile industry, the auto dealers, the opportunity to be heard. And when you're dealing with racial discrimination, that is something that certainly requires an opportunity. And so with that, I have mixed feelings about this, and I think there is a reason why at times the CFPB needs to be open.
Is the gentleman yelled back?
Yes, sir.
Then if there are no further amendments, the question occurs on reporting the bill favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. The committee stands in recess. Committee will come to order. Without objection, the committee will reconsider the vote on H.R. 4811 to the end that the vote will be taken de novo. So ordered. The question occurs on reporting the bill favorably to the House. Those in favor say aye. Aye. Those opposed say nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. A recorded vote has been requested. Those in favor of recorded vote will raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is ordered pursuant to subsection C5 of Rule 3 of the committee rules. The vote on this question is postponed. Pursuant to notice, I now call up H.R. 4809 for purposes of markup and move that it be reported to the House with a favorable recommendation. The clerk will report the bill.
H.R. 4809 to reauthorize the Defense Production Act to improve...
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from California, Mr. Campbell, the chairman of the Monetary Policy and Trade Subcommittee and sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chairman. And now the moment everyone has been waiting for, the crescendo to this markup, the reauthorization of the Defense Production Act. The Defense Production Act has been around since the Korean War, so there shouldn't really be anything particularly controversial about this. It was reauthorized in 2009 and reauthorized in 2005 and 2004 before that. And there is essentially nothing in this reauthorization that we have today that wasn't in one of those bills which passed with a huge bipartisan, I think some cases by voice, but a huge bipartisan vote. Let me just make it one thing clear on the Defense Production Act. There are basically two things we're dealing with here. Title I, which is where, to use an example, which the Defense Production Act was not used for because it was passed during the Korean War. But in World War II, something everyone's familiar with, when the government came in and said, hey, General Motors, Ford, and Chrysler, we need you to stop building cars and build tanks and planes and ships and such. It is the Defense Production Act that we have now that enables the government to do that thing and to hold the company harmless for any liabilities they might have by not building what they would normally build in order to build something for the national defense. And then Title III, which is used, and by the way, Title I is also used in natural disasters. It's been used most recently in Katrina, so it can be used for domestic purposes as well. And then there is Title III, under which the Defense Department, the government can go in and say, this is something that we need for the national defense, and we either need it produced in the U.S. Or we need it produced at all. Perhaps it's not produced anywhere. And but it's not currently being produced because it's probably not economic to do so because it has no commercial use, so only a military use. And so what Title III does is it enables the government to authorize these sorts of things and say, company, you have to build this for us because we need it, or make this for us because we need it for the national defense. The only changes really in this reauthorization from the past reauthorization is that we have put in a couple of things that were in the 2004 reauthorization, one of which says that if a project in Title III is over $50 million, it has to come back for congressional authorization. Since this was originally passed in the Korean War, there have only been 3 such items over $50 million, so it's extremely rare. And because normally what we're doing is we're asking for something that there's no commercial use. When you think about it, if there's $50 million used for it, there probably is a commercial use out there somewhere. So we've put that in there and saying you have to come back and get congressional authorization if you're going to spend over $50 million. We've also asked that the President be the one to sign to authorize things under Title III and say, yes, this is something we definitely need. There's nothing new about that. I've got letters here signed by President Clinton and President Reagan, who were required to sign back then to authorize things in Title III to presidential authorization. And it just makes it so that we understand that at the highest level of the government that we're doing this because we truly need to do it, not because somebody just kind of wants to do it. Also, there's an interagency coordinating committee which had some jurisdiction over Title I. We've left them on Title III. We've left them only on Title I. And we've also just tightened up the language a little that says that if we're using Title III, it has to be the most expedient and cost-effective way to remedy the defense industrial base shortfall. In other words, again, we're doing this kind of thing and stepping into the private sector here, not because we want to do it, but because we need to do it, either for national defense or for some domestic crisis, hurricane, flood, whatever that is going on. So with that, Mr. Chairman, this ought to be a fairly simple and bipartisan thing as it has been in the past. And I should mention that there's a lot of question of why is this in our committee and not in Armed Services, and that's because technically we are looking out for its impact on the economy. And so that's why it's in this committee. But we do have a letter from the chairman of Armed Services saying that they believe over at Armed Services and that the military believes that they need this bill and they need this authorization for furthering the national defense in the future. And I yield back my time.
Gentleman yields back who seeks recognition. For what purpose does the ranking member seek recognition?
Mr. Chairman, I have an amendment at the desk.
We will pause a moment and allow the amendment to be distributed. It does not appear that the desk has the amendment at the moment.
Waters 559.
God bless you, bless your heart.
We just encourage you.
You want to encourage minority businesses to be taken over by the federal government and told what to do?
Most of these businesses will be joint ventures or subcontractors to the big defense guys. Anyway.
Is there any member who has not received the amendment? The clerk will report the amendment.
Amendment offered by Ms. Waters. Add at the end of the bill the following, Section 5, Statement of Policy.
Without objection, the amendment is considered as read. The gentlelady is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chairman. When the Defense Production Act first became law in 1950, Congress understood then that public policy, even defense policy, can incorporate concern for social equity without undermining national security goals. Specifically, the original Defense Production Act of 1950 accorded a strong consideration for small businesses' concerns that submit proposals for contracts under the Act. My amendment today extends the same opportunity provided to small businesses to participate as contractors in programs to strengthen the nation's industrial base, to businesses owned by minorities, women, veterans, and service-disabled veterans, as well as to businesses that demonstrate diversity and inclusion in the workforce. I recognize, of course, that not everyone is as motivated by questions of social equity as others. That is why I want to point out that my amendment has a broader purpose and scope. Linda Hudson, the first woman ever to head a major defense contracting company as the CEO of Bay Systems Incorporated, and who was dubbed the First Lady of Defense by a Washingtonian magazine, identified as one of the most significant challenges faced by the defense industry, the recruitment and retention of talented people, including the difficulty attracting and retaining women, minorities, and employees from other underrepresented groups. Ms. Hudson has strongly advocated for the federal government and defense industry to more fully access the available talent pool in this country by embracing and developing obvious but historically underutilized sources of talent, including women, minorities, and veterans. Moreover, a study completed in 2012 by Aviation Week cited notable and enduring concerns about the low number of women and non-white males in the aerospace industry. Although women have slowly been making some gains, the industry's track record in hiring and promoting minorities remains disappointing, particularly given the fact that minorities have achieved greater gains in the U.S. military, the industry's main customer. My amendment simply extends the maximum practicable opportunity provided to small businesses to participate as contractors and subcontractors in programs to strengthen the nation's industrial base, to businesses owned by minorities, women, veterans, and service-disabled veterans, and to businesses that demonstrate diversity and inclusion in their workforce. This is a clear case where good social policy complements our long-term national security interests. I'd like to submit for the record 2 articles in which Ms. Linda Hudson discusses the importance of including women and minorities in efforts to strengthen the economic and technological competitiveness of the U.S. defense industrial base, as well as a Washington Post article from last year that talks about how minority contracting has not kept up with the population numbers.
Without objection.
Our nation's defense and aerospace industries need to more fully access the talent that other industries seem more eager to embrace. I urge my colleagues to support this amendment.
Gentlelady yield back. Does the gentlelady yield back her time? You yield back your time. Yes. The gentlelady yields back. Who seeks for what purpose does the gentleman from California seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate the ranking member's amendment, but a couple things I would like her to consider. First of all, given the objective you want, I'm not sure you actually want to do this because having under the Defense Production Act, having them come into a company and do something is not something that company necessarily wants, particularly if it's under Title I. If it's under Title I and you build 4 different things, the government can come in and say, okay, you're only building one thing because we need it. You're only building Kevlar vests, as an example, because we need those. And the other 3 things you build, guess what? You're not building anymore. And the Defense Production Act specifically holds that company harmless from being sued by the contracts from their other customers that they're going to have to break to meet that government. That's what it's for, is so that company doesn't get harmed in that way. But you might never get that business back. So frankly, if you wanted to give some consideration or preference to somebody, I don't think you want to do it in this bill because it's not something necessarily good that comes your way when the Defense Production Act comes to a company. Second of all, in terms of small business, Title I is different, but in the Title III area, which is where there's about 5 things a year historically, there's been in Title III. The purpose of Title III is the Department of Defense needs something for which there is no commercial use and for which there is no commercial market that is profitable, so nobody makes it. So or it's only made overseas and they want it to be made here. So they go in and they say, all right, here's this thing and we need you to make it. And this year I think there's 6 of them, or last year, that totaled $22 million. So by definition, these are $1 and $2 and $3 million things because there's something for which there is no application. If it was a $50 million thing, you wouldn't have to use this because there would probably mean there's a commercial application out there. So that stuff almost by definition goes to small business because the big guys don't want to play around with that. It's not, although this could make them do it, but they kind of don't want to play around with it. So I think there's that too. And then the other thing is to remember that unlike other forms of contracting that goes on, everything here is basically an emergency. It's either an emergency because we have a war or a natural disaster and we need it right now. And we don't want to put more regulatory hoops between the Defense Department or whomever. It could be, one of the things, you could have a pathogen that's killing the wheat crop all over, and it's actually agriculture. Isn't necessarily always defense, but you don't want to put something in the way. And if it's a Title III type thing, then again, it is an emergency in that here's this thing that nobody's making, and we need somebody to make it. And if nobody's making it, there's probably a very limited number of people who are even that are even in the mix of having the opportunity to make it. So with respect for the ranking member, I oppose the amendment. And as I said, we actually haven't, to try and make this less controversial, we actually haven't introduced anything in this that hasn't been in one of the prior two authorizations. And so it'd be nice if we could keep it that way, I think. And so with that, I yield back.
Will the gentleman yield?
Oh, yes, I'm happy to yield.
Thank you very much. And I thank you for the explanation of wanting to make sure that I understood exactly what this Defense Production Act is all about. And I would respond to you in this way. First of all, we have been working for years to try and get minorities and women into defense contracts, period. And we continue to work in every way that we possibly can. And as you can understand it, many of the contracts go on for years and years and years, and they may not come under the DPA. And so we want people to have those opportunities. And if in Title I, as you have explained, they get taken over, well, minorities and women deserve to have the opportunity to fail or to be taken over just like everybody else. And so we don't want to protect them so much that we say, you can't have a piece of this pie because you might get hurt down the line. No, we want to play and we want to get hurt. And we want to succeed and we want to fail and all those things. The other part of this, the Title III that you responded to, if in fact nobody else is producing this but one little company and it's only a $1 little $1 million business, we want some of that too. And so we cannot shy away from these opportunities for fear that we may not get enough or we may somehow get it taken away from us. Don't worry, I love the protection that you're offering, but we want to play in this also. Thank you.
Time of the gentleman has expired who seeks recognition. Are there any amendments to the amendment? The question is on agreeing to the amendment. All those in favor say aye. Those opposed say nay. Nay. In the opinion of the chair, the nays appear to have it. The nays have it. The amendment is not agreed to. Are there any other amendments?
Mr. Chairman, I have an amendment at the desk.
We will pause for a moment, allow the amendment to be distributed. Has every member received a copy of the amendment? The clerk will report the amendment.
Amendment offered by Mr. Meeks. Add at the end the following. Section 5. Report.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. And this is very simple. And this is basically very similar, almost identical to an amendment that I submitted in the past. In fact, in a prior authorization back in 2003, the Defense Production Act, which was passed by this House and this committee with complete bipartisan support. Everyone was on it. In fact, I think it passed without any opposition. What this amendment simply requires is the Secretary of Defense to submit a report to this committee on the extent to which contracts issued last year under the Defense Production Act have been contracts with minority-owned businesses, women-owned businesses, and veteran-owned and service-disabled veteran-owned businesses. As you know, defense production contracts offer enormous contracting opportunities that support millions of Americans, very similar to what Ranking Member Waters was just talking about. And what Congress needs to do is to monitor and provide oversight to ensure that all segments of the population are getting their fair share of these business opportunities, including women, minorities, and disabled veterans. The only change that I've made to the 2003 amendment that was, in fact, as I said, adopted with support of my Republican colleagues, is language that will include contracts to veteran-owned and service-disabled veteran-owned businesses. That's the only addition. You know, this is a bill, as I said, that an amendment that we had in a prior authorization, and it's an exact bill, except we want to make sure that we take care of our veteran-owned and our service-disabled veteran-owned businesses also. This amendment is an opportunity to get the facts on DOD contracts so that we can begin to understand and to know what they're doing. And I believe also this helps us to support veteran businesses. Let's give them and minority and women business opportunities to support their families, especially those service members that have honorably served in their armed forces. Mr. Chairman, you know, I really appreciated in 2003, of course, your support on this amendment also, and that's why I wanted to make sure that we made no changes to it except adding our veteran-owned and service-disabled veteran-owned businesses, because I thought it was bipartisan then, and I wanted to make sure I did nothing different so that we could just use this updated version and moving forward. And I thank you.
Would the gentleman yield?
Yeah.
The chair was a freshman in 2003. Gentleman, yield back.
I yield back. That's my time.
For what purposes, gentleman from California seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I appreciate what the gentleman is doing, but I still oppose it. For the reasons stated before, this isn't about quotas. This isn't about doing things like that sort of thing. Not here. Not here. And the Pentagon Small Business Office does outreach on this stuff anyway. So they'll be doing what they normally do on defense contracts as they would on this stuff as well. But I, for the reasons that I've stated before, I don't think a lot of these are contracts that the people on the other side don't want necessarily, because this is what this does is it allows the government to go into private business and say you're going to do this whether you want to or not, and because you have to for the national defense or for a national emergency. And so that's what this needs to be about. And there's all kinds of other things like this you could put in, we could put in, and I don't want to. This member of Congress doesn't want to do that.
Would the gentleman yield?
Yeah, sure.
Number one, I've never said in this amendment this talks about no quotas. It doesn't talk about any mandates. It just says that give us the knowledge so that we know what's going on. It says give us the report so that we know how many contracts were with minority and or veterans, et cetera.
Well, will the gentleman yield? Then why don't we have a report that says...
And the gentleman said previously that, you know, you didn't want anything that was not in a prior authorization. This was in a prior authorization. We had no problems with the Defense Department previously. They had no objections into doing it. It was, you know, done on a completely bipartisan manner. So that's why we made sure. The only thing we're doing here is we approved of it before when it was just minority. I just wanted to include veteran-owned and service-disabled veteran-owned businesses.
Reclaiming my time, our information is different because my information is that it may have been voted on this committee, but that it wasn't in the bill as passed into law. That was different. So our information is different on that.
Well, I'm informed that it was passed into law. It was in the bill.
Then we have different. Then we have different information. But whether it is or whether well, then it wasn't the last time.
But if I could print it out and show you that it was in, if the gentleman would yield, would that then make a difference to the gentleman?
Well, if it was or it wasn't in the 2009, so it was stripped then.
Yeah, but the gentleman said the last two when we talked about Ms. Waterbury. You said
yeah, no, you're right. You're right, but it must have been taken out in the 2009 bill, I'm presuming. But whether it is or whether it isn't, you know, when you set up a report like this, you're basically telling the people that this is something that they have to do, not just the report, but that they have to do. I mean, why don't we report? There's a million things we could have them report on where where these contracts are at. And I think this thing should be just about serving the needs of the emergency or whatever it is at that time.
If the gentleman would continue.
Yeah, I'll continue.
I mean, absolutely. I think that what we know is, we're just trying to find out, I think that we know that our veterans have made tremendous sacrifices, and we're talking about a number of the contracts. And all we're saying is let us know how many that you've given over the last year, right after the appropriation. We're not saying we're mandating you to give them X amount We're not saying it's got to be 5% or 10%. Just let us know what you're doing.
Reclaiming my time.
Transparency in that regard.
You think the Pentagon Small Business Office doesn't take any of that into account now?
I don't know. I want to find out. And that's what the report would do. It will let us know what they have in fact done and what they have not.
These things, reclaiming my time again, these things, it's my understanding that the Pentagon Small Business Office already has a certain amount of guidance on things they do on all contracts. Now, on this stuff, because it is so immediate, there's always going to be a smaller potential group of suppliers, if maybe only one, than there would be in a non-emergency situation.
If the gentleman would continue to yield.
I will.
I just know that it was no objection from the defense previously about this by providing this information to us. So I don't see where the problem would be now. I don't think that it's a big issue that would provide a problem. It's not a problem to them. It shouldn't be. Wasn't a problem bipartisan before. It just lets us know what's happening with our veterans and our women and our minority-owned businesses.
Yeah, well, and in the last 10 seconds, if it was pulled out in 2009 when you guys were in charge, there must have been some reason for that as well. So we simply will agree to disagree on this point, and I yield back.
Time of the gentleman has expired. Are there, what purposes, the ranking member? Gentlelady is recognized for 5 minutes.
Don't get your resistance. I don't understand this. I mean, you're being very passionate and very adamant about this, and what we're trying to point out to you is that, you know, contracting has been a problem, and not all segments of our society have had an opportunity to participate. And while we are working very hard talking about what the Consumer Financial Protection Bureau is not doing or is doing, where they are limiting opportunity and all of that, I think that if we are going to be serious about our efforts to open up opportunities, to close this wealth gap, and to do what we should be doing, this is a very, very mild and meager way of saying, just tell us. Just tell us what you're doing, and I don't get your resistance.
Okay. Will the lady yield?
I yield.
Okay. Because this bill is about emergencies. This bill is about things that we have that we can't get under normal channels for the national defense or for an emergency. I don't want to put any reports on anything except that you solved the problem, except that you dealt with and solved the problem.
Reclaiming my time.
And as far as your
reclaiming my time, I'm trying to understand what you're saying about, this is simply about emergencies. And what we're trying to explain to you is this is simply about fairness. This is simply about opportunity. This is simply about inclusion. This is simply about correcting.
Will the lady yield?
This is my time.
Where in this bill does it say?
I'm not.
It doesn't say minorities and women businesses can't.
The time belongs to the gentlelady from California.
And so, while your emergency may be more important to you, or the emergency that we are affording the DPA to deal with is paramount, it's important, I don't want you to negate the fact that what we're trying to do is extremely important also. And because of exclusion for so many years historically, it's an emergency for us also. And so what I'm saying to you is, you know, we have to fight so hard for fairness. We have to fight so hard for inclusion. We have to fight so hard to correct the ills that have been known about for so many years historically. And so when something this simple is being proposed, and let me repeat, as
will the lady yield?
Said, please, this is my time. You may not talk on my time. As Mr. Meeks has said, this is not about any quota. I noticed you mentioned that in your early discussion. This has nothing to do with any quotas. This has nothing to do with forcing anybody to comply with a law that says you shall, you must do this. All it's about is reporting. Just give us the information. That's very simple. Why is it you get so exercised about that? I don't understand it. And so I have 1 minute and 33 seconds left. I'm not going to give you any of that time, but I'm going to tell you over and over again that your passion is disproportionate on this issue, and I don't get it. When we're simply saying, just tell us what you're doing. We're not trying to force you to take any particular group. We're not trying to say what percentage of business any group should have. We're not saying for how long they should have it. We're just saying, what are you doing? Is that right, Mr. Meeks? I yield my time to you.
Thank you. And just for clarification, we've checked, you know, it was in the 2003 approach, and it was not taken out in 2009. In fact, what took place, because it was in the bill, it was a one-time requirement that met, and so there was nothing that was ever taken out of the bill. It just followed through. So there was not a problem with it. No one had a problem with it. They understood, and I think that most people understood, that it was a good thing to do. Just reporting back, giving Congress information. I often hear, especially from my colleagues on the other side, that they want information, and that this happened to be information about what are we doing with minorities and women-owned and veteran businesses. Are we giving them a fair shake? Are we giving them the opportunity? How many are you doing? Just let us know with transparency what you're doing. Not mandating, not saying demanding, not saying must, not saying you have to, just saying, please, just give us the information. It's not a big thing for anybody. I don't know why the gentleman is having a problem with it.
Time of the gentleman has expired. The chair yields himself 5 minutes. Number one, I listened carefully to this debate and could not consider it more misplaced. This is not a broad-based DoD acquisition program. This is not about closing a wealth gap. This is not about getting additional business to women and minority-owned firms. It's about taking their business away in an emergency situation. Now, again, if this is the way you want to treat a particular constituency, so be it. I find it quite odd. And as the chairman of the committee, the subcommittee, has told us, this isn't about an emergency bill. So now we're going to have perhaps female and minority soldiers on the front lines who are saying, please, I need bullets, it's an emergency. And no, our committee is going to say, well, no, we've got to do a report first. I'm sorry you're engaged in this firefight, but we've got to issue a report. The only reason to have the report is if you believe in what the ranking member is trying to do, and we have already voted that down. And so I'm going to accept the facts as proffered by the gentleman from California, that this has not been in the most recent reauthorization of the bill. And regardless, I do not believe it to be well placed. Again, I'm curious about the fairness and inclusion of taking over one's business on an emergency basis. I'm not sure they necessarily feel it fair or inclusive. Certainly businesses that want to volunteer in an emergency situation can do so, but otherwise this may be somewhat tantamount to the draft as opposed to an all-volunteer armed services. You are getting drafted in an emergency situation, and the business that you lose may never, ever, ever be replaced. You know what? The courtesy was not extended to my colleague from California, so I'm a little loath to extend the courtesy at the moment to my friends, who I'm sure will be my friends in the morning, although the friendship has been tested in these most recent moments. No, but I am happy to yield to the gentleman from California.
Thank you, Mr. Chairman. I was just going to say, you want inclusion. There is nothing in this bill or anything that prevents inclusion. It does not say don't use this, don't do that. And you guys know as well as I do that if in something like this they discriminated against someone, they would be in big trouble. And you also know that under the small business initiatives as part of the Department of Defense, they're required to consider women-owned, service-disabled, and various other people already as a part of what they do. What this bill should do is simply say, without cluttering up with anything else, reporting or otherwise, if it is so important for the national defense or an emergency that you have to step into businesses and make them do something they would not do on their own, would not otherwise do on their own, make that the only reason you're doing it. And don't be putting any other things with that. And with that, Mr. Chairman, I yield back.
It's the Chairman's time. The Chairman yields back his time. No other members are seeking recognition who can be recognized. So the question is on agreeing to the amendment. All those in favor say aye. Those opposed say nay. Nay. In the opinion of the Chair, the nays appear to have it. The nays have it. The amendment is not agreed to.
I ask for a roll call vote.
A recorded vote has been requested. Those in favor of a recorded vote will raise their hand and be counted.
That's 1 for it. That's better than 1/5.
A sufficient number having raised their hands, a recorded vote is ordered pursuant to subsection C5 of Rule 3 of the committee rules. The vote on this question is postponed. There being no further amendments without objection, the previous question is ordered. The committee will now stand in recess until 10 a.m. tomorrow morning, at which time we will resume proceedings on the postponed votes.